Alphonse Madden was trying to complete a shipment, driving all night, and his brakes froze in sub-zero temperatures, which we have, and the heater in his cab broke as well. He called his company to report the issue and waited for help to arrive. While he was waiting for hours in the freezing sub-zero temperatures, he realized he was having trouble breathing and his body was going numb. He called his company to report that he needed to get somewhere warm, but they told him he needed to either wait for the repair person or drag his trailer even though the brakes were frozen. Worried he might freeze to death, he finally unhitched the trailer from his truck. Mr. Madden drove off to seek help, returning in just 15 minutes with assistance. He did what any of us faced with a life-threatening situation would do. A week later, Mr. Madden was fired from his job, even though he was transparent with his actions and completed his delivery. He completed his delivery, despite the issues caused by his frozen brakes and the broken heater. Two different entities within the Department of Labor ruled that what the trucking company did was illegal and that Mr. Madden was protected under federal law because his life was in danger. Thankfully, a majority of the 10th Circuit judges agreed. Judge Gorsuch, however, disagreed, arguing the law did not protect workers who drove away to avoid freezing to death. According to Judge Gorsuch's interpretation, Mr. Madden would have had to choose between his job and his life. And what is deeply concerning to me is that when he was asked about this at his nomination hearing, what he would have done, he said he really hadn't thought about it. Judges should think about what's happening to people in situations as they are ruling in a fair and impartial way. This does not look like the ruling of a mainstream nominee. His rulings don't only affect Michigan workers. I'm very concerned about Judge Gorsuch's rulings on legal protections for individuals with disabilities. We passed the Individuals with Disabilities Act to make sure that children with disabilities got the education they deserved and that the education would be free and available to all children. So when Luke, a young boy from Colorado with autism, was not able to receive the education he needed from his public school, his parents were able to enroll him in a private residential program specializing in children with autism that was more suitable for his needs so he could get what he needed for his development. His parents applied to the school district for reimbursement, as was appropriate, but the school district refused. His parents went to court, and an administrative judge and a district judge both ruled that the school did not provide Luke with the necessary education to meet the needs that IDEA requires. However, Judge Gorsuch ruled in favor of the school district, saying that all the school district had to do was provide an education that was more than just the bare minimum. Just the bare minimum. He set a very low bar for Luke and for students like Luke, like my nephew Barry. Just to show how disconnected Judge Gorsuch is from the lives of everyday Americans, look at the Supreme Court ruling that occurred at the same time as Judge Gorsuch's confirmation hearings. In a different case on the very same issue, the Supreme Court challenged and rejected the standard in interpretation that Judge Gorsuch believes should be provided for children and students with disabilities. They unanimously rejected the standard that he approved. This is not the view of a mainstream nominee. This is not the view of a mainstream nominee. I'm also deeply concerned about Judge Gorsuch's opinions and how they could affect women's access to health care. In the 10th Circuit's deeply concerned about Judge Gorsuch's opinions and how they could affect women's access to health, deny their employees access to essential health care services, including birth control. His concurring opinion suggested that he supported that notion that for-profit corporations, that they have the right to deny women insurance coverage or any form of contraception that an employer disagrees with. This is both alarming and unacceptable. And it once again shows how disconnected Judge Gorsuch is from what women in Michigan and around the country experience. Judge Gorsuch did not recognize the impact of denying coverage to women employees and their families and putting those decisions in the hand of their employers. Women in Michigan should not have to pay higher costs for health care than men, and they should not be denied essential health care services. And these dangerous interpretations will continue to take us down the path of permitting and protecting discrimination by corporations and institutions over the rights of workers and consumers. Again, not a mainstream nominee. And when it comes to supporting women, not just in healthcare, but in the workplace, Judge Gorsuch has had some extremely troubling rulings. In 2003, a woman named Betty Pinkerton experienced several instances of disgusting sexual harassment from a male supervisor at the Colorado Department of Transportation. Every time she made it clear that his comments were not acceptable in any way, they continued over the course of months. She went to her office's civil rights staff and submitted a written complaint, and he was removed as her supervisor. She was fired about a week later. She sued. But Judge Gorsuch upheld a ruling that claimed she waited too long. She waited too long to report harassment and believed that Pinkerton's firing was, quote, performance-based. How often do we hear that in these situations? Despite not being able to produce any real evidence that this was the case. He ruled that she couldn't go to trial and present her case in front of a jury. So when it comes to protecting women in the workplace, we know that Judge Gorsuch has come up short. This is not a mainstream position and not acceptable, in my judgment, for any Supreme Court nominee, not acceptable to what I want to see happen for people in Michigan. I want to end my speech on the importance of consensus, because that's what we should do here. That's how we get things done. For decades, we've confirmed our Supreme Court nominees with consultation and consensus. We have said, and I think it's the right thing, that we should have to have more than just a simple majority to confirm judges, the highest court in the land, a lifetime appointment, that it makes sense that we come together to do that. And in fact, for 7 of the 8 current United States Supreme Courts on the bench today, they received 60 votes or more somewhere in their process. Both President Bush's and President Obama's nominees as well, those now on the court. President Clinton, President Bush, President Obama talked to senators from both parties about their picks to get input as who would likely be supported and not supported. This did not happen with Judge Gorsuch. President Trump had a list chosen by very narrow special interests and did not ask opinions of key people on our side of the aisle as to what would make sense to get the consensus to get 60 votes. I do not believe Judge Gorsuch will be fair and impartial, giving a fair shot to the workers and families in Michigan, as well as around the country. And my test is very much about what is best for the people I represent in Michigan. Who will be fair and impartial and give them a fair shot? Because I do not believe he can do that, I cannot support his nomination. He is not the right choice for this vacancy. We can come together. I would urge my colleagues to go back to the drawing board, bring in a consensus mainstream nominee. In the past, we have basically had a practical rule of saying if the nominee cannot get 60 votes, we change the nominee. We don't change the rules. And it's extremely concerning that that would not be the approach at this time. I would urge that we come together, get a mainstream nominee at this time. I would urge that we come together, get a mainstream nominee, and be able to work together to get this done. Thank you, Mr.
Judge Gorsuch to be an Associate Justice of the United States Supreme Court. Every member of the United States Senate has an obligation to review this nomination thoroughly and to make a determination. I believe that the advise and consent duty of a United States Senator, certainly in my case, when I make decisions about any judge for confirmation, but especially one decision for the Supreme Court, has to be a decision that's grounded in a review of a number of considerations. I think they're generally the same no matter who the nominee is, but sometimes they can vary. And I think in this case, there are probably additional considerations that I weighed. Of course, you want to look at someone's, the nominees, I should say, their character and their integrity, certainly their temperament, judicial temperament. Someone can be very capable as a judge and very learned in the law, but may not have the temperament or the integrity. I don't think there's any question, there's nothing in the record that indicates that Judge Gorsuch doesn't have the experience or the character, the integrity to do this job and to do it with the kind of temperament we have a right to expect from any judge. I also believe at the same time, though, that you have to do a review of the cases that were decided by the nominee, in this case a judge on the 10th Circuit Court of Appeals, a very similar kind of job that the Supreme Court Justice does. You're reviewing cases on an appellate court, in Judge Gorsuch's case, the 10th Circuit, not the Supreme Court, but still appellate court decisions. Part of that inquiry, I believe, is a review or an assessment, really, of this individual's judicial philosophy. And that's where I'll spend most of my time tonight. And I'll also talk about the rule change that might be upon us. But while reading Judge Gorsuch's opinions, I developed very serious concerns about his rigid judicial philosophy. Judge Gorsuch's opinions indicate, in my judgment, an extremely conservative judicial approach. This leads him to come down disproportionately on the side of powerful interests and against workers in many cases, consumers in other cases, a cause for particular concern at a time when the Supreme Court itself, under Chief Justice Roberts, has become an even more, or I should say an ever more reliable ally to big corporations. A major study published by the Minnesota Law Review in 2013 found that the 4 conservative justices currently sitting on the court are among the sixth most business-friendly Supreme Court justices since 1946. A review by the Constitutional Accountability Center shows the consequences of the court's corporate tilt, finding that the Chamber of Commerce, the National Chamber of Commerce, has had a success rate of 69% in cases before the Roberts Court, a significant increase over previous courts. These are cases of serious importance to everyday Americans, cases involving rules for consumer contracts, challenges to regulations, ensuring fair play and labor standards, attempts by consumers to hold companies accountable for product safety, and much more. Another concern that I have about his nomination is that at some point in the campaign of last year, the Republican nominee was given a list of names from which he should choose were he to be elected president. I would hope that there'd be a list of names that any president would consider beyond what we're told in published reports was just 21 names developed by organizations on the far right. And that fact alone causes me great concern, that the president is only permitted, that fact alone causes me great concern, that the president is only permitted those organizations developed. The record of this judge indicates also that he would only exacerbate the problem that I pointed to with regard to the corporate tilt of the current Roberts Court. And in my judgment, by doing so, would further stack the deck against ordinary workers and families. It starts with his basic judicial philosophy. He employs the narrowest possible reading of federal law and shows extreme skepticism, even hostility toward executive agencies, or what some might call administrative agencies, agencies that carry out the law in areas like labor or consumer protections and the like. Many have expressed concerns about his opinion in the Hobby Lobby case, where Judge Gorsuch endorsed the idea that owners of for-profit corporations can assert corporate religious liberty rights, opening the door potentially to widespread discrimination against LGBT Americans and other Americans as well. But a variety of other cases are equally illustrative of Judge Gorsuch's troubling approach to the law. Just give you a few examples. One case involved the tragic death of a trench hand who was electrocuted while working as part of an excavation crew. The court reviewed a ruling by the Department of Labor punishing the mining company for failing to provide proper safety training to the worker. Judge Gorsuch mocked the Department of Labor's ruling as nothing more than a, quote, Delphic declaration, unquote, devoid of necessary proof, and he concluded that the agency was wrong to penalize the company following the worker's death. Fortunately, a majority of the court, the 10th Circuit, disagreed and affirmed the Department of Labor's ruling. Another case involved a truck driver who was stranded on the side of the road at night in sub-zero temperatures, with the brakes on his trailer frozen and the heater in his cab broken. He called dispatch for help multiple times, but after hours of waiting in the freezing cold, this truck driver was having trouble breathing, and his torso and his feet were numb. Worried about his safety, he unhitched his trailer, drove the truck away, and then later the company fired him for abandoning the trailer. 3 different authorities within the Department of Labor ruled against the company. Judge Gorsuch disagreed, parsing a federal statute to argue the driver was not protected in his decision to drive away despite the risk of freezing to death if he stayed put. Again, fortunately, the majority of the court disagreed on the 10th Circuit, describing the judge's labored interpretation of the statute as, quote, curious, unquote, in ruling in favor of the truck driver. I have a basic disagreement with Judge Gorsuch's rulings regarding the legal protections for individuals with disabilities, and especially students with disabilities. In one case, he ruled against parents who believed their autistic child was not receiving an adequate education at his public school. A hearing officer, an administrative law judge, and a United States District Court all found in favor of the family, ruling that they were entitled to reimbursement for tuition at a residential program tailored for children with autism. Judge Gorsuch reversed the rulings and instead articulated an extremely narrow interpretation of federal law, this particular federal law that protects students with disabilities, the IDEA law, the Individuals with Disabilities in Education Act. In 2004, Congress amended the IDEA in part based upon findings that its implications, quote, has been impeded by low expectations, unquote. Nevertheless, Judge Gorsuch ruled that because the student in this case made some progress in public school, even though he could not generalize his learning to settings outside of school, which is the goal of the Individuals with Disabilities Education Act, the family, the judge believed, was not entitled to tuition reimbursement. So that happened a number of years ago, that decision. Just so happens that the United States Supreme Court, the current court with only 8 members, voted 8-0 against the basic position that Judge Gorsuch had in that education case. Different case, but the same question about what is the duty owed by a school district to a child with a disability. That ruling happened to be announced during the week that Judge Gorsuch was in front of the Judiciary Committee. In fact, on one of the very days he was in front of the committee. So a unanimous court disagreed with his approach to those kinds of cases involving children with disabilities in a public school. So these cases and others are illustrative of a broader trend in the judge's jurisprudence, whether it's a case involving an employee seeking redress for workplace discrimination, hospital staff fighting for back pay after an unlawful reduction in work hours, or a victim of improper conduct by a medical device company looking for justice. Judge Gorsuch, I should say, his approach produces rulings disconnected from the lived experience of those they impact. So therefore, after a review of his cases, many of his cases, after a consideration of his judicial philosophy, and after a review as well of the current state of this court, especially the corporate tilt of this current Roberts Court, I have concluded that I could not support Judge Gorsuch's nomination to the Supreme Court. I wanted to add some comments before concluding tonight about what this vote may mean to the Senate and the rules of the Senate. It's my belief, others of course disagree, but it's my belief that if you seek to become an associate justice on the most powerful court in the world, you ought to be able to garner the support of at least 60 members of the United States Senate. If your nomination to the court is the subject of such consensus, you ought to be able to get 60 votes in the United States Senate. If your nomination is seen as both your nomination and your judicial philosophy is seen as such a mainstream nomination, you ought to be able to get 60 votes. Despite that, it's a point in time when we're having a debate about how we arrived at this question of a potential change in the rules. I believe that the reason we got here is because of substantial and unyielding obstruction by Republicans in the United States Senate over a number of years. Just consider this. From the founding of our nation through President Obama's first term, when Senate Republicans were in the minority, cloture, the motion to cut off debate and proceed to a final vote, has been filed on a total of just 147 nominations. 147 times in the total history of the United States Senate, the minority forced the majority to file cloture. Of all the presidents before President Obama combined, cloture only needed to be filed on 68 of these nominations. But in President Obama's first term, before Republicans took the majority in the Senate, Republicans refused to consent to votes and forced the Democratic leader to file cloture on 79 nominations. So over 50% of all the cloture motions ever filed on nominations in the history of the United States Senate. So half of those cloture petitions filed just in the last couple of years. That doesn't even include what I think was an outrageous obstruction that continued once Republicans took the majority, culminating, of course, in their refusal to consider Judge Merrick Garland's nomination. So Judge Garland of the District of Columbia Circuit, the chief judge, who had great support, I think, on both sides of the aisle, Judge Garland got no meetings, or maybe a few meetings, no vote, and not even a hearing before the Judiciary Committee. According to the Congressional Research Service, President Obama is the only one of the 5 most recent presidents whose first term was marked by nominations that languished for over half a year on average. Also in his first term, he was the only president of the previous 5 under whom the district court vacancies increased, unaccompanied by the creation of new judgeships to meet the demand. In fact, in President Obama's district court nominees during his first term, they waited an average of 60 days longer for confirmation than the nominees of President George W. Bush. I think the evidence is overwhelming. Senate Republicans' obstruction of judicial nominations reached historic levels under President Obama. So we are here at this point, and we have to make a decision. My vote will be to insist on 60 votes, therefore voting no on cloture, and also voting no to insist on 60 votes, therefore voting no on cloture, and also I would yield the floor.
Mr. President.
Senator from Minnesota.
Mr. President, I come to the floor to join my colleagues in speaking on the nomination of Judge Neil Gorsuch to serve as an Associate Justice on the Supreme Court. As you know, senators have a solemn obligation to advise and consent on a president's nominee for the Supreme Court, and I take that obligation very seriously. My goal during the hearing as a member of the committee was to understand the judge's view on the law and his judicial record and his philosophy. We needed to know what kind of justice he would be and what that would mean for Americans. Although many cases decided by the lower courts are less complicated, even though some of them are complicated, many of them are more straightforward than the ones that come before the Supreme Court. The cases that go before the Supreme Court are the hardest cases. They involve the most complicated legal gray areas. I had heard my colleagues many times talk about some of the unanimous decisions that the judge was involved in. I know that, but when I look at the kind of cases that come before the Supreme Court, those are different kinds of cases. As I looked over the judge's record, I tried to focus on situations where he faced hard cases like those he might decide as a Supreme Court justice. In my mind, the question was this: what would Judge Gorsuch do if he was appointed to the Supreme Court? What kind of philosophy would he have? In difficult cases, one judicial approach is to try to find consensus by ruling on the narrowest possible grounds. Judge Merrick Garland, who was nominated last year, was known and praised for that approach from senators on both sides of the aisle. Congress actually provides a helpful analogy. When Democrats and Republicans pass legislation, we try to find common ground. We often have different views, but we do find areas of consensus. Sometimes that ground is narrow, but we can find agreement and then come together. In reviewing the judge's record, I saw that he often took a different approach, one where he often tried to go a step farther than the consensus opinion, sometimes really farther than the consensus opinion, by suggesting a provocative change in the law or making a broader ideological leap, which I felt was not consistent with the precedent and was not consistent with the kind of philosophy of a judge that, regardless of their political beliefs, I didn't expect to agree with everything he said or how he answered the questions, but what I saw was a strikingly different philosophy. Many of the judge's opinions presented opportunities for narrow judicial consensus, but the judge decided more than the case in front of him. That is what concerns me if he were to be confirmed to the Supreme Court, where he would have to decide the toughest cases and hardest legal questions facing our country. So after thorough examination and consideration of his answers and the record, I've decided not to vote in favor of the judge's nomination. His judicial approach and his record on critical cases, including the rights of children with disabilities, campaign finance, and preserving health and safety protections, have led me to conclude that I cannot support his nomination to the Supreme Court. Now, let me make this clear. Again, I didn't expect to agree with every opinion he wrote or everything he said, and I certainly did appreciate the introductions of the presiding officer, as well as Senator Bennett, and the support he had from Colorado. That meant something to me. But then when I looked at the record, what I saw time and time again was a judge who clearly demonstrated the contrast between a narrow, consensus-based approach and a more far-reaching one. One area where the judge has gone farther to issue broad rulings that would have profound consequences on people's lives is in the case he decided on children with disabilities. During the hearing, because this case had been decided by the Supreme Court right before I got to ask questions, I asked a lot of questions about this case on the IDEA, or also known as the Individuals with Disabilities Education Act. The IDEA was passed to ensure that students with disabilities are supported in school, and in my state, 124,000 children rely on this critical protection. I occupy the Senate seat once held by Minnesota's own Hubert Humphrey, someone who, of course, was never at a loss for words. In fact, this very desk that I'm standing behind was a desk that Hubert Humphrey signed and used. He delivered a speech 40 years ago, and one line of that speech is just as appropriate today as it was back then. He said, quote, "The moral test of government is how that government treats those who are in the dawn of life. The children, those who are in the twilight of life, the elderly, and those who are in the shadows of life, the needy, the sick, and the disabled." The Supreme Court has honored that principle. On the day of the judge's hearing, the Supreme Court, in an 8-0 unanimous decision, ruled against the narrow interpretation of the IDEA embraced by Judge Gorsuch, an interpretation that limited the educational opportunities of children with disabilities. I couldn't agree with the 8-0 decision more. All children, particularly those with disabilities, deserve the tools they need to succeed in life, and every justice on the Supreme Court has a duty to protect these kids. So when the Supreme Court ruled that morning and overturned the standard that the judge had embraced in this 10th Circuit case, I asked him about his, quote, merely more than de minimis, end quote, standard that he wrote into that opinion back in 2006. In explaining his ruling, the judge said that he was bound by precedent to use the narrow standard that he used in that case. He cited a 1996 case from the 10th Circuit his circuit, that he said he was bound to follow. Now, he wasn't on the court back in 1996, but when he did the case in 2006, he used that 1996 case. So I look back at that case. Since during the hearing and at the Judiciary Committee business meeting earlier this week, my Republican colleagues repeated those words. They said that the judge was bound by precedent to use his narrow, merely more than de minimis standard that had in fact been rejected by the Supreme Court just this past month. So I looked to see if in fact that was true. Was he truly bound by precedent? Because that's pretty important to me. There have been a number of decisions where he has gone much further than he needed to, where he, in my mind, has abandoned precedent. And I thought, well, here we have a case that's fresh, right before us, and he has said that he was simply following the precedent, that he had no choice at all. Here's what I found. While the 1996 case made a number of findings and concluded that the school district satisfied the requirement in the IDEA statute of providing an appropriate education, the case never actually turned on the standard that the judge said he was bound by, that the judge said was precedent. Here's why. The 1996 case only mentioned the de minimis standard once. It was a passing reference. Even in that mention, the de minimis language is from a different circuit. It was from the Third Circuit. And in that 1996 case that he claimed that he was bound by and that my Republican colleagues keep mentioning that he was bound by, there is no discussion about whether the benefits provided to the high school students satisfied that standard. The case simply did not turn on the de minimis language. I know this seems in the weeds, but the court in 1996 never relied on the de minimis standard to reach the result that it did. And was that enough? No. In the one passing mention in the 1996 case, which was not binding, the language actually says, I quote, more than de minimis. But the judge went out of his way to add the word merely to that standard, which had never even been there before in the case that wasn't binding on him to begin with. So he changed it and said merely more than de minimis, that's all the kind of education a kid with disabilities in that school district in Colorado would have to get. This is like if you say more than empty, the gas tank's more than empty, which means it could be a lot more than empty. Adding merely puts it closer to empty. You just say, it's merely more than empty. The addition of a single word made it more difficult for children with disabilities to get help at school. That's why it's hard for me to understand why the judge said that the merely more than de minimis standard was binding on him when he wrote that opinion in 2006. It was not. He added the word merely, and then in fact he used a standard that didn't even decide that 1996 case that was from a different circuit. When interpreting the IDEA, the judge once again went a step further, instead of deciding the case on a narrow ground. That matters because decisions like this have a dramatic impact on the lives of children and families, which is exactly what Justice Roberts noted when he wrote the opinion 8-0, rejecting the standard that was the one that Judge Gorsuch had used. I have heard from families in my state, and so many of them tell me how IDEA has made a real difference for them. My mom taught second grade until she was 70 years old in the Minnesota public schools. And I know from her how much she worked with those kids with disabilities and how much she cared about them. Here's an example I just learned about from my state. A mom from Watertown, Minnesota, told me about her son who was born with Down syndrome. She is so thankful for IDEA because this protection ensures that he can have everyday life experiences. IDEA allows her son to be fully integrated with the rest of the students in his school. And as a result, he has made many friends and built a strong social network. When she asks her son whether he likes school, he always says in a resounding voice, yes. Those are the stakes of this legal debate. Second, I want to focus on campaign finance. In my view, one of the most troubling court decisions in recent years is Citizens United. Since Citizens United, dark money has been spent in extraordinary sums, adding up to an estimated $800 million in just the past 6 years. This continues to have an outsized influence on our politics, distorting our representative democracy and hurting, in my mind, campaigns on both sides of the aisle. Now, how does this apply to the judge? It applies to the judge because of an opinion that he wrote that is very relevant to this area of the law. In that case, which is called Riddle v. Hickenlooper, a narrow case about how campaign finance laws apply to certain kinds of contributions in Colorado, about if they're major party or not major party, the judge again decided that a narrow consensus decision was not enough. He was part of that decision, but then he went out of his way to write a separate concurring opinion to suggest that the court should in fact apply strict scrutiny to laws restricting campaign contributions. If the Supreme Court adopted the approach in the judge's opinion, it would compromise the few remaining campaign finance protections that are still on the books, and it would make it even more difficult for Congress to pass future reforms. The notion that Congress has little or no role in setting reasonable campaign finance is in direct contradiction with where the American people are. In recent polls, over 3/4 of Americans have said that we need sweeping new laws to reduce the influence of money in politics. While polls may not be a judge's problem and should not be a judge's problem, democracy is. When unlimited, undisclosed money floods our campaigns, it drowns out the people's voices. It undermines our elections and shakes the public's trust in the process. My colleagues and I repeatedly asked the judge about his views on campaign finance laws and public disclosure requirements. He declined to tell us what the proper legal standard would be for evaluating campaign finance laws. He also would not give us a real sense of his views on public disclosure of campaign contributions, although a majority of current justices support this. During our exchange on campaign finance, I was reminded of Justice Scalia's support for greater public disclosure and his comments on that topic. Justice Scalia said, "Requiring people to stand up in public for their political acts fosters civic courage, without which democracy is doomed." For my part, I do not look forward to a society which, thanks to the Supreme Court, campaigns anonymously and even exercises a direct democracy of initiative and referendum hidden from public scrutiny and protected from the accountability of criticism. Justice Scalia added, "This does not resemble the home of the brave." The most striking example of the judge choosing not to decide a case narrowly based on the facts was the one last year in which he wrote the opinion and then wrote a concurrence to his own opinion. Now, as I noted at the judiciary hearing, it is better to write a concurrence to your own opinion than writing a dissent to your own opinion, but still, he felt compelled to write a concurrence to what was an opinion that he wrote. And mostly, judges are happy when they get their peers to agree to a decision. But in this case, he went a step further. In Gutierrez, the name of the case, the judge went beyond the fact, happy when they get their peers to agree to a decision. But in this case, he went a step further. This is a 33-year-old Supreme Court case that ensures the most complex regulatory decisions are made by the experts who are best equipped to handle them, not by judges or lawyers without any relevant technical knowledge. Justice Scalia, again, embraced the Chevron doctrine, and it has been used in more than 13,500 decisions. Chevron ensures that federal health, safety, and education rules stay on the books. These rules protect everyone from the hard-earned pension of an hourly Minnesota grocery store worker to the clean water in their Great Lakes, to the difference between life and death for Minnesota iron ore workers. The judge's approach would have titanic, real-world implications on the daily lives of Americans. When the judge wrote an opinion that suggested it might be time to, quote, face the behemoth, he suggested a change in the law that would jeopardize countless rules, compromise important protections, and create widespread uncertainty in our laws. I asked the judge about the uncertainty that would result from overturning Chevron. I asked what he would replace it with. I didn't get a direct response. The judge even said that he, quote, didn't know what all the consequences would be, end quote, and that he, quote, wasn't thinking about being a Supreme Court justice, end quote, when he was writing the decision. So what does all of this mean? It means that the judge has repeatedly gone beyond the facts of the case, issuing separate concurrences with far-reaching effects, or, as in the disability decision, writing opinions with profound consequences. When I read these opinions, I'm reminded of Justice Byron White, who I know Judge Gorsuch clerked for and greatly admired. Justice White has been described by many as a justice who was focused on deciding only the case in front of him. Here is a quote: "Time and again, Justice White avoided broad theoretical bases for a decision when a narrow, fact-specific rationale would suffice." There is a reason we have judges to apply the law to the facts of a case. It is because answers aren't always as clear as we would like them to be. And sometimes there is more than one reasonable interpretation of the law. The cases that get to the Supreme Court are not the ones where everyone agreed at the lower court level. They're the really hard cases. It is that discretion in making those decisions that makes it so critical that justices interpret the law evenly, without fear or favor, and with the humility to recognize the gravity of the office, to respect the role of the judiciary, and to understand the impact of their decisions on people's lives. As I look back at the judge's record and his answers in the hearing, I'm again reminded that it wasn't a law professor or a federal jurist who was helped by a court's reliance on Chevron in interpreting a Labor Department rule. It was an hourly Minnesota grocery store worker who got to keep his hard-earned pension after the Eighth Circuit Court relied on Chevron. And when the court stripped away the rules, the Supreme Court stripped away the rules in that Citizens United case that opened the door to unlimited super PAC spending, it was not the campaign financiers or the ad men who get paid to write these ads who were hurt. It was the grandma in Lanesboro, Minnesota, who actually thought it mattered when she sent her senator a $10 campaign contribution. And when Chief Justice Roberts wrote the unanimous opinion just this past month rejecting being at school, he said, the justice said, "When all is said and done, a student offered an educational program providing merely more than de minimis progress education at all." That is what the Supreme Court said about can hardly be said to have been offered an education at all, affected students with disabilities. So in the end, Mr. President, I believe we need justices who understand that the law is more than a set of dusty books in the basement stacks of a law library. It is the bedrock of our society. And above all, we need justices who understand and will uphold the motto on the Supreme Court building, to ensure all Americans achieve equal justice under law. That's why I won't be supporting the judge's nomination to be an Associate Justice of the Supreme Court. Thank you, Mr. President. I yield the floor.
Mr. President.
Senator from Hawaii.
Thank you, Mr. President. What is the purpose of the Senate? The authors of the Constitution laid the foundation of the Senate without really knowing what it would look like once it was standing. They knew it would rival and restrain the House of Representatives. After all, the Senate had a higher age requirement. Members were to serve 6-year terms and to represent not just a district, but an entire state. But it was clear from the beginning of the formation of the Senate that it would take time before the purpose of this body was truly realized. For several decades in our nation's history, it was the House of Representatives, not the Senate, that hosted the great debates and introduced major legislation. It wasn't until the nation began to splinter in the shadow of slavery that the Senate came into its own. And while the rules of the Senate gave us its basic structure, it was the members of the Senate, the people who made up this body, who had to stand up and to lead. We remember them today as the lions of the Senate: Daniel Webster, John Calhoun, Henry Clay. And this body owes its status to them and their leadership because they began to define the Senate in a way that no one had before. Over time, this place became one that valued bipartisanship, deliberation, and compromise. It has become a chamber that balances the right to debate with the demands for action. In some of the toughest moments in our history, the members of the Senate have used this body to lead, particularly when the president has faltered. Take President Nixon. The Watergate scandal had weakened the presidency in ways that do-nothing presidents never had. But the Senate, led by a member of the president's own party, didn't stand by and watch the void unmoved. They filled the vacuum for the good of the country. It is this kind of history that has shaped the Senate into what it is today, a body that examines, considers, protects. Senator Byrd, the longest-serving senator in the United States history, said, "The Senate is a source of wisdom and judgment, both on the actions of the lower house and on the executive. That is what the Senate is for. That is our purpose." And we achieve that purpose through customs and traditions, through members serving 6 years and representing whole states, through rules that force bipartisanship, deliberation, and compromise. But now, the majority leader has placed one of those rules on the chopping block because they can't get to 60. They can't find the 60 votes needed to end debate on the president's nominee for the Supreme Court. But we shouldn't be surprised to find ourselves here because, after all, back in February, President Trump told the majority leader to change the rules if he had to. And now, as this administration closes in on its first 100 days without passing a single piece of major legislation, the Senate Majority Leader is ready to fulfill the president's request and change the rule instead of changing the nominee. And the question I have for this body is, should we change the rules in order to give the president a win before spring break? Should we be weakening the Senate at a time when the executive branch is so weak? Isn't it our obligation to assert ourselves into this void instead of receding from responsibility? I can think of no instance in the history of any great legislative body in which the legislature decides to diminish its own power. And this is beyond strange in the world's greatest deliberative body, in the world's most powerful legislative chamber. For what good reason would we give up our own prerogatives? This administration has been ineffective. Now the Senate Majority Leader is suggesting that the Senate respond to this executive weakness by weakening ourselves. This is wrong. The purpose of the Senate is achieved through bipartisanship, deliberation, and compromise. The 60-vote threshold for Supreme Court nominees preserves these ideals. Changing this rule will make it harder to get there. Look at the House of Representatives. Look at the way the House Intelligence Committee dissolved so quickly into partisanship, unable to do its job. Look at the country. Look at the campaign last year. We are a country divided. Polarization is at an all-time high, and so now is not the time to crush a cornerstone of the Senate's foundation. But I don't think this is inevitable. This is not unstoppable. This is up to all of us. It is up to the members of the Senate to decide if we are going to damage the world's greatest deliberative body at a time when the country needs us the most. This is up to all of us. It is up to the members of the Senate to decide if we are going to damage traditions. They help. But at the end of the day, it's the members of the Senate who, like Calhoun, Webster, Clay, Kennedy, Inouye, Hatch, McCain, who made the Senate relevant and necessary. So we're going to find out who we are as senators. And I would ask that at a minimum, the Senate take its time on this decision. Don't rush. That's not who we are. That's not how we get to the best decisions. This is about the future of the Senate. and the future of the court. The nuclear option will mean nominees for the Supreme Court won't have to even meet with the minority party to be confirmed. It will mean that the Senate's habit of being slow, sometimes maddeningly slow, will go away. And that tradition that allows the center to hold not just in this chamber, but across the country, will be undermined. And so to my Republican colleagues, please take a few weeks before you decide to change the Senate forever. Take your time here. This is probably one of the most serious decisions that you're ever going to make as a senator, because it's about the Senate itself. This is worth talking about. This is worth deliberating over. It's worth thinking over. Go home and talk to your constituents. If you want to do this, you have the votes. You can do this 3 Mondays from now, anytime you want, but for goodness sake, there is no harm in thinking about it. All we need are 3 members of the Republican Party to go to the majority leader, either publicly or privately, and say, give us some time to find another way to do this. Because otherwise, you will make the Supreme Court and this place, this country, more extreme and more divided. You will answer this difficult moment in history by weakening one of the last bastions of bipartisanship. And I believe you will regret it. I yield the floor.
I don't understand it.
Suggests the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
Mr. President,
Senator from Alaska,
Mr. President, I ask that the quorum call be vitiated.
without objection.
Mr. President, for months I've been coming down to the floor every week to recognize someone in my state who has made a difference to our communities in Alaska, someone who has devoted time and energy to making my state a better place to live. I call these individuals our Alaskan of the Week. Now, as I've said repeatedly, all of my colleagues and those watching on TV, that I'm a little biased here, but I believe my state is the most beautiful in the country. I'd argue in the world. I urge everybody in this room, everybody watching on TV, come to see for yourself. Take a trip to Alaska. It'll be the trip of a lifetime, guaranteed. But, Mr. President, it's the people that truly make my state unique. People who are helping each other, strong-willed, warm-hearted, tenacious people who have worked tirelessly for years for all of those who live in Alaska. So, Mr. President, this week I'd like to honor Dan Fauske. one of the strongest-willed, warmest-hearted people I've ever known. All he's done for us has made Alaska a better place for literally thousands and thousands of people throughout our state. Dan came to Alaska in 1974 after serving in the Army, as so many Alaskans do. And like so many Alaskans, he arrived with a glint of steel in his eye and a mission to help build our state. Alaska is full of natural wonders, but our man-made wonders are also marvels. And Dan wanted to be part of building more of those marvels for our state, for our country. He first arrived in the North Slope Borough, the top of the world, to help the community build up their infrastructure and strengthen the Alaska Native villages in the area. It was a time of enormous change for all of Alaska, and particularly the North Slope. Oil from the North Slope's Prudhoe Bay, the largest oil field in North America, had recently begun to flow down the Trans-Alaska Pipeline system, 800 miles. The largest land claims act in U.S. history, the Alaska Native Claims Settlement Act, had recently passed, and the governments of villages in rural Alaska were being formed and reformed to take advantage of these opportunities. After Dan went back to school to receive a master's degree in business administration from Gonzaga, he made his way back to Alaska again to serve as the chief financial officer and chief administrative officer for Alaska's North Slope Borough, where he launched an ambitious and ultimately successful capital plan to provide basic necessities that so many Americans take for granted, like running water and sewer. These kind of services to the villages throughout the North Slope Borough, again, on the top of the world. According to Bill Tracy, Sr. from Point Lay, one of the villages there, who was a co-worker at the time, Dan's excellent work ethic and skills earned him the respect of the North Slope leaders. His accomplishments were remarkable, said Mr. Tracy. With this beautiful and spirited wife Elaine by his side, always by his side, Dan then moved his family to Anchorage to head up the Alaska Housing Finance Corporation. And for 18 years, he managed AHFC's nearly $5 billion in assets. It's not an overstatement, Mr. President, to say that he revolutionized that agency, doing remarkable things, including, and most importantly, helping thousands of Alaskans, thousands of our constituents, of our fellow Alaskans, pursue their dream of buying an affordable home. Nothing more important than that. The Alaska Legislature just passed a bill to name the Alaska Housing Finance Corporation the Daniel R. Fauske Building, and the dedication ceremony will take place in Anchorage on Saturday. Now, as his bio indicates, there's no doubt for decades Dan Fauske served Alaska with his hands, with his heart, with his head. But a bio on paper can only tell you so much about a person. To really appreciate him, you have to have been with him and watch the energy and can-do spirit radiate from Dan Fauske. You had to watch him talk to people with respect and humor and understanding and a very keen intelligence. He had a big laugh, a very big laugh, and he told great stories. He also had that rare ability to genuinely connect with everybody he met. Didn't matter who. He was able to speak the language of a businessman, a builder, a veteran, a public servant. He spoke the language of a father, a husband, a friend, a true Alaskan. And in doing so, he gained the respect of everybody. And I mean everybody in my state. Politicians, state workers, military members, people from all across Alaska, people from all across the political spectrum. If you wanted something done and you wanted it done right in Alaska, you asked Dan Fauske to help you do it. People trusted him. I trusted him. Most importantly, Mr. President, Dan was a great father to 3 great boys, DJ, Scott, and Brad, and 2 daughters, Marcy and Kathy. And he was a great husband to his incredible, vivacious, and very strong wife, Elaine. Mr. President, Dan Fauske passed away this afternoon with his family and friends by his side. Our prayers and the prayers of so many Alaskans go out to all of them during this very difficult time. And for anyone watching, I humbly ask that you say a prayer too. For all he's done for all of us, all his memory will continue to do for all of us. Dan Fauske is our Alaskan of the week. He was also my very good friend. And my wife, Julie, and I will miss him greatly. I yield the floor.
Senator from Colorado.
I ask consent to proceed to legislative session.
Without objection.
I understand that there are 2 bills at the desk, and I ask for their first reading en bloc.
The clerk will read the titles of the bill en bloc.
S. 861, a bill to provide for the compensation of federal employees affected by lapses in appropriations. H.R. 1301, an act making appropriations for the Department of Defense for the fiscal year ending September 30th, 2017, and for other purposes.
I now ask for a second reading, and I object to my own request, all en bloc.
Objection having been heard, the bill will receive its second reading on the next legislative day.
I ask unanimous consent the Senate proceed to the immediate consideration of SRES 118 submitted earlier today.
The clerk will report.
Senate Resolution 118, condemning hate crime and any other form of racism and so forth.
Is there objection proceeding to the measure? Without objection.
I further ask that the resolution be agreed to, the preamble be agreed to, and the motions to reconsider be considered made and laid upon the table with no intervening action or debate.
Without objection.
I ask unanimous consent that when the Senate completes its business today, it recess until 10 a.m. Thursday, April 6th. Further, that following the prayer and pledge, the time for the two leaders be reserved for their use later in the day. Further, that following leader remarks, the time until the cloture vote on the Gorsuch nomination be equally divided between Senators Grassley and Feinstein or their designees. Finally, that the mandatory quorum call with respect to the cloture vote be waived.
Without objection.
I ask unanimous consent that the Senate resume executive session to consider the nomination of Neil Gorsuch.
Is there objection? Without objection.
If there is no further business to come before the Senate, I ask that it stand adjourned under the previous order following the remarks of Senators Cantwell for 10 minutes, Franken for 30 minutes, Murphy for 30 minutes, Hirono for 30 minutes.
Is there objection? Without objection, so ordered. Clerk will call the roll.
Mr. Alexander.
Senator from Washington,
Mr. President, I ask the quorum call be dispensed with.
without objection.
Mr. President, I rise to oppose the nomination of Neil Gorsuch and to oppose cloture on this nomination. I take this responsibility seriously to give advice and consent, and I take the President's remarks that he planned on nominating someone to the court who did not believe that Roe v. Wade was settled law. The U.S. Supreme Court nominee requires 60 votes, and if a nominee can't clear 60 votes, then I agree with my colleague, the senator from New York, that it's the nominee that should be changed and not the Senate rules. If confirmed, Judge Gorsuch will have a lifetime appointment to the U.S. Supreme Court and have an impact on many, many Americans' lives. When people say lifetime, I think that almost doesn't quite accurately reflect this issue and nomination. Lifetime in this case may be 30 to 35 years. It's hard for me in an information age to think of all the issues that are going to occur in the next 30 to 30 years. It's hard for me in an information age to think of all the issues that are going to occur in the next my constituents, but to people all over the country. Judge Gorsuch is commonly referred to as a proponent of originalism and textualism. He believes the U.S. Constitution should be interpreted by the original intentions of those who drafted it as closely as possible. As someone who knows well the record of a former Supreme Court justice who wrote the Connecticut versus Griswold decision, I doubt that you would say that he was an originalist. Some legal scholars have even called Judge Gorsuch a selective originalist, favoring some textual provisions while overlooking others. And while no one expects Judge Gorsuch to reveal how he would vote on a particular case during his Senate confirmation hearing, he did not give senators enough background about his judicial philosophy, nor in private meetings did he give me enough of assurance of his philosophy as it relates to these issues on privacy for my constituents in Washington. Whether you're talking about access to health care or you're protecting individuals' privacy rights from unwanted corporation or government intervention, these issues are critically important. Judge Gorsuch told the Senate Judiciary Committee that he does recognize privacy rights. However, his earlier writings actually said that unenumerated constitutional rights were a contradiction to this statement. So this contradiction raised questions with me, and I worked to try to further clarify his judicial philosophy on this. I told him that my state actually had codified the rights of women to access to health care. He said, "Oh, you mean your state legislature did that?" And I said, "No, Judge Gorsuch, I mean the people of Washington voted on these issues and voted to protect a woman's right and access to health care." So when it comes to the right to privacy, I work hard to understand where our judiciary is coming from. And if it's for the next 30 to 35 years, I guarantee you these privacy rights are going to be of critical importance. In the longstanding precedent known as the Chevron doctrine, that judges should defer to reasonable agency interpretations of ambiguous statutory language, it allows agencies to get expert input from agencies on their decisions and regulations. By overturning this doctrine, it could make it easier for courts to challenge important agencies' decisions protecting health and the environment. This is also important to my state, having fought the Enron case and making sure that the federal energy regulators did their job in protecting the ratepayers of Washington from, at the time, what was, in my opinion, a violation of the Federal Power Act on just and reasonable rates. We had to go to a great extent to make sure that the agency's decisions were inputted and considered to make sure we didn't become the deep pockets. So making sure that this doctrine was continued and not overturned, Judge Gorsuch concluded that Chevron versus the Natural Resource Division should be overturned. So I find this record troubling. Also yesterday was Equal Pay Day, and a lot of discussion about how women still face unequal wages. What would Judge Gorsuch do about equal pay? As a professor, he told his students that women manipulate family leave policies for their own benefits. As a judge, he frequently ruled against women and their rights. In the Hobby Lobby versus Sibelius, a privately held company which was a store chain, challenged the Affordable Care Act and the birth control benefits. The Affordable Care Act required health insurance plans to provide women with birth control coverage with no cost sharing. Judge Gorsuch joined the 10th Circuit majority, holding that an employer's religious beliefs could override employees' right to birth control coverage. Judge Gorsuch also supported an effort to defund Planned Parenthood as an important provider of women's health. In the Planned Parenthood Association of Utah versus Herbert, the 10th Circuit upheld an injunction to prevent the then the governor of Utah from defunding Planned Parenthood. However, Judge Gorsuch, the governor of Utah from defunding Planned Parenthood. Judge Gorsuch has had a narrow interpretation of the law as it has meant to protect workers against discrimination. In another case, a worker alleged she had been unlawfully discriminated based on gender because she took 2 weeks of leave under the Family and Medical Leave Act. She claimed that her employer had a higher performance standard than her male co-workers, and the 10th Circuit ruled in her favor and found that the employer had discriminated against her. However, Judge Gorsuch dissented, arguing the evidence of sexual discrimination was entirely absent. These issues and rulings make me concerned about his judicial philosophy as it relates to what now I believe has been accepted standard. Judge Gorsuch also has ruled against LGBTQ individuals seeking fair and non-discriminatory treatment. Lambda Legal and other groups have called his record openly hostile towards the LGBT people. Gorsuch held that a trans woman's constitutional rights were not violated, citing the absence of any medical evidence. And as many of my colleagues have talked about, that Judge Gorsuch has had a pattern of ruling against the little guy. My colleague from Hawaii noted he seems to favor corporate interests over the workers' rights and private interests over public interests. Judge Gorsuch took the outcome of many of these cases, which have been cited frequently since his nomination, but probably none more than the case in the Individuals with Disability Education Act. But I think it's so important that it needs continued to be talked about. This case, which was recently rejected by the US Supreme Court, said Gorsuch that it limited the opportunities for children with disabilities. Gorsuch had concluded that to comply with the law, the school's responsibility to the student was to make progress that was merely no more than de minimis. That is to say that those children in our education system who have special needs, autistic, need through our education system to make progress, that it could be, quote, no more than de minimis. This ruling impacts hundreds of thousands of students all across America, including in the state of Washington. He wrote the majority opinion and used the word merely. I asked Judge Gorsuch about this because of the cases I mentioned earlier on federal energy regulators and the fact that we needed strong anti-manipulation laws and we needed people to interpret the standards to make sure that they were upholding the interest of the public. So we had quite a long discussion about this. The notion that Judge Gorsuch was bound by a previous decision, but the previous decision was not based on that standard. So I don't believe that Judge Gorsuch's decision, which was then overruled by the Supreme Court, kept him bound by that decision. I know some of my colleagues have also noted this, but when Justice Roberts wrote the unanimous opinion rejecting these merely more than de minimis standards that Judge Gorsuch had used to limit the access, Justice Roberts said, quote, "When all is said and done, a student offered an educational program providing merely more than de minimis progress from year to year can hardly said to have been an effective education at all," end quote. On this point, I agree with the Chief Justice. I have great concerns that not having a deeper understanding about his judicial philosophy, my great concerns for the right to privacy issues that will remain constant in our society, I guarantee you, for the next 30 years, and these issues of standards that are so important, I cannot support this nomination nor support cloture to move ahead. I thank the President, and I yield the floor.
Clerk will call the roll.
Mr. Alexander.
President.
Senator from Minnesota.
Mr. President, I ask that the quorum call be vitiated.
Without objection.
Thank you, Mr. President. Mr. President, before I begin my remarks on Judge Gorsuch, I just want to take a minute to talk about the chemical attack in Syria. Words cannot describe these vicious attacks against civilians. We have all seen the horrific footage. Many of these victims were children. These are innocent men, women, and children, Mr. President, who through no fault of their own are caught in the middle of a bloody civil war, stuck between a brutal regime, armed groups, and foreign powers. My heart goes out to the victims and their families. Mr. President, the world has come together and unequivocally condemns these acts and their perpetrators. We must work together to find a path toward peace and stability in Syria, and the United States must take a leadership role in that effort. Now I will turn to my remarks. Mr. President, I rise in opposition to the nomination of Judge Neil Gorsuch to serve as an Associate Justice on the United States Supreme Court. After meeting with the nominee, carefully reviewing his record and questioning him during his confirmation hearing, I've come to the conclusion that elevating Judge Neil Gorsuch to the Supreme Court's bench would merely guarantee more of the same from the Roberts Court, a sharply divided, already activist court that routinely sides with powerful corporate interests over the rights of average Americans. Mr. President, I think it's important to start by acknowledging just exactly how it is that Judge Gorsuch came to be before the Senate, namely this body's failure to fulfill one of its core functions. Immediately following the death of Justice Scalia, in a move as cynical as it was irresponsible, Senate Republicans announced that they would not move forward with filling the vacancy until after the presidential election, before President Obama had even named a nominee. The majority leader said, quote, "The American people should have a voice in the selection of their next Supreme Court justice." The only problem with the majority leader's reasoning was that the American people did have a voice in the decision. They had voted to make President Obama President of the United States. Nonetheless, Republican members of the Judiciary Committee gathered behind closed doors and vowed to deny the eventual nominee a hearing. Many Republicans refused to even meet with the nominee. They said it didn't matter who the president nominated. They said this was about principle. But Senate Republicans had a difficult time justifying their obstruction. That is, until they decided to mischaracterize a speech delivered by former Judiciary Committee Chairman Joe Biden in June of 1992. In that speech, then Senator Biden discussed the possibility of a Supreme Court justice. This is in June of 1992. The possibility of a justice resigning in an election year in order to ensure that a president of the same party could name a replacement. Under those circumstances, he said the president should refrain from nominating a replacement and the Senate should not hold confirmation hearings until after the election. My Republican colleagues seized upon this portion, this small portion of Senator Biden's speech, and dubbed it the Biden rule. Chairman Grassley said the Senate ought to abide by the Biden rule, which he said holds that there are, quote, no presidential Supreme Court nominations in an election year. The majority leader said, quote, as Chairman Grassley and I declared, the Senate will continue to observe the Biden rule so that the American people have a voice in this momentous decision. So in order to justify a truly unprecedented act of obstruction, my Republican colleagues pointed to the so-called Biden rule and said they were standing on principle. That was the principle. But my Republican colleagues chose to overlook a few important details. First of all, the scenario Senator Biden described in his 90-minute speech was not the situation that our country faced last year. No one strategically resigned last year. A justice died. No one dies to game the system. And second, my Republican, and most importantly, my Republican colleagues ignored the actual point that Senator Biden made in that speech. If they had bothered to read the entire speech, or I suspect they actually had, they would have found that further down, Senator Biden said, quote, and this is important. This is what Senator Biden said in the speech that was used as the justification not to take up Merrick Garland. Senator Biden said in that speech, quote, if the president, then George H.W. Bush, If the President consults and cooperates with the Senate or moderates his selections absent consultation, then his nominee may enjoy my support, as did Justices Kennedy and Souter. Allow me, Mr. President, to dwell on that for a moment. Senator Biden said that if a Supreme Court vacancy arose during an election year and the President consulted with the Senate or, absent consultation, put forward a moderate consensus candidate, that candidate should enjoy the support of the Judiciary Committee's chairman. That's the Biden rule. That's the Biden rule. If Senate Republicans had actually followed the Biden rule, we wouldn't be here today. Merrick Garland would be sitting on the Supreme Court bench. Of course, over the past few days, I've heard my Republican colleagues denounce Democratic opposition to Judge Gorsuch by claiming that there never has been a partisan The past few days, I've heard my Republican colleagues denounce Democratic opposition to Judge Gorsuch. And if the shameful and unprecedented obstruction that Republicans use to effectively block President Obama from appointing a Supreme Court justice wasn't a partisan filibuster, then I don't know what is. Now, perhaps my Republican colleagues were concerned that President Obama would seek to replace Justice Scalia, a reliably conservative member of the court, with a jurist whose view would place him or her on the opposite end of the ideological spectrum. That seems to be the concern that my good friend Senator Hatch expressed when he said, quote, "The president told me several times he's going to name a moderate, but I don't believe him." President Obama could easily name Merrick Garland, who is a fine man. He probably won't do that because his appointment is about the election, so I'm pretty sure he'll name someone the Democratic base wants. But as it turns out, in recognition of the forthcoming election and the Republican-controlled Senate, President Obama did exactly what then Senator Biden, or what former Senator Biden had said a president should do. He named a moderate consensus candidate. He named Merrick Garland. Judge Garland was supremely well qualified for the job. Here's a guy who was his high school valedictorian, who attended Harvard College on a scholarship, won clerkships with legal legends like Second Circuit Judge Henry Friendly and Supreme Court Justice William Brennan, and left a partnership at a prestigious law firm to become a federal prosecutor during the George H.W. Bush administration. He later joined the Justice Department, where he prosecuted the men responsible for bombing the Oklahoma City federal building in 1995. And he kept in touch, Merrick Garland kept in touch with the survivors and the victims' families. And that's the reason why one of the very first Republicans, there are three announced at one time, one of those three, the first three, who agreed to meet with Judge Garland was Senator Jim Inhofe of Oklahoma, a staunch conservative, because the people of Oklahoma had such regard for Merrick Garland. After Judge Garland was confirmed to the D.C. Circuit in 1997, he earned a reputation for working with his colleagues from across the ideological spectrum. to identify areas of agreement, and to craft strong consensus opinions, often deciding a case on the narrowest grounds possible. Judge Garland was the right choice, often deciding a case on the narrowest grounds possible. Animal, a political animal. He was a judge's judge, and everyone knew it. That's why my Republican colleagues had to hide behind new and misleading so-called rules in order to deny him a hearing and a vote. Judge Gorsuch is no Merrick Garland. Judge Gorsuch is a creature of politics. Now, that's not what Judge Gorsuch told me when I met him earlier this year. I asked Judge Gorsuch if he is bothered by the way the Senate treated Merrick Garland, and he responded by telling me that he said, "I try to stay away from politics." But documents that the Judiciary Committee received from the Department of Justice, including emails between Judge Gorsuch and Bush administration officials, show that Judge Gorsuch was very heavily involved in politics. A resume that he sent to President Bush's political director in November 2004, back when Judge Gorsuch was looking for a job, detailed his work on Republican political campaigns dating back to 1976 and highlighted an award he had received from Senate Republicans for his work to advance President Bush's judicial nominees. Ken Mehlman, the former chairman of the Republican National Committee, later recommended Judge Gorsuch for a post at the Justice Department, described him as, quote, a true loyalist. Now understand, being politically active or being a Republican are not disqualifying characteristics in a Supreme Court nominee, at least not in my book. But Judge Gorsuch's resume is relevant here because, contrary to what he told me, his resume establishes that he's not just intimately familiar with politics, he knows the politics of the judicial nominations process, and he knows it well. And let me explain why I think that is important. During the campaign, then-candidate Trump spoke openly about his litmus test and what kind of judge he would appoint to fill Justice Scalia's seat on the court. He said that he would, quote, appoint judges very much in the mold of Justice Scalia. During the final debate, he said, quote, the justices that I'm going to appoint will be pro-life. They will have a conservative bent. Now, part of the reason that then-candidate Trump could say that with such conviction is because he had already outsourced the job of coming up with a list of potential nominees to the Federalist Society and the Heritage Foundation, both right-wing organizations. The groups produced a list of 21 conservative judges for then-candidate Trump, a list that included Judge Gorsuch. And presumably the Federalist Society and the Heritage Foundation knew something about the judicial philosophy of the men and women that it had decided to include on that list. Given Judge Gorsuch's previous work to push judicial nominees through the Senate, I'm sure he knew a thing or two about the Heritage Foundation and the Federalist Society as well. In fact, Judge Gorsuch first learned that he was under consideration for the vacancy from the Federalist Society's vice president, who was working with the transition team. Judge Gorsuch went on to interview with a host of other members of the transition team, including now White House Chief of Staff Reince Priebus and senior strategist Stephen Bannon. Weeks later, after President Trump had officially nominated Judge Gorsuch, both Mr. Priebus and Mr. Bannon appeared before right-wing activists at CPAC and talked about his nomination. Mr. Priebus told the crowd that a Justice Gorsuch would bring about, quote, a change of potentially 40 years of law. A change of potentially 40 years of law. He said, quote, Judge Neil Gorsuch represents the type of judge that has the vision of Donald Trump, and his nomination fulfills the promise that he made to all of you, gesturing to a crowd of conservative activists. So whether Mr. Priebus was suggesting that if confirmed, Judge Gorsuch would unsettle 40 years of precedent, like Roe v. Wade or Chevron, or whether he was suggesting that Judge Gorsuch would be a reliably conservative vote for the next 40 years, it seems clear to me that confirming Judge Gorsuch is central to President Trump's political agenda. Now, my Republican colleagues would have you believe that nothing could be further from the truth. In their view, they say judges call balls and strikes, nothing more, nothing less. Earlier this week, for example, Senator Cruz said, and I quote, conservatives understand that it is the role of a judge, especially the role of a Supreme Court justice, simply to follow the law. He said that Senate Republicans, quote, are not confirming someone who will simply vote with our team on a given issue. It's Democratic judges, according to Senator Cruz, who, quote, by and large view the process as achieving the result they want and view the process of adjudicating a case as a political process. Mr. President, let me explain why I take issue with that. If my Republican colleagues truly believe that a judge's proper role is to call balls and strikes and to decide cases narrowly, they would have confirmed Merrick Garland, a judge with a proven track record of crafting consensus opinions built on narrow holdings. But a judge who calls balls and strikes isn't really what my colleagues want. Contrary to what Senator Cruz said, my Republican colleagues, what they want is a results-oriented judge. Why else would they hold open a seat on the Supreme Court bench? Why else would they turn to the Heritage Foundation and the Federalist Society for candidates? Why else would they trample on the traditions of the Senate? What my Republican colleagues really want is a judge who will vote with their team. And that's the judge they'll get by confirming Neil Gorsuch. That's what this is all about. That's what this is about. Unlike Merrick Garland, Judge Gorsuch has little interest in reaching consensus or in deciding cases narrowly. Now, Judge Gorsuch took great pains to paint himself as a mainstream nominee. He pointed out that the 10th Circuit ruled unanimously 97% of the time, and that he was in the majority 99% of the time. But that's not unusual, and it doesn't provide any insight into his approach to being a judge. After all, the courts of appeals are required to follow Supreme Court precedent, and in all the circuits around the country, the vast majority of their cases are decided unanimously. So in order to really understand Judge Gorsuch's approach to deciding cases, in order to really understand how he views the law, it is critically important to look at the cases where he chose to write separate concurrences or dissents. These concurrences, these concurring and dissenting opinions, offer the clearest window into how he really thinks. And Judge Gorsuch tends to write a lot of concurring and dissenting opinions. Even when Judge Gorsuch agrees with the majority and joins their decision, he frequently writes his own concurrence, setting out his own views. Judge Gorsuch has done this 31 times, including writing 2 concurrences to majority decisions that he himself had written. That's not seeking out consensus, that's holding his nose to join a consensus opinion and then writing separately in order to point the way to broader, more sweeping rulings that other courts might issue in future cases. Other courts, like the Supreme Court, which doesn't have to follow precedent, and which he is now poised to join, and where he will not be restrained by precedent. Judge Gorsuch is a results-oriented judge, and his record demonstrates that he approaches cases with a very specific outcome in mind. Contrary to what my Republican colleagues would have you believe, he doesn't hide that judicial philosophy, whether it's his concurrence in Hobby Lobby or his dissent in Trans Am trucking. Judge Gorsuch wears that philosophy on his sleeve, and it only underscores a disturbing pattern of siding with corporate interests over average Americans. Now, that philosophy was on full display in the dissent that Judge Gorsuch wrote in Trans Am trucking. It seems clear to me that Judge Gorsuch approached this case with a specific outcome in mind, which was siding with a company over a worker. And in order to justify that outcome in his dissent, Judge Gorsuch twisted himself into a pretzel. You may have heard the story, but I want to lay it out as efficiently as possible because I think it reveals a great deal about Judge Gorsuch's philosophy and helps to explain exactly why I am voting against him. In this case, trucker Alphonse Madden is driving a rig on the interstate through Illinois. He's pulling a long trailer that's fully loaded. He makes a stop. He takes a break. And then at 11 p.m., he's about to pull back onto the interstate, but discovers that the brakes on his trailer are locked. It's 14 below zero out. These brakes are literally frozen. So he calls his dispatcher to ask for repairs. And he waits. While he's waiting, the heater in his cab stops working. And he falls asleep and is awakened by a call from his cousin. When Madden sits up to answer the phone, he realizes that his torso is numb and that he can't feel his feet. He's having trouble breathing. His cousin later says that Madden's voice is slurred and he wasn't tracking. According to the Mayo Clinic, these are all symptoms of hypothermia. Madden calls in to the dispatcher again. He's told to hang on. He says, I can't. His boss tells him he has two choices. Wait there until the repair truck comes, or he can take the whole rig on the road, including the trailer with frozen brakes. Those are the two options. Two options he was given by his boss. Madden knows that if he waits, he may very well freeze to death. That's his first option. Or he can go out on the interstate at 2 in the morning, dragging a fully loaded trailer with frozen brakes at 10, maybe 15 miles an hour max, posing a safety hazard to other drivers at the interstate. Remember, it's 2 in the morning. It's dark. It's probably icy. Imagine a car going 80, 85 miles an hour, as people do at 2 in the morning on an interstate, coming up over a hill on that, behind that rig, and then coming down and seeing this rig going 10 or 15 miles an hour while you're going 80, 85. That would be like suddenly coming down on a stopped tractor trailer while you're going 70 miles an hour. That's the second option. Instead, Madden does what any of us would do. He unhitches the trailer and drives down the interstate to find someplace warm. And he does. He gets warm, and then he returns to the trailer. When the repair truck finally shows up, and he is fired. He's fired for abandoning his cargo. Now, there is a law to protect people in Madden's situation, so he files a case, and it gets to the 10th Circuit, and a 3-judge panel agrees with him, with Madden. They find that the trucking company shouldn't have fired Mr. Madden, but one judge dissented, Judge Neil Gorsuch. So during my question, I asked Judge Gorsuch a very simple question: what he would do, what he would have done if he had been the truck driver, if he had been driving that truck. Which would you have chosen? Which would you have done? I asked. And here's Judge Gorsuch's response. Oh, Senator, I don't know what I would have done if I were in his shoes. Now, is there anyone here who would not have done what that driver did? I don't think so. Of course you would unhitch the trailer and find someplace warm as quickly as possible. Of course. But Judge Gorsuch said he didn't know what he would have done? Is that possible? I asked him if he'd even thought about what he would have done if he were Madden. You know, he had heard the case. He didn't answer. So I asked him again. I asked him, given the choice of sitting there and possibly freezing to death or going on the road with an unsafe vehicle or doing what Mr. Madden did, Judge Gorsuch responded, Senator, I don't know. I wasn't in the man's shoes. Judge Gorsuch said he decides cases based on the facts and the law alone. I go to the law, he said. But so, in fact, did the majority. Here's the operable law. Here's the law. Quote, a person may not discharge an employee who refuses to operate a vehicle because the employee has reasonable apprehension of serious injury to the employee or the public because of the vehicle's hazardous safety or security condition. The majority ruled that the company couldn't fire the truck driver because he had refused to operate the rig, the entire rig, because it was unsafe. But Judge Gorsuch said, no, by operating the cab, he was operating the vehicle. Therefore, he didn't refuse to operate a vehicle. Judge Gorsuch said he made that decision by applying the plain meaning rule. Now, I pointed out that the plain meaning rule has an exception. Quote, when using the plain meaning rule would create an absurd result, courts should depart from the plain meaning. It is absurd to say that this company was within its rights to fire him because he refused to choose between possibly dying by freezing to death or possibly killing other people by driving a semi on an interstate at 10 miles an hour at 2 in the morning. Frankly, the company is fortunate that Mr. Madden made the choice he made, because otherwise they may very well have faced a wrongful death claim. Now, everyone who is in the hearing knows what Judge Gorsuch would have done in Alphonse Madden's situation. If Judge Gorsuch had answered honestly, he would have said that he would have done exactly what the driver did. Everyone would. Judge Gorsuch just didn't want to admit it. That's because there was no good answer. If Judge Gorsuch said that he'd do the very same thing that Mr. Madden did, that would make his dissent look pretty bad. But if he said, I would have done what the company told me to do, that would be an absurd answer. That would make you question the man's judgment. No one would believe it. So instead, Judge Gorsuch said, I don't know what I would have done. But of course he knew. Just wasn't being honest. Judge Gorsuch approached Mr. Madden's case with an outcome in mind, siding with the corporation. And the dissent that he wrote makes that perfectly clear. Mr. President, when I joined the Senate back in 2009, I arrived here in June, a little later than the rest of my class. And just a few days later, my 5th day in office, Judge Sonia Sotomayor appeared before the committee, the Judiciary Committee, for her first day of confirmation hearings for the Supreme Court. I've been thinking a lot about Justice Sotomayor's hearings because the concern I expressed about the direction of the court back then is just as relevant as today. Back then, almost 8 years ago, I voiced concern about it becoming more difficult for Americans seeking a level playing field to defend their rights and get their day in court. From bringing a discrimination claim, to protecting their right to vote. Back then, I said, this is a quote, "I am wary of judicial activism, and I believe in judicial restraint. Yet, looking at recent decisions on voting rights, campaign finance reform, and other topics, there are ominous signs that judicial activism is on the rise." Now, that was my first opening statement, the first opening statement that I ever delivered in the first confirmation hearing that I ever attended. But in the years that followed, my concerns have proven to be justified. In one 5-4 decision after another, we have seen the Roberts Court go out of its way to answer questions not before it. Seen the Roberts Court go out of its way to answer questions not by Congress. And to do all of this at great cost to consumers and to workers, to small businesses, and to middle-class Americans. Decisions like Shelby County, where the court gutted one of our landmark civil rights laws. 5-4. Justice Scalia, during the oral arguments, suggested that when the Voting Rights Act had last been passed, 97-0 in the Senate, that the Senate had done it because of the name, Voting Rights Act. How could you not vote against the Voting Rights Act? What a great name. Showing contempt for this body. What's more judicially active than overturning a law voted unanimously in the Senate because the Senate just liked the name? And of course, what that did was you got rid of pre-clearance. Well, what's pre-clearance? Pre-clearance said that those states who had had a history of suppressing votes of minorities had to pre-clear any new voting laws with the Justice Department. These were states that had historically had a history of suppressing the votes of racial minorities. Well, that gets overthrown, boom. States like North Carolina and Texas start passing new laws, voting ID laws. The second section of the Voting Rights Act still stayed, so you could appeal to a federal court, but it takes a while to work its way through. So finally, in early 2016, a circuit court, Fourth Circuit, I believe, rules that North Carolina had targeted African Americans with almost surgical precision to suppress their votes. That's why you have pre-clearance. That's why you want pre-clearance. But in a 5-4 vote, preclearance was struck down. That's one 5-4 case. Concepcion, 5-4 decision that allows corporations to force consumers into mandatory arbitration. There are a whole host of 5-4 decisions that make it impossible for people to get to the courts. Perhaps most egregious of all the 5-4 decisions, Citizens United. Another 5-4 decision that paved the way for individuals and outside groups to spend unlimited sums of money in our elections. Now, in each one of these 5-4 decisions, Justice Scalia sided with the majority. So now this body considers replacing him with Judge Gorsuch. And I think it's important to understand the extent to which he shares Justice Scalia's views. And Judge Gorsuch's record demonstrates that he is, in President Trump's words, a judge, quote, very much in the mold of Justice Scalia. During his time on the 10th Circuit, Judge Gorsuch has consistently ruled in favor of powerful interests. He sided with corporations over workers, corporations over consumers, and corporations over women's health. A study published in the Minnesota Law Review found that the Roberts Court is the most pro-corporate Supreme Court since World War II. And if the Senate confirms him, Judge Gorsuch guarantee more of the same from the Roberts Court. And I don't believe that's a court that our country can continue to afford. So I oppose Judge Gorsuch's nomination. I urge my colleagues to take a close look at his record of siding with powerful corporate interests over average Americans, to consider carefully how he stands to impact the court, and to reject his nomination. Thank you, Mr. President, and I would suggest the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
Is eminently qualified to serve on the Supreme Court. He was confirmed by the Senate to his federal judgeship with no Democratic opposition at all, none. He participated there in more than 2,700 cases, writing in the majority 99% of the time, and enjoying unanimous support 97% of the time. He received the highest possible rating from a group the Democratic leader called the gold standard for evaluating judicial nominations, the American Bar Association. He's earned high praise from across the political spectrum, with Democrats and Republicans alike, attesting to his qualifications, his fairness, and his impartiality. He also enjoys the support of a bipartisan majority of the Senate. And yet, the Democratic leadership is now determined to block his confirmation with the first successful partisan filibuster of a Supreme Court nominee in American history. They proved that in yesterday's procedural vote. Judge Neil Gorsuch is one of the most impressive nominees we've ever seen. If a widely praised nominee like this can't get past the Democratic filibuster, then no nominee of a Republican president could. Democrats would filibuster Ruth Bader Ginsburg if President Trump nominated her. We all know why. The Democrats are bowing to hard left special. Trump nominated her. We all know why. The Democrats are bowing to everything this president touches. And as the Washington Post just reported, the Democratic leaders seem ready to endorse every argument the activists have made. It seems some Democrats made up their minds long ago to oppose whomever the president nominated. The Democratic leader himself indicated as much before Judge Gorsuch was even selected. He even mused on a liberal talk show about holding the seat open indefinitely. So it doesn't really matter who this president nominates. A Democratic minority is determined to successfully launch an unprecedented partisan filibuster regardless. Perhaps that's why Democrats still have yet to put forward a cogent rationale to oppose him. Not that that would be easy, you understand. As a longtime Democrat and board member of the left-leaning American Constitution Society put it, the Senate should confirm Justice Gorsuch because there is no principal reason to vote no. Well, if there's no principal reason to vote no on this nomination, then there's certainly no principal reason to prevent the Senate from taking a vote on it at all. But that's just what a partisan Democratic minority of the Senate is threatening to do. For the first time in nearly 230-year history of the Senate, so let me remind colleagues of something I said yesterday. When President Clinton nominated Justice Ginsburg, I voted to confirm her. When President Clinton nominated Justice Breyer, I voted to confirm him. When President Obama nominated Justice Sotomayor and Justice Kagan, I led my party in working to ensure that they received an up or down vote. In other words, not a filibuster. I knew I would often disagree with their opinions on the court, and I certainly wasn't wrong about that, but I thought it was the right thing to do. I understand that our Democratic colleagues are currently under a great deal of pressure from special interests on the far left. I think everyone in elected office can empathize with the situation they're experiencing. Listening to these hard left special interests may seem like the politically expedient thing for Democrats to do for their party today, but I'd ask them to make their decision based on what they know is right for the country tomorrow. There's still time for them to make the right choice. There's still time for them to support a nominee who even longtime Democrats have praised, or at the very least, to not block him with the first successful partisan filibuster in American history. So I hope Democrats reevaluate their position before the important vote we'll take tomorrow. I hope they'll consider what their actions would mean for future Supreme Court confirmations. I hope they'll consider what their actions could mean for the future of this body more broadly. Because as we all know, the American people will be watching. History will record the decision Democrats make, and there's simply no principal reason to oppose this exceptional Supreme Court nominee.
Mr. President.
The senator from Iowa.
We're continuing to debate the nomination of Judge Gorsuch to serve as Associate Justice of the United States Supreme Court. My colleagues on both sides of the aisle have said that this is an important moment for the United States Senate. I couldn't agree more. I think it's important to reflect on why we're here and how we got here. Before I turn to the Supreme Court and the current debate, let me take just a few minutes to talk about lower court nominees and provide a little bit of history and context, especially for the benefit of some of the senators who weren't here over the last few years. I'm going to start way back in the spring of 2001. President George W. Bush had just been elected president. As we know, we all know, in fact, it was a close election, and it was hardly fought. The Senate was closely divided, with the Republicans in control. Given how close the presidential election was, there were elements of the hard left who refused to accept the results of that election. Some blamed Ralph Nader, others blamed Governor Jeb Bush, and still others blamed the Supreme Court. Many on the hard left claimed that President George W. Bush wasn't, quote unquote, a legitimate president. Liberal interest groups were egging on the Democratic leadership to fight the new president at every turn. Now, that still sounds very familiar for this year that we're in. At the same time, one major concern for the hard left liberal interest groups was that President Bush, whom they claimed wasn't legitimate, would be able to nominate conservative judges. Again, doesn't that sound familiar? Senator Cornyn went over some of this same subject yesterday, but it deserves discussion now, and it deserves as a reminder where we've been before, because sometimes the past predicts the future. So in the spring 2001, the hard left interest groups went to the Senate Democratic leadership with a plan. According to the New York Times, 42 of the Senate, and this is a quotation, 42 of the Senate's 50 Democrats attended a private retreat where a principal topic was forging a unified party strategy to combat the White House on judicial nominees, end quote. Thinking about 2017, doesn't that sound a little familiar? At that meeting, Cass Sunstein, Marsha Greenberger, and Lawrence Tribe spoke at the retreat and pitched to the Democrats present there, their idea of how this crusade could proceed. One to attend, I quote, according to one attendee, and I want to quote, they said it was important for the Senate to change the ground rules, and there was no obligation to confirm someone just because they're scholarly and erudite, end of quote. Well, let's think about that for a moment. Why do you suppose they believe they needed to change the ground rules for confirming judges? It's because up to that point, you didn't filibuster judges. You just didn't. And you heard the minority or the majority leader just speak to that point in his short remarks this morning about how things have changed after more than 200 years. Well, as it happened, less than a month after the caucus retreat, Senator Jeffords from Vermont switched parties and began caucusing with the Democrats. That threw the majority to the Democrats for the next 18 months. And then they lost the election of 2002, and in the spring of 2003, Republicans were back in the majority. Now, back in the minority, Senate Democrats went ahead with plans that were enunciated at that retreat to change the ground rules. For the first time in the history of the Senate, they began to systematically filibuster circuit court nominees, not because they believed the nominees weren't qualified, because these nominees were qualified, not because they believed those nominees didn't have the necessary experience, because these nominees did have the necessary experience. They filibustered those nominees because they believed that they were conservative judges. So with respect to appellate court nominees, Senate Democrats, at the behest of the far left, took the unprecedented step of using the filibuster in a very systematic way for the first time in Senate history. At the time, there was a lot of debate about changing the rules, dubbed the so-called nuclear option, so that nominees would be afforded an up or down vote consistent with Senate history and practice. Well, Republicans exercised restraint and agreed to step back, vote consistent with Senate history and practice. Well, Republicans of the filibuster for judges, but we also didn't think there should be two sets of rules, one for a Republican president and one for a Democratic president. Common sense tells you that that's a legitimate position to take. We defeated two circuit court nominees, one to the Ninth Circuit and one to the D.C. Circuit. Then President Obama nominated three individuals to the D.C. Circuit. One side denied cloture. Our side denied cloture on these three nominees to the D.C. Circuit. Well, at that point, their side didn't like playing by the rules that they wrote. So Majority Leader Reid, then Majority Leader Reid, took another unprecedented step. In November 2013, he utilized the so-called nuclear option to eliminate the very tactics that they pioneered. So nuclear option becomes effectively the Reid rule. So that's how the filibuster was first used on lower court nominees and later eliminated. Senate Democrats took the unprecedented step to utilize that. And then when it no longer benefited them, they used unprecedented means to eliminate it. So this brings me back to where we are today and the rest of this week, to talking about a Supreme Court nominee, Judge Gorsuch. Everyone knows that we had a big debate last year about whether to proceed with a Garland nomination. There were 52 Republicans who believed that we should follow Senate history and tradition and not proceed with the nomination in the middle of a heated election year. And I know it frustrates my colleagues to hear me say it, but the fact of the matter is that in 1992, when then Senator Biden was chairman of the Judiciary Committee, he announced that he wouldn't hold a hearing to fill a vacancy in the last year of President Bush's term. So last year, we followed the precedent.
The senator from Connecticut.
I'd ask that we dispense with the quorum call.
Without objection.
Thank you, Mr. President. Mr. President, confirming a Supreme Court justice, it's really one of, if not the most important responsibilities that we have as U.S. senators. It's a vote that we cast full well knowing that the tenure and the influence of the nominee that's before us will likely be greater and much more long-lasting than our own in the Senate. After meeting with Judge Gorsuch and reviewing hours of his testimony before the Judiciary Committee, I've decided to oppose his nomination, and I come to the floor this evening to talk about the reasons why. I'm deeply concerned about the politicization of the Supreme Court and its recent capture by corporate and special interests. I'm convinced that Judge Gorsuch would exacerbate that slide and continue the activist bent of the existing court. And for that reason, I won't be supporting him in the vote tomorrow. And there's no doubt that Neil Gorsuch is a well-trained, very intelligent lawyer who likely has the right disposition to serve on our nation's highest court. But that's not the end of the analysis that I or any of us are required to conduct. I'm concerned by Judge Gorsuch's record of putting corporate interests before the public interest. His past decisions, they demonstrate a resistance on his part to put victims' and employees' needs above those of large corporations. He's regularly sided with employers over workers, corporations' religious rights over the rights of employees to make personal health care decisions. And while he admirably claims to rest his decisions on the law rather than on political views, his consistent support for the powerful over the powerless, it doesn't seem coincidental. The Roberts Court, in my mind, has swung dramatically in favor of the rights of corporations and special interests over those of individual Americans. I would have supported a mainstream nominee, but the risk that Judge Gorsuch will inject his political judgment into a process that already too often favors the rights of special interests or corporations over the rights of individuals, it's just too great. That risk is too great for him to earn my support. Mr. President, that was the statement that I released upon making my decision. I want to begin my remarks with it. But I want to talk a little bit about the elements inherent in my decision to vote against Judge Gorsuch, because I don't take that decision lightly. I've said all throughout the beginning of President Trump's tenure that I do believe that we owe some degree of deference to a president in making choices as to who will serve him in his administration. And I think that likely applies to the question of who a president chooses for the Supreme Court as well. And I think I've voted that way. I've certainly voted against many of President Trump's nominees, but I've voted for many of them as well, nominees with whom I had very deep disagreements over policy. And so it's not a question of whether Judge Gorsuch would be my choice. It's a question of whether I think he is going to be in the mainstream on the Supreme Court or whether I think that he is going to be an outlier, bring potentially radical views into the courtroom. But it's kind of silly for us to pretend that this debate is happening in a vacuum. I'm making my mind up on Judge Gorsuch, as I will try to outline this evening, based upon my review of his record and my belief about who he will be as a justice. But we'd all be lying if we didn't say, as Democrats, that we don't remember what happened on the floor of the Senate all throughout 2016. Merrick Garland should be on the Supreme Court today. Or if not Merrick Garland, someone else that was nominated by President Barack Obama. A Supreme Court vacancy occurred with nearly 12 months left on his term, 25% of a term that he was elected to by the people of the United States. The Constitution doesn't allow for 3-year terms. It doesn't say that the president becomes illegitimate once he hits the final 12 months. The framers of our Constitution, they were hopeful that a president would be president for all 4 years. And that last year was robbed, not just from President Obama, but from the American people by Republicans in the Senate, when they treated Judge Garland with such disrespect. It would have been one thing to simply vote against him because you didn't want to let a president of an opposing party fill that seat, but to not even give him a hearing, to not give him a vote, to not even take meetings with him, which was the decision of many Republican colleagues, that was a That was a show of disrespect to Judge Garland that I don't think any of us could have imagined. And it was a show of disrespect to this chamber, to the traditions of this body, that those of us who may have supported Judge Garland, we remember. That bad taste still sits in our mouth. And so I'm clear to tell you that my vote against Judge Gorsuch is not payback for the way in which Merrick Garland was treated. But I remember what happened. And to the extent that my Republican colleagues are suggesting that we should vote for Judge Gorsuch, or at least vote for cloture tomorrow, as a means of upholding the traditions of the Senate, spare me. Spare me. There isn't a lot of interest on this side of the aisle in upholding the traditions of the Senate if we're the only ones doing it. I mean, some people say, well, if you voted for cloture on Gorsuch tomorrow and let it go to a final vote, then maybe Republicans would, keep the rules as is. That just is belied by the facts. Last year, the Republican majority made it pretty clear that they were willing to break all tradition, all precedent, and all comedy in the Senate in order to get their person on the Supreme Court. That wasn't just a 2016 thing. That is the new normal for Republicans in the Senate. And so whenever Democrats raised an objection to a nominee to the Supreme Court, the rules were going to change. Because Republicans have made it clear that their first priority is to get their people on the Supreme Court, and their second priority is to think about and try to preserve the way in which the Senate has run. So I'm not voting against Neil Gorsuch because I'm mad about what happened. But to the extent that I've heard Republicans in the Senate lecture us about violating the traditions of the Senate, it makes my blood boil. Because I was here in 2016. I saw what the Republican majority did to Merrick Garland. And maybe we can sit down after this is done and talk about how the Senate just doesn't get into a giant vortex of devolvement, tit for tat, such that all of the reasons why people run for the Senate, the individual pejoratives that senators have, the demand to find consensus in a way that doesn't exist in the House, it all vanishes. Merrick Garland is still here. And it'd be silly for us to try to pretend that he isn't. One of the reasons that I am so worried about Judge Gorsuch is because of his enthusiasm for a brand of judicial interpretation called originalism. Now, it doesn't sound that radical, right? Originalism. The idea is that you interpret the Constitution as the Founding Fathers intended it to be. You don't place it in the context of today. You simply think to yourself, what would those white men who wrote those words, what would they think about what's the case before us? What did they mean back in the late 1700s? On its face, it's an absurd way to think about judging cases because so much of what is before you as a justice, right, had no relevance, did not exist back in the 1780s. So questions about what these men thought about various questions regarding technology or civil rights, right? They are irrelevant because the framers of the Constitution simply weren't thinking about the same things that we're thinking about today. And one of our most famous jurists, he understood this right from the outset. Justice John Marshall famously wrote in McCulloch versus Maryland, we must never forget that it is a constitution we are expounding, intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. Even those that were judging the Constitution at its outset understood that as the questions presented to this country changed, originalism, the idea that you only look to the thoughts and words and deeds of the Founding Fathers, probably wouldn't be an efficient way to decide cases. Justice Brennan gave a really wonderful speech at Georgetown in 1985 that's worth reading from tonight. Justice Brennan said, "We current justices read the Constitution in the only way that we can, as 20th century Americans. We look to the history of the time of framing and to the intervening history of interpretation. But the ultimate question must be, what do the words of the text mean in our time? For the genius of the Constitution rests not in any static meaning it might have had in a world that is dead and gone, but in the adaptability of its great principles to cope with current problems and current needs." He further went on to say, "Time works changes, brings into existence new conditions and purposes. Therefore, a principle to be vital must be capable of wider application than the mischief which gave it birth." It's a wonderful turn of phrase. He says this is peculiarly true of constitutions. They are not ephemeral enactments designed to meet passing occasions. They are, to use the words of Chief Justice John Marshall, designed to approach immortality as nearly as human institutions can approach it. He says interpretation must account for the transformative purpose of the text. The transformative purpose of the text, he says. Our Constitution was not intended to preserve a pre-existing society, but to make a new one, to put in place new principles that the prior political community had not sufficiently recognized. Senator Klobuchar asked Justice Gorsuch at his hearing if, because the Constitution only uses the word he or his, if it meant that a woman could not be president. Well, the Constitution doesn't specifically speak to this question, but if you're an originalist, I can imagine how many of those founding fathers would have answered that question. Why? Because they didn't believe that women deserved the right to vote. So why on earth would they have believed that a woman should be president? At the time, blacks were considered to be subhuman. They were granted 3/5 status in the Constitution. They were slaves. And so to read a document only through the lens of a group of white males who didn't believe that a woman should be allowed to vote, didn't believe that blacks were human beings on equal footing with the rest of us, is to freeze this document in a time and ask it to consequently freeze ourselves in that time as well. If you don't allow the document to move, then you don't allow the rest of us to move either. Originalism is a fraud. And what it has become is a mask for politics. Now, what do I mean by that? When you insist on interpreting the Constitution only based on the ways in which the writers of that document viewed the world, you have no way to base decisions in current times based on any real text or set of historical facts, because of course the Founding Fathers had given no thought to many of the most important questions that are presented to us today. For instance, questions about what rights individuals have with respect to government surveillance over their cell phones, a question that the Founding Fathers, the framers of the Constitution, could have never considered. And so it allows you to essentially make it up for yourself, because there's no way that you can find a quote from any of the signers of the Constitution as to what they thought about these modern questions. So you can spin it any way that you need to. Originalism is an invitation to bring politics into the court, because anybody can make up a reason why the people that wrote the Constitution would ultimately have decided the way that that jurist wants the decision to turn out. And it connects with other troubling writings of Judge Gorsuch. He proudly calls himself an originalist, which I would argue is not a mainstream, historically, if we look at the broad swath of jurists who have sat on the Supreme Court, it is not a mainstream school of judicial interpretation. But he has other radical views as well. The Chevron deference standard is named for a 1984 case in which the Supreme Court held that it should defer to regulatory agencies when they interpret ambiguous laws passed by Congress. We pass ambiguous laws sometimes on purpose and sometimes by accident here, but we often do it on purpose because we ultimately leave it to the regulator to fill in the details, to proffer regulations, to work out the details of enforcement. We often don't define every single term, in part because we know that there's going to be an elected branch, the executive branch, people working for an elected official, the President of the United States, who is going to carry out that act and be ultimately responsible to the people. What Judge Gorsuch has suggested is that maybe it's time to overturn the Chevron deference standard. Maybe we shouldn't give any deference to administrative agencies any longer. Maybe the Supreme Court, on every single law, should do a de novo review of its constitutionality and give no deference to the executive branch. Well, first of all, that would be pandemonium. It would greatly accelerate the number of cases that come before the Supreme Court and the number of major, potentially life-changing decisions that the court, the unelected court, is making. Why? Because we are always passing statutes here that leave room for interpretation. Again, we do it many times intentionally, sometimes unintentionally, but it happens every single month here, that we pass statutes that leave room for interpretation. And we often do that knowing, as I said, that the executive will make some of those secondary interpretations. And we are comfortable with that because if their interpretation goes wrong, then that executive is never more than about 3.5 years from an election. The executive branch is responsible to the people. The courts are not. These are lifetime appointments that we make. And if every single statute that we passed is interpreted from the foundation by the Supreme Court, if they get it wrong, there is no way to get rid of them. There is no way to roll that interpretation back. In fact, that's one of the reasons for Chevron deference. The reluctance of the court to make itself an active political player in the process of interpreting statutes. And so it is radical that Judge Gorsuch is suggesting that if he was put on the Supreme Court, he would overturn that 1984 case. Justice Scalia was one of the primary defenders of Chevron. for that very reason, that he saw that the legitimacy of the court, indeed the legitimacy of the entire judicial system, would be put in jeopardy if it inserted itself as the primary arbiter of ambiguous statutes, of statutes that needed interpretation. Originalism is an invitation to bring your politics onto the court. The evisceration of the Chevron defense would inherently make the court a political body. And you combine the two together, and you start to see a justice who will likely continue this trend line of an activist court making political decisions in substitute of the United States Congress. And we all have seen it happen, whether it be in the voting rights case, in which the unelected Supreme Court decided that racism wasn't something that we had to think about any longer due to their vast experience in the South dealing with cases of voter suppression, or their arbitrary decision that corruption should be very, very narrowly defined, and that we need not pay attention to the slow, creeping corruption that happens when donors get access to the political process through donations of thousands and tens of thousands and hundreds of thousands and millions of dollars. The Supreme Court telling the people of this country and this Congress what corruption is and what it isn't. Those are political decisions that the court has made. An activist court who now may have amongst its members a justice who has effectively advertised himself as willing and eager to join that trend line on the court. Individual cases raise concerns as well. In Riddle v. Hickenlooper, Judge Gorsuch expressed an openness to providing a higher level of constitutional protection to a donor's right to make political contributions than is currently afforded to the right to actually vote. Donors having more rights than voters having. The result of applying strict scrutiny, which is the term that he's referring to political donations, we don't exactly know what would happen, but it likely would have the consequence of making it almost impossible to regulate campaign finance. 93% of Americans in a recent poll think that government should be working to limit the impact that big donors have on politics today. And yet, Judge Gorsuch has suggested that as a Supreme Court jurist, he may move the law in the opposite direction, robbing from us, both of us, Republicans and Democrats, the ability to do what 93% of Americans want us to do, which is to restrict the ability of a handful of billionaires to affect the political process. In the Hobby Lobby decision, yet again, Judge Gorsuch suggests that corporations, in this case, have more rights under the Constitution than the individuals who work for them, that the religious freedom rights of the corporation trump the religious freedom rights of employees. Once again, ruling that those with power, big donors or corporations, have more rights than those with less power, ordinary voters, employees of these big companies. Judge Gorsuch wrote years ago in complaint, according to him, that liberals were using the court to try to push their political agenda rather than bringing it here to the United States Congress. Well, the reality is that over the course of the Roberts Court, the exact opposite has happened. It's been conservatives who have brought their complaints to the court system, their complaints about voting rights, their complaints about campaign finance, their complaints about the Affordable Care Act, rather than bringing them to the floor of this body. As the House of Representatives abandons for the time being the repeal and replacement of the Affordable Care Act, their allies continue to push cases through the court system that would attempt to unwind it. Justice Gorsuch has been, in his writings at least, blind to this idea that conservatives have spent just as much time over the past 20 years trying to push their agenda in court as have progressives. Progressives have done that as well. Clearly, we have full marriage rights in this country because of court cases that progressive groups pushed. I'm not denying that there isn't this trend line on both sides of the political spectrum, but Judge Gorsuch seems to only recognize it in his writings when it comes to the liberals that are pushing these causes. These are the most important decisions we make. Many of us may only get to vote on a Supreme Court justice once or twice. This is my 5th year in the United States Senate, and this is my first vote. My first vote should have come in 2016, but it's coming now in 2017. And so I don't take it lightly. But there's a reason why when you go back to your apartment here in Washington, you're watching TV commercials paid for by big corporations and billionaires supporting Judge Gorsuch's nomination. He says that he's going to play it straight. He says that he's not going to be affected by his political agenda. I hope that he's right, but the folks that are fronting the money for these ads don't believe him. They think they know how he's going to rule. Believe me, they would not be putting up all of this money on TV if they didn't think that Judge Gorsuch was going to be a friend to the big companies, to the billionaire donors who want more and more protection through the court system. Donald Trump was right about something when he ran for president. He wasn't right that elections are rigged, but he was right that in general, the system, our economic state of affairs, does seem to be pretty rigged against regular people. Right? Economic mobility, which is how we define ourselves as a country, it's further away from the people that I represent in Connecticut than ever before. And the statistics bear that out, right? Your ability to move from poverty to prosperity is less today than it has been at any point in our lifetime. It does feel like the powerful, the rich, feels like they've recovered very nicely from this recession and nobody else has. And it feels like they have a voice here in Washington that no one else has either. And so if you're President Trump, having run on this promise to unrig the system, boy, this doesn't seem like the person that you should be sending to the bench. Somebody that has openly advertised his enthusiasm for voting with billionaires, with corporations, with folks who have lots of political power already. The Trans Am case, which has been talked about enough on this floor, is a unique one. Case of a trucker who was being potentially left to die by his employer on the side of the road and left his truck to save his life and potentially the lives of others on the road had he chose instead to operate it. And Judge Gorsuch ruled with his employer, effectively suggesting that this man should have risked his life or the life of others to comply with the strict letter of the law. And Judge Gorsuch was asked in the Judiciary Committee what he would have done. What would you have done if you had two options? Sit in that truck and face death, or put it back on the road and potentially kill others? What would you have done? And Judge Gorsuch said that he hadn't thought about that. I don't want my Supreme Court justices to be political. I don't want them to be us. Right? It really is our job to think about in a real, tangible, grassroots way the effect of our laws on their lives. But I don't want a justice who doesn't even contemplate the answer to that question, the impact of the law on regular people. I don't want a justice who only views the law through the eyes of a group of white men who lived in a fundamentally different world. I don't want a judge who isn't thinking about how the law applies to people that need a statute's protections, rather than thinking about those who frankly don't need the protection of statute because they've been handed a pretty good lot at life from the start. I'm going to oppose cloture tomorrow, and if we eventually get to a vote, I will oppose Judge Gorsuch on final passage. And my final comment is this, Mr. President. When that moment comes, I do hope that our colleagues will think twice about changing the rules of the Senate. You already broke with precedent once in 2016 in a way that I think is unforgivable. To do it twice in a 24-month period, it puts this place on a downward spiral that I'm not sure we can recover from. And if we just want to be the House of Representatives, let's just do it. But there's another way to go, to select a nominee who could truly get bipartisan support. As my colleague Tim Kaine is fond of saying, there's only one appointment by the President of the United States that needs 60 votes. There's only one person that the President picks that needs to get more than 50. That's a justice to the Supreme Court because it's permanent, because it's important, because it lasts longer than us. There's probably some good reason for that. Precedent in comedy was broken in 2016. It's something I will never, ever forget. The disrespect shown to Judge Garland and to everyone in this body. But to double down on that break with precedent, on that break with tradition, by changing the rules of the Senate permanently with respect to Supreme Court justices. I know you can say that Democrats did it a few years ago. That's true. But the Supreme Court is a different animal entirely. And the decision is one that I hope my Republican colleagues will rethink. I thank the body for their indulgence this evening, and I yield the floor.
Mr. President.
Senator from Hawaii.
Mr. President, when Senate Republicans executed their unprecedented block of President Obama's nominee, Merrick Garland, the well-credentialed, well-respected, moderate chief judge of the D.C. Circuit, they knew what they were doing. They were willing to set aside the history and practice of the Senate to make sure no nominee of President Obama's would fill the vacancy created by Justice Scalia's death. As fate would have it, a Republican won the presidency, and now the majority leader's path was clear. And this is exactly what happened. President Trump selected Neil Gorsuch from a list put together for him by the ultra-conservative Heritage Foundation and Federalist Society. These organizations selected Judge Gorsuch because they want to preserve the conservative 5-4 majority of the Roberts Court. This majority has done terrible damage to many laws Congress has passed to protect ordinary Americans and has made it more difficult for us to pass new laws. My colleagues and I have shined the spotlight on these right-wing organizations and the 10 million plus campaign they've run on Judge Gorsuch's behalf because they believe his view of the law matches theirs, and therein lies our concern. These organizations have spent so much money and worked so hard on Judge Gorsuch's behalf because they could trust, perhaps not 100% of the time, but enough of the time that Judge Gorsuch would decide cases in ways they would agree with and support. Judge Gorsuch is an Ivy League educated lawyer with 10 years on the federal bench. He is not naive. Even if he refuses to acknowledge the fact that these groups are supporting him, Judge Gorsuch knows, as well as we all do, that politics have a real impact on the kinds of nominees selected to serve on the Supreme Court. We know he understands this because he said so in his 2005 National Review online article, which he entitled, quote, "Liberals and Lawsuits." In that article, he wrote that because Republicans had won elections for the presidency and for control of the Senate, the Republicans were in charge of the judicial appointment process. As a result, he said, and I quote, "The level of sympathy liberals pushing constitutional litigation can expect in the courts may wither over time, leaving the left truly out in the cold," end quote. This article demonstrates that Judge Gorsuch understands that judges appointed and confirmed by Republicans will have less sympathy for, as he put it, liberals pushing constitutional litigation. Clearly, judges do not make decisions divorced from their personal and philosophical leanings. However often or however loudly they might protest, conservatives understand that their arguments about the narrow role of judges, their claims that justices are only there to modestly apply the law and adhere to the Constitution, are bunk. And Judge Gorsuch must know this too. Nowhere is this brand of conservative judicial activism clearer than in the actions of the Roberts Court to reach into our elections, to tilt the political landscape with a significant impact on whose votes are heard in our political process and who is able to take part in our elections. Based on his writings, Judge Gorsuch clearly understands the relationship between politics and the courts. And I am convinced that adding Judge Gorsuch to the Roberts Court will only continue the court's intervention into politics. The actions of the Roberts Court are clear. This court has issued a series of decisions that have made it easier for conservative organizations to spend unlimited and unregulated dark money on elections, and that may have made it harder for people to vote, harder for people to participate and have their voices heard in the political process. These decisions have changed who is able to participate in the democratic process, who gets elected, and in turn, who gets nominated to the Supreme Court. Justice Felix Frankfurter's famous admonition that, quote, "courts ought not to enter this political thicket," end quote, captures the challenges for courts treading into politics. Of course, there are times when the courts must do so, to ensure one person, one vote, for example. But courts must also be careful when wading into politics because the legitimacy of the court is itself put at risk. The most memorable example, of course, came when the court effectively decided the 2000 presidential election in Bush v. Gore. In the Citizens United and Shelby County decisions, we have seen the tremendous damage the court can do to democracy when it tilts the electoral process so heavily against ordinary Americans. In the 2010 Citizens United decision, the Roberts Court struck down bipartisan laws limiting campaign contributions that went back more than a century. This decision opened an unrestrained flow of money and potential corruption that has dominated our politics and drowned out the voices of ordinary Americans ever since. This court's decision in this case was not an accident. Chief Justice Roberts engineered the decision in that case by steering it away from the narrow question before the court about how to apply a particular law and took it into a broad constitutional question. His efforts demonstrate that the Supreme Court has broad power and latitude to push and shape the law. This kind of conservative judicial activism directly contradicts what Justice Roberts famously said during his confirmation hearing. He said the job of a justice is just to simply call balls and strikes. Jeffrey Toobin, in a 2012 article in The New Yorker entitled, quote, "Money Unlimited, How Chief Justice John Roberts Orchestrated the Citizens United Decision," and in his recent book, The Oath, recounts very clearly how Chief Justice Roberts engineered this campaign spending decision. The question originally presented to the Supreme Court in Citizens United, according to Toobin's account, was a narrow one. It involved whether one of the provisions of the bipartisan McCain-Feingold campaign finance law applied to a documentary criticizing a candidate and not just to television commercials. In fact, Ted Olson, the well-known conservative candidate, and not just to television commercials, made a narrow argument that the McCain-Feingold law was not meant to apply to that kind of documentary. And this was an argument based not on the Constitution, but on deciding the case before the court in the narrowest possible way. Such a decision would have been judicial restraint. It became clear during oral argument that the conservatives on the court had the opportunity not just to apply the law, but began to do this by aggressively questioning the government's lawyer on issues not then directly before the court. As Toobin describes, and I quote, "Through artful questioning, Alito, Kennedy, and Roberts had turned a fairly obscure case about campaign finance reform into a battle over governmental censorship." End quote. Now that it was clear to Chief Justice Roberts that there was a majority on the court for making a broad constitutional decision, he ordered that the case be re-argued, rather than simply decide the narrow question argued by both Olson and the government's attorney. Chief Justice Roberts wanted the court to take head-on a question that was not in fact before it, and which the court had decided the opposite way only 6 years before. When the Roberts Court decided Citizens United the following year after re-argument, it did so on the broadest possible ground, on constitutional grounds, and found that corporations, like people, have First Amendment rights. It found that these rights could be violated by limits on campaign contributions. Again, this outcome did not happen by accident. Chief Justice Roberts engineered the result. According to Toobin's account, Chief Justice Roberts chose to assign the opinion for the majority to Justice Kennedy, who was known to be very skeptical of campaign finance laws and believed that limits on campaign spending violate free speech. By doing so, Chief Justice Roberts ensured that Citizens United decision would be a broad one, and it was. The way the court chose to reach out and change the law was wholly unnecessary to decide the case at hand. And it certainly was not judicial restraint. It was judicial activism. The court and Citizens United reached out to overturn precedent and upended laws dating back more than a century to find new rights for corporations to funnel untold millions into our political system. This decision also severely limited the ways in which Congress could take action to continue to pursue the aims of campaign finance laws to limit political corruption. In his article, Mr. Toobin said, and I quote, "Citizens United reflects the aggressive, conservative judicial activism of the Roberts Court. It was once liberals who were associated with using the courts to overturn the work of the democratically elected branches of government. But the current court has matched contempt for Congress with a disdain for many of the court's own precedents." When the court announced its final ruling on Citizens United on January 21st, 2010, the vote was 5-4, and the majority opinion was written by Anthony Kennedy. Above all, though, the result represented a triumph for Chief Justice Roberts. Even without writing the opinion, Roberts, more than anyone, shaped what the court did, end quote. But the Roberts Court was not done with its activism to radically change the landscape of our elections. In another narrow 5-4 decision in Shelby County in 2013, the court substituted its conclusions for that of Congress and gutted core protections of the Voting Rights Act, protections which were essential for the right to vote for millions of Americans. Again, this was not a decision the court needed to or should have reached. And again, it was a decision engineered by Chief Justice John Roberts and the conservative majority on the Supreme Court. Back in 1982, Chief Justice Roberts, then a special assistant to the Attorney General, was the point person for the Reagan administration's opposition to strengthening the Voting Rights Act. At that time, Congress acted to fix a hole in the Voting Rights Act that the Supreme Court had opened in a 1980 decision. John Roberts was opposed to these efforts to make clear that election practices or procedures that result in discrimination, not only those with the intent to discriminate, violate the Voting Rights Act. In 1982, Congress successfully passed their fix over the objections of John Roberts and the Reagan administration. If you look at John Roberts' memos and articles from that period of time in which he was a strong advocate within the administration for the position it took, his view of the Voting Rights Act was clear. It was a view he would apply years later as Chief Justice of the Supreme Court when he led a 5-4 majority to gut Section 5 of the Voting Rights Act. The pre-clearance provisions of Section 5 mandated that any changes to voting laws in states with a long history of discrimination have to be approved in advance or pre-cleared by the Justice Department or by the D.C. District Court. These provisions, passed a century after the conclusion of the Civil War, for the first time effectively guaranteed the rights protected by the 14th and 15th Amendments in many parts of the country. Section 5 changed the landscape of our democracy and opened the door for millions of people to exercise their right to vote. These provisions of the Voting Rights Act were reauthorized nearly unanimously by Congress in 2006. Before reauthorizing the Voting Rights Act, the Senate Judiciary Committee alone held 9 hearings on it. Thousands of pages of material the Senate reviewed, together with the record developed in a dozen hearings in the House, clearly established why it was so important to maintain pre-clearance in order to protect the right to vote in jurisdictions with a long history of voting discrimination. And yet, in Shelby County, the Roberts Court ignored this evidence and the court's long precedent. The court made its own determination about the value of the extensive evidence reviewed by Congress. it struck down these core provisions. The court refused to defer to the extensive findings and determination of Congress, even though Congress is expressly charged by the 14th and 15th Amendments to enforce the guarantees of those amendments, the guarantee, the right to vote. The court did what John Roberts fought to do years before and weakened the Voting Rights Act. So much for judicial restraint. So much for just calling balls and strikes. A justice and a court devoted to judicial restraint with an understanding of the separation of powers never would have ignored Congress acting at the height of its constitutional powers and its fact-finding capacity. Yet, Chief Justice Roberts and the narrow conservative majority on the court chose to act, to reach out, and to gut one of the core protections of the fundamental right to vote. We now know that Congress got it right and the Supreme Court got it wrong in its judgment about the continuing need for Section 5 of the Voting Rights Act. Immediately after the Shelby County decision, numerous states previously covered by Section 5 immediately passed onerous voter ID laws and other barriers that affected the right to vote of millions of people. Some of these laws were even enacted with discriminatory intent, not just discriminatory effect. In other words, they were blatantly meant to discriminate in voting. These newly raised barriers had a clear impact in last year's elections. For the first time in 2 generations, thanks to the actions of the Roberts Court, we risk unraveling the progress my friend John Lewis fought for alongside so many others during the civil rights movement. During his confirmation hearing, I asked Judge Gorsuch about the Shelby County decision, since he often explained the constraints on his approach to judicial decision-making in terms of the separation of powers. He said several times that judges make terrible legislators, that courts lack the staff, capacity, and training to do the kind of fact-finding that is an essential part of the legislative process. And yet, when I asked him whether the court's decision in Shelby County raised the kinds of concerns he had noted about the limits of judges as policymakers and legislators, he declined to answer. But this is about more than Judge Gorsuch's refusal to answer. It is about more than the narrow view he expressed of the role of the judge, or particularly a justice. A narrow view that is not a reflection of the real world. Both the process and the outcome in Shelby County and in Citizens United raise exactly the kind of concerns that make it so important for the Senate to understand Judge Gorsuch's judicial philosophy before putting him on the Supreme Court. Judge Gorsuch would become part of a newly empowered 5-4 conservative majority on the Roberts Court that has been anything but restrained in moving the law for the benefit of corporations and against individual rights. Taken together, these 2 decisions, Citizens United and Shelby County, have made it harder for millions of Americans to have their voices heard in our election process and their votes counted in the ballot box. Since Citizens United, the floodgates have opened to unfettered corporate money in our elections. Since Shelby County, 13 states have enacted laws placing limitations on voting. Many of these are in states that would have been prevented from doing so in the first place before the court gutted Section 5 of the Voting Rights Act. After Shelby County, these states could pass such laws, and they did, disenfranchising tens of thousands of voters in the process. My Democratic colleagues and I asked Judge Gorsuch many questions to try to understand his pattern of narrowly interpreting laws meant to protect individual rights or worker safety in ways at odds with the law's purpose. For example, the narrow interpretation Judge Gorsuch took on the Individuals with Disabilities in Education Act, IDEA, would have left For example, the narrow interpretation Judge Gorsuch took on the Individuals with Disabilities in Educational Progress. His interpretation was so at odds with the purpose of the IDEA law that the Supreme Court unanimously rejected and criticized Judge Gorsuch's narrow standard in a case that they decided just a few weeks ago. Time and again, Judge Gorsuch threw up his hands and told us if we disagreed with his narrow reading of the relevant law, that Congress should do better. In his view, the problem was not the court, which he seemed to cast as an innocent bystander, but rather the way Congress had written the law. By tilting the political playing field so heavily towards corporations and unfettered dark money and against individuals, the Roberts Court has impacted the composition of who is in Congress. Fettered dark money and against individuals, the Roberts Court has protect worker safety or the access of students with special needs to an education. In turn, these decisions have made a real-world impact by changing who gets to participate in the political process and therefore who gets elected and who has input on the kinds of laws that are passed and, of course, who gets nominated to the United States Supreme Court. The actions of the Roberts Court and Citizens United in Shelby County make clear the stakes of the Gorsuch nomination. They made clear what the Senate Republicans had in mind in their unprecedented and arrogant refusal to consider President Obama's nomination of Merrick Garland to the Supreme Court. They wanted instead a justice like Judge Gorsuch, who would continue the rightward march of the 5-4 conservative majority on the Roberts Court. And the United States Senate should not allow this brazen gambit to succeed. I urge my colleagues to oppose this nomination. Mr. President, I yield the floor.
Under the previous order, the Senate stands in recess until 10 a.m. tomorrow.
The Senate spent most of the day debating Neil Gorsuch's Supreme Court nomination. They'll gavel in tomorrow morning at 10 Eastern with the vote on limiting debate scheduled for 11 o'clock. That might be followed by votes on invoking what's called the nuclear option that would lower the 60-vote threshold for ending a filibuster. The final confirmation vote on the Gorsuch nomination is expected Friday. Earlier, Senate Majority Leader Mitch McConnell called Democrats' opposition to Gorsuch's nomination partisan, saying they'd filibuster Ruth Bader Ginsburg if Trump nominated her. Here's his remarks on the Senate floor. We'll also hear from Judiciary Committee Chair Chuck Grassley.
Neil Gorsuch is eminently qualified to serve on the Supreme Court. He was confirmed by the Senate to his federal judgeship with no Democratic opposition at all, none. He participated there in more than 2,700 cases, writing in the majority 99% of the time and enjoying unanimous support 97% of the time. He received the highest possible rating from a group the Democratic leader called the gold standard for evaluating judicial nominations, the American Bar Association. He's earned high praise from across the political spectrum, with Democrats and Republicans alike attesting to his qualifications, his fairness, and his impartiality. He also enjoys the support of a bipartisan majority of the Senate. And yet, the Democratic leadership is now determined to block his confirmation with the first successful partisan filibuster of a Supreme Court nominee in American history. They proved that in yesterday's procedural vote. Judge Neil Gorsuch is one of the most impressive nominees we've ever seen. If a widely praised nominee like this can't get past the Democratic filibuster, then no nominee of a Republican president could. Democrats would filibuster Ruth Bader Ginsburg if President Trump nominated her. We all know why. The Democrats are bowing to hard-left special interests that can't get over the results of the election and thus are demanding complete Democratic opposition to everything this president touches. And as the Washington Post just reported, the Democratic leaders seem ready to endorse every argument the activists have made. It seems some Democrats made up their minds long ago to oppose whomever the president nominated. The Democratic leader himself indicated as much before Judge Gorsuch was even selected. He even mused on a liberal talk show about holding the seat open indefinitely. So it doesn't really matter who this president nominates. A Democratic minority is determined to successfully launch an unprecedented partisan filibuster regardless. Perhaps that's why Democrats still have yet to put forward a cogent rationale to oppose him. Not that that would be easy, you understand. As a longtime Democrat and board member of the left-leaning American Constitution Society put it, the Senate should confirm Justice Gorsuch because there is no principal reason to vote no. Well, if there's no principal reason to vote no on this nomination, then there's certainly no principal reason to prevent the Senate from taking a vote on it at all. But that's just what a partisan Democratic minority of the Senate is threatening to do for the first time in nearly 230-year history of the Senate. So let me remind colleagues of something I said yesterday. When President Clinton nominated Justice Ginsburg, I voted to confirm her. When President Clinton nominated Justice Breyer, I voted to confirm her. When President Clinton nominated Justice Breyer, I led my party in working to ensure that they received an up or down vote. In other words, not a filibuster. I knew I would often disagree with their opinions on the court, and I certainly wasn't wrong about that, but I thought it was the right thing to do. I understand that our Democratic colleagues are currently under a great deal of pressure from special interests on the far left. I think everyone in elected office can empathize with the situation they're experiencing. Listening to these hard left special interests may seem like the politically expedient thing for Democrats to do for their party today, but I'd ask them to make their decision based on what they know is right for the country tomorrow. There's still time for them to make the right choice. There's still time for them to support a nominee who even longtime Democrats have praised, or at the very least, to not block him with the first successful partisan filibuster in American history. So I hope Democrats reevaluate their position before the important vote we'll take tomorrow. I hope they'll consider what their actions would mean for future Supreme Court confirmations. I hope they'll consider what their actions could mean for the future of this body more broadly. Because as we all know, the American people will be watching. History will record the decision Democrats make, and there's simply no principal reason to oppose this exceptional Supreme Court nominee.
Mr. President.
The senator from Iowa.
We're continuing to debate the nomination of Judge Gorsuch to serve as Associate Justice of the United States Supreme Court. My colleagues on both sides of the aisle have said that this is an important moment for the United States Senate. I couldn't agree more. I think it's important to reflect on why we're here and how we got here. Before I turn to the Supreme Court and the current debate, let me take just a few minutes to talk about lower court nominees and provide a little bit of history and context, especially for the benefit of some of the senators who weren't here over the last few years. I'm going to start way back in the spring of 2001. President George W. Bush had just been elected president. As we know, we all know, in fact, it was a close election, and it was hardly fought. The Senate was closely divided, with the Republicans in control. Given how close the presidential election was, there were elements of the hard left who refused to accept the results of that election. Some blamed Ralph Nader, others blamed Governor Jeb Bush, and still others blamed the Supreme Court. Many on the hard left, Bush, and still others, blamed the Supreme Court. Many on the hard left claimed that President George W. Bush wasn't, quote unquote, leadership to fight the new president at every turn. Now, that still sounds very familiar for this year that we're in. At the same time, one major concern for the hard left, liberal interest groups, was that President Bush, whom they claimed wasn't legitimate, would be able to nominate conservative judges. Again, doesn't that sound familiar? Senator Cornyn went over some of this same subject yesterday, but it deserves discussion now, and it deserves as a reminder where we've been before, because sometimes the past predicts the future. So in the spring 2001, the hard left interest groups went to the Senate Democratic leadership with a plan. According to the New York Times, 42 of the Senate, and this is a quotation, 42 of the Senate's 50 Democrats attended a private retreat where a principal topic was forging a unified party strategy to combat the White House on judicial nominees, end quote. Thinking about 2017, doesn't that sound a little familiar? At that meeting, Cass Sunstein, Marsha Greenberger, and Lawrence Tribe spoke at the retreat and pitched to the Democrats present there their idea of how this crusade could proceed. One to attend, I quote, according to one attendee, and I want to quote, they said it was important for the Senate to change the ground rules, and they're important for the Senate to change the ground rules, early and erudite, end of quote. Well, let's think about that for a moment. Why do you suppose they believe they needed to change the ground rules for confirming judges? It's because up to that point, you didn't filibuster judges. You just didn't. And you heard the minority or the majority leader just speak to that point in his short remarks this morning about how things have changed after more than 200 years. Well, as it happened, less than a month after the caucus retreat, Senator Jeffords from Vermont switched parties and began caucusing with the Democrats. That threw the majority to the Democrats for the next 18 months. And then they lost the election of 2002, and in the spring of 2003, Republicans were back in the majority. Now back in the minority, Senate Democrats went ahead with plans that were enunciated at that retreat to change the ground rules. For the first time in the history of the Senate, they began to systematically filibuster circuit court nominees. Not because they believed the nominees weren't qualified, because these nominees were qualified. Not because they believed those nominees didn't have the necessary experience, because these nominees did have the necessary experience. They filibustered those nominees because they believed that they were conservative judges. So with respect to appellate court nominees, Senate Democrats, at the behest of the far left, took the unprecedented step of using the filibuster in a very systematic way for the first time in Senate history. At the time, there was a lot of debate about changing the rules, dubbed the so-called nuclear option, so that nominees would be afforded an up or down vote consistent with Senate history and practice. Well, Republicans exercised restraint and agreed to step back. Then President Obama became president. Our side didn't like the use of the filibuster for judges, but we also didn't think there should be two sets of rules, one for a Republican president and one for a Democratic president. Common sense tells you that that's a legitimate position to take. We defeated two circuit court nominees, one to the Ninth Circuit and one to the D.C. Circuit. Then President Obama nominated three individuals to the D.C. Circuit. One side denied cloture. Our side denied cloture on these three nominees to the D.C. Circuit. Well, at that point, their side didn't like playing by the rules that they wrote. So Majority Leader Reid, then Majority Leader Reid, the rules that they wrote. So Majority Leader Reid, then Majority Leader, the so-called nuclear option to eliminate the very tactics that they pioneered. So nuclear option becomes effective, the very tactics that they pioneered. So nuclear option become lower court nominees and later eliminated. Senate Democrats took the unprecedented step to utilize that. And then when it no longer benefited them, they used unprecedented means to eliminate it. So this brings me back to where we are today and the rest of this week, to talking about a Supreme Court nominee, Judge Gorsuch. Everyone knows that we had a big debate last year about whether to proceed with a Garland nomination. And tradition and not proceed with a nomination in the middle of a heated election year. And I know it frustrates my colleagues to hear me say it, but the fact of the matter is that in 1992, when then Senator Biden was chairman of the Judiciary Committee, he announced that he wouldn't hold a hearing to fill a vacancy in the last year of President Bush's term. So last year, we followed the precedent that then Senator Biden described in 1992 for all of the same reasons he discussed. And you get back to this common sense principle. Can you have one rule for Republican presidents and another rule for Democratic presidents? We didn't feel you could. And of course, everyone in this chamber knows that if the shoes were on the other foot, the Democrats would have done the same thing because they said they would. In fact, President Obama's former White House counsel admitted as much. She said she would have recommended the same course of action if the tables were turned. So now, here we are, April 2017, with a nominee before us. Just like in 2001, we had just had a very contentious presidential election. It was close. It was hard fought. And frankly, some on the hard left refused to accept the results of the election. Once again, left-wing groups are egging on the minority leader to take another unprecedented step with respect to judicial nominations. Only this time, they want him to lead the very first partisan filibuster of a Supreme Court nomination in United States history. And based on the vote we had yesterday, it appears that 44 Democrats are prepared to follow the minority leader on this fool's errand. No Supreme Court nomination in our country's entire history has ever failed because of a partisan filibuster. There's no getting around that fact. Abe Fortas, they might refer to, was subjected to a bipartisan filibuster over ethical concerns when President Johnson tried to elevate him to be Chief Justice. Now, Justice Thomas was confirmed by a vote of 52 to 48. I was here for that nomination. A single senator, any senator, could have demanded a cloture vote. But out of 100 senators, none did that. Why? For a simple common sense fact and 200 years of history. You don't filibuster Supreme Court nominations. But today is entirely different. The minority is committed to filibustering this fine nominee, the first partisan filibuster in U.S. history. So here we are. The president has nominated an exceptionally qualified judge to take Judge Scalia's seat on the Supreme Court. And the Democrats will break new ground again by conducting a partisan filibuster of that nominee. Republicans aren't the ones breaking new ground here. As a matter of fact, the Democrats' own vice presidential nominee last year emphatically promised that the Democrats would further change the rules to make sure and expected President Clinton's nominees couldn't be filibustered. So at the end of the day, the fact is that if Democrats insist on a filibuster, Republicans will insist on following the practice that senators have followed for more than 200 years, and that is not to filibuster, have a partisan filibuster for somebody going to the Supreme Court nominees. And we're certainly not going to start with this highly qualified nominee. And I hope those that think back 16, 17 years when this meeting of Democrats in retreat came to the conclusion you had to break new ground, that they realize that that has poisoned the well of the comity traditional of the United States Senate. And I think maybe a lot of them realize that was a mistake, as we realize that that's a mistake. And it'd be nice to get back to the comity of the Senate that existed on judges prior to 15 or 16 years ago. But that's going to take people on their side who were present at that same retreat, who are still in the United States Senate, to drill a new well, because the present one is poisoned. And we need to get back to the comity that we've had. I yield the...
Now, Mr. President, as each hour brings us closer to the cloture vote on the nomination of Judge Neil Gorsuch to the Supreme Court and a potential rules change if that vote fails, I rise this afternoon to entreat my friend, the Majority Leader, to step back from the brink. As I and so many other of my colleagues have made clear, we Democrats have principled reasons to vote against this nominee on tomorrow's cloture vote. Second, he hasn't shown a scintilla of independence from President Trump. And third, Judge Gorsuch, based on his record and history, has a deeply held, far-right, special interest judicial philosophy that is far out of the mainstream. He was selected off a list developed by the very hard-right special interest Heritage Foundation and Federalist Society. The Washington Post, after analyzing his decisions on the 10th Circuit, concluded that Judge Gorsuch may be the most hard conservative justice on the bench, to the right of even Justice Thomas. It may be abstract to many Americans, but Judge Gorsuch's judicial philosophy matters a great deal. It'll affect dozens of decisions and decades of jurisprudence that could have far-reaching consequences on the lives of average Americans. As Emily Bazelon in the New York Times put it, the reality is that Judge Gorsuch embraces a judicial philosophy that would do nothing less than undermine the structure of modern government, including the rules that keep our water clean, regulate our financial markets, and protect workers and consumers. If that philosophy becomes the majority view on the Supreme Court, average Americans are in big, big trouble. The prospect concerns almost every Democrat here in this body, enough to prevent cloture on Judge Gorsuch's nomination tomorrow. This leaves the majority leader and my Republican friends with a choice: break the rules of the Senate or sit down with we Democrats and the President to come up with a mainstream nominee who can earn bipartisan support to pass the Senate, enough bipartisan support to pass the Senate. We Democrats believe the answer isn't to change the rules, it's to change the nominee, as presidents of both parties have done when a nominee fails to earn confirmation. Instead, my Republican friends seem intent on breaking the rules for Judge Gorsuch and are trying to find reasons to justify it. The truth is, each side can blame the other. We believe they're more in the wrong. They believe we're more in the wrong. The game of pointing fingers, and they started it, can go back and back and back to the very founding of the Republic. If my Republican friends think they have to change the rules because this blame game has gotten so far out of hand that Democrats will never pass a Republican-nominated Supreme Court justice, I'd remind them of Justices Alito and Roberts, two conservatives who nonetheless passed the Senate having met a 60-vote bar. That was during a pretty contentious time as well. If my Republican friends think that what we Democrats did in 2013 was so wrong, and that's reason to break the rules, I'd remind them the only reason we changed the rules was because the Republican minority in the Senate had forced cloture petitions to be filed on more nominees under President Obama's first 5 years than in all the 225 years before him combined. They filed more cloture petitions against President Obama's nominees than all the cloture petitions filed from George Washington through George W. Bush. When Democrats changed the rules, however, we purposefully left the 60-vote bar for the Supreme Court intact because we knew, as the Republicans know, that the Supreme Court is different. Justices on the court don't simply apply precedents of a higher court. They set the precedents. That's why justices should be mainstream enough to garner substantial bipartisan support. If the majority leader breaks the rules tomorrow, and that's his choice, he would be forever unwinding that important principle, erasing the last shred of bipartisanship in the Senate confirmation process. If my Republican friends think a filibuster on Judge Gorsuch is so wrong that they have cause to break the rules, I'd remind them that almost every one of them lined up behind the majority leader when he vowed, mere hours after the death of Justice Scalia, that President Obama would not get to fill a Supreme Court seat despite 11 months left in his presidency. That was much worse than a filibuster. Even my friend, the Republican senator from Tennessee, called it audacious. But I think Representative Adam Schiff of California said it best. Quote, when McConnell deprived President Obama of a vote on Garland, it was a nuclear option. The rest is fallout. The fact of the matter is the Republicans blocked Merrick Garland using the most unprecedented of maneuvers. Now we are likely to block Judge Gorsuch because we're insisting on a bar of 60 votes. We think a 60-vote bar is far more in keeping with tradition than what Republicans did to Merrick Garland. The majority leader himself has stipulated, this is his quote, Mitch McConnell's quote, in the Senate, it takes 60 votes on controversial matters. On the other hand, there is absolutely no precedent, rule, tradition, or custom that can justify what the Republicans did to Merrick Garland. None. The two are not equivalent. Over the long history of partisan combat over judicial nominations, of course, there is blame on both sides. We don't believe the blame should be equally shared between Republicans and Democrats. The Republican Party has been far more aggressive in employing new tactics and escalating old ones to fight the nominees of a president of the opposing party. The Republican Party has been far more aggressive in their selection of judicial candidates, picking judges who have an ideology closer to the conservative extremes of American politics, while Democrats have tended to select candidates closer to the center. Keep this in mind. The last time a Republican-controlled Senate confirmed the Supreme Court nomination of a Democratic president was 1895. Let me repeat that amazing fact. The last time a Republican-controlled Senate confirmed the Supreme Court nomination of a Democratic president was 1895. So, Mr. President, we can argue endlessly about where and with whom this all started. Was it the Bork nomination, which received a vote in the Democratic Senate, by the way? Or was it the obstruction of judges under President Clinton? Was it when Democrats blocked a few judges under President Bush? Or when Republicans forced Democrats to file more cloture petitions in 5 years of President Obama's presidency than during all other presidencies combined? Was it Judge Garland or Judge Gorsuch? Wherever we place the starting point of this long twilight battle over the judiciary, we're now approaching its end point. We are nearing the final hour, and the stakes are considerable. After the cloture vote on Judge Gorsuch, Democrats will have been denied Merrick Garland due to tactics we felt were unfair, and Republicans will have been denied Judge Gorsuch because of tactics they think are unfair. Our two parties have traded bitter blows. In the tortured history of the Scalia vacancy, the debate has been saturated with contradictions. But in a very real sense, even though each side thinks their side is more right than the other, neither side is happy with how we got here. And now we are standing on the brink of an irrevocable with how we got here. And now we are standing on the brink. Changing the rules is a bell that's very hard to unring. As the clock ticks steadily towards tomorrow, what are we going to do? I, for one, would like to see us step back from the brink. As a Democratic leader, I still hope I can sit down with the Republican leader and find a way out of this pernicious cycle. I believe that, as leaders of our respective caucuses, it is at least up to us to try, for the sake of the Senate. The Republican leader and I disagree on a great many things, but we agree upon the importance of the Senate in American life. We can decide today to commit to solving this problem. Each side can stop pointing fingers. Each side can lay down their arms. Each side can put aside the resentments built up after years of trench warfare on nominees. We can decide today to talk about a way out of this impasse instead of changing the rules. We've both lost Supreme Court nominees. We shouldn't also lose a long-standing rule of the Senate that encourages our two parties to work together to fulfill one of the Senate's most important functions. So the option to sit down with us Democrats and talk about a new nominee that can gain sufficient bipartisan support remains on the table right now. I hope my friend, the Republican leader, thinks about where we're headed and takes a moment to let reason and prudence prevail over rancor and haste. Just as the majority leader holds the power to exercise the nuclear option, he also has the power to avoid it. If the majority leader is willing to cooperate in a bipartisan way, if he's willing to sit down with us in good faith and try to find a way out, he will find an open door and an open mind. And maybe we can, for the moment, avoid an outcome that no senator from either side wants to see. I yield the floor.
Tomorrow, Politico talks to House Freedom Caucus Chairman Mark Meadows and caucus members Jim Jordan and Justin Amash. Watch it live at 8:20 a.m. Eastern Time here on C-SPAN 2 and cspan.org. And listen live with the C-SPAN radio app.
Sunday night on Q&A.
And so here was a yellow pad where Haldeman writes down, in the midst of the October 1968, we're going to monkey wrench Lyndon Johnson's peace initiative. Now, this is something that had always been rumored, and bits of pieces had come out over the years, but Nixon denied it at the time to Lyndon Johnson, and he denied it to David Frost, and he denied it to his biographers. Always said that he had never played any role in doing this.
John Farrell, longtime journalist and author of the book Richard Nixon, The Life, on Mr. Nixon's political career, from his early days in Congress to his tenure and downfall as president.
The way that the Watergate burglars their team was assembled was clumsy. They were cynical, burnt out former intelligence or FBI agents who were supervised by young men on Nixon's staff who just wanted to be, as one of the famous quotes go, the cat that brought the dead mouse to the president's door.
Sunday night at 8 Eastern on C-SPAN's Q&A. Check out our C-SPAN Classroom website at cspan.org/classroom. It's full of free teaching resources for C-SPAN Classroom members. The improved layout gives teachers easy access to ready-to-go resources for the classroom, including short current events videos that highlight important events in Washington, D.C., Constitution clips that bring the Constitution to life, social studies lesson plans, as well as On This Day in History resources. Our search function allows C-SPAN Classroom teachers to search and filter by date, person, keyword, topic, and grade level. Our Bell Ringers video clips are teacher favorites. They're short videos paired with vocabulary and discussion questions that make the federal government and politics more accessible to your students.
I love the bell ringers. A lot of times I don't use them as actual bell ringers, but I'll use them in conjunction with an activity that we're doing that day as more of like a wrap-up.
The new website is something that is just fabulous. My students use it regularly, and it's so easy, in fact, that they are right now working on clipping videos and making questions that they can design and turn into their own bell ringers.
Probably my favorite aspect of C-SPAN Classroom is the deliberations page. It's just a perfectly set up, ready to go classroom deliberation, classroom discussion on just a variety of topics that are current and relevant today.
If you're a middle school or high school teacher, join thousands of your fellow teachers across the nation as a member of C-SPAN Classroom. It's free and it's easy to register at cspan.org/classroom. And if you register now, you can request our free classroom-size American Presidents Timeline poster, a graphic display of the biographies of all 45 presidents. Find out more about it at cspan.org/classroom.
The Senate will return at 10 a.m. Eastern Time to continue debate on the Gorsuch Supreme Court nomination and is expected to have a vote to limit debate at 11 Eastern. Here's some more of Wednesday's Senate debate on Neil Gorsuch. It begins with Maryland Democrat Ben Cardin.
Senator from Maryland.
Mr. President, I take this time to explain to the people of Maryland and our nation my views on Judge Neil Gorsuch to be an associate judge of the Supreme Court of the United States. Madam President, I might tell you there is no more important responsibility that a member of Senate has than the advice and consent of an associate justice of the Supreme Court of the United States. There are many important responsibilities we have. This is one of the most important responsibilities, and I have taken this on to try to understand as much as I can about Judge Gorsuch to understand the dynamics of what his membership of the Supreme Court would mean, because I recognize it's not just an appointment for this term of Congress. This is a lifetime appointment, and it's very possible that he, if confirmed, will serve on the Supreme Court for a generation. So his impact on the workings of the Supreme Court is something that is extremely important to each member of the Senate. I think many of us are looking for an associate justice who can bring about more consensus on the Supreme Court, who can try to deal with some of the great divisions in our nation in a way representing the values of our Constitution that will allow our nation to move forward in a united way. We also recognize that the Senate must give an independent evaluation of a Supreme Court justice. This is not because a president of your party nominated someone to the Supreme Court, whether you would support or oppose. It's the independent review process that each senator undertakes to determine whether the nominee should get our support. So what I look at is someone who would be a mainstream jurist, who's sensitive to the civil rights of all Americans, that would understand the importance of our Constitution, which has been a Constitution which has expanded rights and not one that we would look at ways to move in the wrong direction on extending constitutional protections, that is, to move backwards rather than forwards. So, Madam President, first let me start by saying I am troubled by the process that President Trump followed in nominating Neil Gorsuch to the Supreme Court. During his campaign, he talked about a litmus test for Supreme Court justices, that they must be pro-life in the mold of Justice Scalia. The list that was submitted to him, and which Judge Gorsuch was part of, was proposed by the Heritage Foundation and the Federalist Society. That's not a good way to start a process of bringing in a consensus nominee to the Supreme Court of the United States. To my knowledge, there was no consultation with any Democrats prior to the nomination being made. And the reason why consultation with all members of the Senate are important is that if you engage in real understanding as to what the Senate, which we represent the entire country, is looking for in a Supreme Court justice, you have a much better chance of ending up with a nominee who's going to enjoy broader support, bipartisan support, real bipartisan support in the United States Senate. And then the 60-vote threshold does not become a hurdle. There's a reason why we have the rules we do in the Senate. And the 60-vote concept on a controversial nominee is so that we don't end up with an extreme candidate that would end up being on the Supreme Court of the United States, that there must be that process that would generate 60 votes. So despite my concern about the process that was initiated by President Trump in the nomination, I have tried to look at all of the opportunities to understand Judge Gorsuch's record and his likely actions as a member of the Supreme Court. I took the time to meet with Judge Gorsuch, and I found that interview, that process, to be extremely helpful in understanding his judicial philosophy. I monitored the hearings that took place in the Senate Judiciary Committee, and I found that testimony to be helpful. I reviewed the testimony of experts that have submitted both verbal and written comments in regards to Judge Gorsuch. And, Madam President, I have reviewed his extensive legal record, and we do have an extensive legal record that I'm going to comment about that went into my own process in determining whether I can support him or not. I came to the conclusion that I could not support Judge Gorsuch for an Associate Justice on the Supreme Court of the United States because he was not a mainstream candidate. To me, I am concerned that he would put corporate interest before individual rights. And to me, the strength of our Constitution is in the individual. Individual rights should be paramount to special interest or corporate interest. I saw in his legal opinions a hostility towards environmental, women's health, marginalized students with disabilities, and others, vulnerable type of individuals, that have me greatly concerned. I was particularly concerned about whether he could separate his political views from his legal views. Madam President, to me, this is an extremely important point. We want our judges on the Supreme Court, justices on the Supreme Court, not to be influenced by the politics around us. Legislative branch, that's perfectly legitimate for us to take into consideration political views. The President of the United States is nominated by a political party. That's understood. But the Supreme Court, the justices on the Supreme Court, need to leave their political views outside of their responsibilities. And I was deeply troubled after reading the opinions of Justice Gorsuch and his writings that he would not be able to separate his political views from his legal views. And I was concerned about whether he would truly be an independent check on the presidency. We know that President Trump is testing the constitutional reach of his office. We've seen that in some of the executive orders that he's issued. And I have little confidence by his responses at the hearings that Judge Gorsuch would be an independent voice towards the President of the United States. So let me cite some examples to fill in the blanks on what I am saying. Judge Gorsuch challenges the Chevron deference doctrine. In the Gutierrez case, he indicates that judges rather than agencies should be basically administering our laws. The long-standing deference to agencies to interpret our law has been allowed agencies to carry out their mission. Without that authority, it's extremely challenging to see how an agency can carry out the missions of agencies to carry out their mission. Without that authority, it's extremely challenging is still relevant. Now, let me make it clear. Who benefits from the Chevron doctrine? The Chevron doctrine has allowed agencies to protect workers' rights, to protect our environment, protect consumers, food safety, and the list goes on and on and on. In each of our states, we have many examples to show how important the Chevron deference doctrine has been. In my state of Maryland, the Chesapeake Bay, which is critically important to Maryland's economy, critically important to the character of the state that we have in Maryland and our future, the protection of the public health of the Chesapeake Bay has very much been advanced by the Chevron deference doctrine. Judge Gorsuch wrote, quote, Chevron appears to qualify as a violation of the separation of powers. And then he argued that its primary rationale is no more than a fiction. Well, Madam President, when you look at what he has said about a fundamental document that's there to protect our environment, protect workers, protect public health, versus what Justice Scalia once explained, and I quote from Justice Scalia, in the long run, Chevron will endure and be given its full scope because it more accurately reflects the reality of government and thus more adequately serves its needs. In the Gutierrez case, Judge Gorsuch was showing a more activist conservative agenda than Justice Scalia. Let me move on to Citizens United. We've talked about Citizens United probably more than any case of the Supreme Court on the floor of the United States Senate. We all know it's a 5-4 Supreme Court decision. We know it opened up the floodgates for dark money, allowing corporations to have constitutional rights, which we thought were only individual. In the Riddle case, Judge Gorsuch announced a strict scrutiny standard to political contribution limits. That, quite frankly, would make the Citizens United's case even worse and would gut campaign finance law limits. I think each of us should be concerned about that decision. Let me move on to the Trans-American Trucking case. Here, Judge Gorsuch was in dissent. He was in the minority. And what he basically said is that a truck driver had to sacrifice his life in order to protect his job, otherwise he could be fired. And what I mean by that, as I think many of our colleagues know, but let me say for those who may not be totally familiar, the truck driver found himself abandoned because the brakes of his trailer were frozen in sub-zero temperature. He contacted his dispatcher for help, and after several hours, recognized that his life was in danger because of hypothermia. He did not have adequate heat in his cab. He had one of three choices. He could try to maneuver the cab and the trailer with frozen brakes, maybe costing himself his life or other people on the road. He could remain as he was instructed by the dispatcher and perhaps freeze to death, or he could do what I think any reasonable person would do. He disconnected the cab, took care of making sure that he was safe, warmed himself up, returned to the trailer in order to complete the mission. For that, he was fired, and Judge Gorsuch said that was acceptable. That's an extreme opinion, Madam President, and one in which gives us great pause as to how Judge Gorsuch will act on the Supreme Court of the United States. Let me talk about the NLRB versus Community Health Services, where Judge Gorsuch again was in the dissent. It had to do with back pay for workers, and in this opinion, he shows real hostility to workers and unions, something that has me greatly concerned. Another case that has received a great deal of publicity in this body is Hobby Lobby, and I raise it for one principal reason. Here, what the court was saying, and Judge Gorsuch was agreeing with, that the religious protection that's provided under the Constitution, that it's more important for a company to be able to exercise that religious freedom than the employees. Once again, one of my principal concerns is whether Judge Gorsuch will protect the rights of individuals or whether he will side on behalf of business. Clearly, in the Hobby Lobby case, he decided on business to the detriment of women's rights, the LGBT community, and others. In the Planned Parenthood Utah case, he showed a direct hostility to Planned Parenthood. Quite frankly, Madam President, this case is very difficult to understand because Judge Gorsuch would have allowed the governor to cut off funds even though the case had been settled and the parties had not asked to have the case retried. We talk about activism, and we don't want to see activist judges. To me, that demonstrated that Judge Gorsuch indeed will be an activist judge in trying to move a particular political agenda. And then in the Andrew versus Douglas County School District, a case that came in during the confirmation hearing process, we had a severely autistic child, and Judge Gorsuch was responsible for the absurd. We had a severely autistic child, and Judge Gorsuch was responsible for the Supreme Court rightly rejected that logic by an 8-0 decision. Judge Roberts, writing the opinion about the IDEA law, that there are protections for disabled students in our school system. Judge Gorsuch would turn back the progress that we've made on civil rights and on constitutional protection. Madam President, as I mentioned earlier, I am very concerned about whether Judge Gorsuch can keep his political views separate from what he says, how he acts as potential justice on the. American liberals have become addicted to the courtroom, relying on judges and lawyers rather than elected leaders and the ballot box as the primary means of affecting their social agenda. This overweening addiction to the courtroom as the place to debate social policy is bad for the country and bad for the judiciary. I mention that particular case, and I quote Judge Gorsuch, because we don't want a judge to side with either being a liberal or conservative. We don't want a judge to say, I have a responsibility to promote an agenda as a judge. We don't want a judge to be able to take a political view and bring that onto the bench. Whether it's a person who we agree with politically or disagree with politically, we want to have an independent judiciary. This National Review article causes me grave concern as to whether Judge Gorsuch can in fact be that neutral person on the court. Judge Gorsuch appears to be an activist judge, would become an activist judge, turning back progress to protect individual constitutional rights. That's something that gives me grave concern, and the reason why I could not support his nominee to be an Associate Justice of the Supreme Court. So let me turn to process for one moment, because it looks like sometime tomorrow we're going to be called upon to vote on a cloture motion. And I want to comment about that, if I might. As I said earlier, Judge Gorsuch to me is not mainstream. He'll put corporate interests above individual interests. He shows a hostility towards environment, women's health, etc. He has political views that I think he would not be able to differentiate, and he would not be an independent check and balance in our political system. So for all those reasons, it seems appropriate to me that this is why we have a 60-vote threshold, to make sure that we don't take extreme nominees and allow them to be confirmed by a partisan vote, that we want to have a broader consensus. And Judge Gorsuch did not earn that broader consensus. But there are additional considerations here. And this goes back a few years, Madam President, but the Republican leadership, what they did to President Obama's judicial nominations must be underscored, because this is not in vacuum. We didn't get to this place in vacuum from what has happened already. But going back to President in vacuum, we didn't get to this place in vacuum from what has happened already. But going back, requiring a record number of cloture motions to have been filed and acted upon, a record number. We had more, I understand, more cloture, more filibusters of President Obama's nominees by Republicans than we did in the entire history of the United States Senate. So there's been a direct effort by the Republican leadership to filibuster judicial nominees. That's wrong. It shouldn't have been done. Yes, there are reasons for some, but not for the record numbers that were done. You should be able to allow for the comedy. And quite frankly, in 2013, the Republican leader told President Obama, no more district court circuit judges. Let me repeat that. In 2013, this is the first year of the president's term. He said, no more, the Republican leader, no more D.C. circuit judges. We had 3 vacancies in the D.C. circuit. 8 of the 11 had been filled, 3 were vacant. And it had nothing to do with the nominees. They just said they weren't going to consider any of them and used the filibuster to block any filling of this position. Now, I'm going to quote first from Chief Judge Henry Edwards when he talked about the D.C. circuit. It said, review of a large, multi-party, difficult administrative appeals is the staple of judicial work in the D.C. Circuit. This long distinguishes the work of the D.C. Circuit from the work of other circuits. It also explains why it is impossible to compare the work of the D.C. Circuit with other circuits by simply referring to raw data of case filings. Chief Justice Roberts noted about 2/3 of the cases before the D.C. Circuit involved the federal government in some civil capacity, while that figure is less than 25% nationwide. He also described the D.C. Circuit's unique character as a court with special responsibility to review legal challenges to the conduct of the national government. My point is clear. This is the second most important court in our land. And in the first year of President Obama's term, the Republicans announced that they would filibuster any attempt to put any judge on this circuit. And then we had the ultimate filibuster by the Republicans, and that was Merrick Garland. February 2016, with Justice Scalia's death, a nominee submitted to us by President Obama, acknowledged to be mainstream, acknowledged to be well qualified, acknowledged to be a consensus nominee, and he got the ultimate filibuster. Most members of the Republicans in the Senate wouldn't meet with him. He didn't have a committee hearing, didn't have a committee vote, didn't have a floor vote. that was the ultimate filibuster. It was wrong, particularly when we know that he would have received 60 votes. So you can't compare Judge Gorsuch with Judge Garland, because unlike Judge Garland, Judge Gorsuch does not share the same evaluation of being able to be a consensus mainstream candidate who would receive a 60-vote threshold. So for all these reasons, if the majority leader is going to pursue the cloture vote on the Gorsuch nomination, I will not vote in favor of cloture. I would hope that we would be able to return to the comity that is important in the United States Senate, but we recognize there are times where you should have a 60-vote threshold when the President of the United States goes outside of the norms in a process that has already been employed by the Republicans. I would urge my colleagues to rethink the course that we're on. With that, Madam President, I would yield the floor.
Madam President.
Senator from Hawaii.
Madam President, when our country was founded, corporations were on the minds of no one. They aren't mentioned in the Constitution or the Bill of Rights. And when the topic finally came up to the Supreme Court, Chief Justice John Marshall called corporations the mere creature of the law. People have certain inalienable rights. Corporations do not. We established corporate personhood so that companies could raise capital and enter into contracts. But nobody ever thought that this term that was used, personhood, actually meant that corporations were people. They are not. It's not complicated. Corporations don't eat, they don't sleep, they don't worry about their children or their elderly parents, they don't get sick, they don't retire, and they don't have complex motivations. In fact, under the law, they only have one motivation, which is to maximize profits. Any logical person knows that corporations are not people, but in Judge Gorsuch's America, they are. Now, there's no doubt that he's a very smart person, but he actually had a hand in creating this theory that corporations have the same rights as human beings, that they are in fact people. And we're supposed to pretend that this premise isn't insane, but it is crazy, and it's hurting our democracy. For the past several decades, we have increasingly limited people's rights in favor of corporate rights. And now Republicans want us to confirm a judge who says that corporations have religious rights. Judge Gorsuch was a part of the Hobby Lobby decision that went before the Supreme Court, in which the 10th Circuit decided that corporate personhood extends to First Amendment religious rights. And because the corporation, not just the people who owned it, the corporation itself has been granted those rights by judges like Neil Gorsuch, the rights of corporations now usurp the health and the rights of American citizens. And that's the problem with Judge Gorsuch's worldview. It's not just that he's a conservative, it's that he actually thinks that corporate entities have the very same rights as American citizens. Rights, by the way, that don't come with the same responsibilities that we all have as American citizens. But this judge wants to confer more rights onto corporations, and we're already past the tipping point as a society where corporations have more power than people. We're in this absurd position of asking, how far are these corporate rights going to extend? They've been given First Amendment rights. They've been given Fourth Amendment rights. Do they get the right to vote next? Do they get the right to keep and bear arms? How many more constitutional rights are we going to give to corporations before we say enough is enough? Because we are already well beyond the point where corporate interests beat out the individual, whether it's at the polls or in the workplace. There are a lot of other things about Judge Gorsuch's worldview that I object to, but at my core, I think I might be able to get around some of those things, knowing that the Constitution requires the Senate advise and consent, not agree with. But his worldview regarding corporations as people embodies everything that's going wrong with our country and with the court. And by the way, it's probably fair to say that almost every nominee that we've seen this year embodies this worldview. Time and time again, Democrats in the Senate have raised the alarm about this administration's nominees, and we've been overruled. And what's the result? You have cabinet secretaries destroying American diplomacy. You have secretaries trying to ban Muslims from entering the United States. You have an EPA administrator, Scott Pruitt, leaving a dangerous product on the market that has been proven by his own scientists to hurt children. And why? Because they prioritize corporate rights over people's rights. But the problem is this: cabinet secretaries come and go. Supreme Court justices do not. Let me put it this way. This administration's cabinet is like a date. It's a really bad date, but at least it comes to an end. A Supreme Court justice, on the other hand, that's not a bad date. That's a marriage. It's a lifetime appointment that will have an impact on generations of Americans. And that's why the fact that he is out of the mainstream is absolutely essential for us to consider. The fact that he thinks corporations are people is, in my mind, disqualifying. So disqualifying that I will vote no on cloture, and I will vote no on final confirmation if it comes to that. Which brings me to the question of cloture. When the Senate votes on cloture, the question before the Senate is it the sense of the Senate that debate should be brought to a close? Is it the sense of the Senate that debate should be brought to a close? And for the Supreme Court nominee, we have rules. And those rules say that you need 60 senators to end debate. Not 59, not 51, not 57. 59 senators don't get to decide when to end debate. 60 do. And if you can't get 60 votes to end debate, you don't have cloture. And now, after 2013, there is only one position, one appointed position, that retains that 60-vote threshold, and that is the United States Supreme Court. And that is for a very straightforward reason. It's that we have decided as a body that the Supreme Court needs to have bipartisan support. That if a person cannot get 60 votes, that you change the nominee. You do not change the rules. We have decided that this position, that this institution, the court itself, the highest court in the land, should be beyond our partisan disputes and differences. And that is the foundation of the United States Senate. It's the way this place works. Without this rule, the reality will be grim. Without this rule, if you're a member of the minority party, the president's nominees don't have to listen to you, meet with you, think about you. Without this rule, advice and consent is rendered meaningless for whichever party is out of power. And everybody ought to remember, I've been here now 5 years, a little over about 4.5 years. And even in my short time here, the door swings both ways in Washington. Remember that today, this week, for the Republicans, it might feel satisfying to use power maximally, to use the greatest authority possible under the United States Constitution. But without this rule, the Senate itself will be undermined by its own members. I've never seen any legislative body endeavor to diminish its own authority, and that is what is going to happen this week. Now, we can argue about how we got here. Was it in 1987 when the Senate rejected Robert Bork? Was it in 2013 when Leader Reid responded to historic obstructionism by eliminating most filibusters on nominees? Was it last year when Merrick Garland was not even given a hearing? Well, we all have our talking points. But at the end of the day, both sides own some of this mess. Now, I'm a Democrat. I think it's 80-20. Republicans will think it's 80-20 on the other side. The general public may think it's 60-40 or 50-50. I'm not sure that matters anymore. The question of who's at fault is not the most important question. The question is, what do we do next? Will the Senate undermine its own authority and strengthen the power of partisanship? So I would say this to my Republican colleagues: think about what you are going to do next. Think about what this is going to mean the next time you're in the minority party, because it will not be Senators Duckworth and Cortez Masto, who can't even get a meeting with a Supreme Court nominee, it will be you. This is about the future of the Senate and the Supreme Court. The nuclear option will mean nominees for the Supreme Court will not have to meet with or consider minority opinions. It will mean that the Senate's habit of being slow, sometimes maddeningly so, but we know in the best interest of the country, will go away for this appointment. That tradition allows the center to hold, and it will be undermined. So to my Republican colleagues, I'm not asking you not to do this. I am asking you to take your time. In the world's greatest deliberative body, there is no reason to rush this decision. I'm asking you to wait. I'm asking you to take a few weeks before you decide to change the Senate forever. Take your time. This is probably one of the most consequential decisions you're going to make in the United States Senate because it is about the Senate itself. Because this is worth talking about, this is worth deliberating over, it's worth thinking over. So go home, talk to your constituents. If you want to do this, you can do this anytime you want. You can do this the Monday we get back from our spring work period. But for goodness sake, there is no reason not to think about it for a little bit longer. All we need are 3 members of the Republican Party to go to their leader, publicly or privately, and say, we're not with you on nuclear yet. Give us some time to try to save this important aspect of the Senate. Because otherwise, you will make both the Supreme Court and the world's greatest deliberative body more extreme and more divided. And I believe you will regret it. I yield the floor.
Madam President.
Senator from Massachusetts.
Thank you, Madam President. Madam President, I rise to speak in opposition to the nomination of Judge Neil Gorsuch to serve as an Associate Justice of the United States Supreme Court. Let me begin by making clear my view that the vacancy on the Supreme Court created by the death of Justice Antonin Scalia was President Obama's to fill. But in an act of unprecedented obstructionism that makes a filibuster pale in comparison, Senate Republicans broke with longstanding Senate tradition and refused to hold a vote or even a hearing on President Obama's nominee, Judge Merrick Garland. As we now consider President Trump's nominee, Judge Neil Gorsuch, we cannot ignore or forget this hyper-partisan action. We also cannot ignore how Judge Trump came to nominate Judge Gorsuch. President Trump went to 2 of the most partisan conservative organizations which he could find. The Koch brothers-supported Heritage Foundation and the right-wing Federalist Society, and said to them, who do you want on the Supreme Court? And they compiled their dream team of 21 ultra-conservative candidates. President Trump looked at the names on that list and asked himself which judge could pass the right-wing litmus test he had articulated during the campaign. His choice was Judge Neil Gorsuch. On the campaign trail, candidate Donald Trump made clear that he was pro-life and would appoint pro-life judges to the Supreme Court. In one interview, he was asked about his pro-life position as follows. Here's the question posed to him. So, how important is that issue to you now? When President Trump picks the Supreme Court justices, would there be a litmus test? Trump responded, quote, it is. During the second presidential debate, candidate Trump doubled down on this issue. He was asked specifically about Roe versus Wade, the long-standing Supreme Court precedent establishing a woman's right to choose. The question to candidate Trump was, quote, do you want the court, including the justices that you will name, to overturn Roe versus Wade? Trump responded that he would, quote, be appointing pro-life judges, adding, well, if we put another 2 or perhaps 3 justices on, that will happen, meaning Roe versus Wade will be overturned. So we know from Donald Trump's own words that he had a litmus test for Supreme Court nominees on a woman's right to choose. And that litmus test is that he will appoint only pro-life justices who are committed to overturning Roe versus Wade. What about a litmus test on guns? Well, during the presidential campaign, candidate Trump repeatedly emphasized his pro-gun views, which are in lockstep with the National Rifle Association. He was asked about a litmus test for the Second Amendment, specifically the precedent established in the 2008 Supreme Court case of District of Columbia versus Heller. In Heller, the justices ruled 5-4 that a common-sense Washington, D.C. law banning handguns and requiring other firearms to be stored, unloaded, or locked violated the second decision, a litmus test in Supreme Court nominees. Trump answered, quote, yes, I would. The follow-up question, so you won't nominate somebody to the Supreme Court unless they agree with Scalia on the Heller decision? Trump responded, quote, correct. So we know from Donald Trump's own words that he had a litmus test for Supreme Court nominees on guns. His judges must support the National Rifle Association's agenda and its unreasonable and dangerously broad view of the Second Amendment. So, from that list of 21 names provided to him by the Heritage Foundation and the Federalist Society, President Trump chose Judge Neil Gorsuch, apparently convinced that he was the man who would pass these litmus tests. The Senate Judiciary Committee's hearings on Judge Gorsuch were an opportunity for him to dispel doubts about his independence that President Trump's selection process had raised. Unfortunately, Judge Gorsuch did nothing to address these concerns. In fact, his appearance before the Judiciary Committee raised more questions than it answered because Judge Gorsuch was positively Sphinx-like before the senators questioning him. For example, when repeatedly asked about something as elementary as his judicial philosophy, Judge Gorsuch refused to answer. He declined to say whether he agreed with the Roe versus Wade decision, the District of Columbia versus Heller decision, or other controversial decisions like Citizens United, which opened the floodgates to unrestricted secret money in electoral campaigns, or even the decision in Bush versus Gore, which decided the 2000 presidential election. Judge Gorsuch also refused to respond to whether he agreed with other important Supreme Court precedents on the right to privacy, the right to counsel in criminal proceedings, voting rights, or same-sex marriage. Contrast that to Justice Sonia Sotomayor, who during her confirmation hearing explained that she fully understood the individual right to bear arms that the Supreme Court recognized in the Heller decision. Or contrast that with Justice Anthony Kennedy, who during his hearing praised the Supreme Court's landmark 1963 decision in Gideon versus Wainwright, which established the right to counsel in criminal cases. Or even contrast Judge Gorsuch to Chief Justice John Roberts, who at his hearing affirmed that privacy is part of the liberty interest protected by the Due Process Clause. Instead, at his hearing, Judge Gorsuch repeatedly parroted that critical Supreme Court decisions were precedents of the court that he would follow unless and until they were overturned. But he shed no light on what he felt about those precedents or whether or not he would be inclined or disinclined to vote to overturn them. Only after considerable prodding did Judge Gorsuch eventually agree that the decision in Brown versus Board of Education, which did away with the doctrine of separate but equal and desegregated schools across our nation was correct. Having to pry out of Judge Gorsuch that concession does not inspire confidence in him. So, his performance at the hearings left us with many troubling things that we don't know about Judge Gorsuch. But equally troubling about Judge Gorsuch are the things we do know about him. We do know that Judge Gorsuch authored the Hobby Lobby decision, in which he ruled that corporations are people whose religious beliefs are more important than the reproductive rights and health of women. We do know that Judge Gorsuch has questioned the judicial doctrine of what is known as Chevron deference. That's the rule from the Supreme Court case of Chevron versus the Natural Resources Defense Council, under which judges must generally defer to expert administrative agency interpretations of laws they are charged with administering. In a speech last year, Judge Gorsuch attacked the modern administrative state that has developed under Chevron, saying, quote, that it, quote, poses a grave threat to our values of personal liberty. What Judge Gorsuch is saying is not some abstract legal theorizing. He is attacking the fundamental rules that protect the health, safety, and welfare of all Americans that are put in place by agencies like the Environmental Protection Agency, the Food and Drug Administration, and the Securities and Exchange Commission. In the decades since Chevron was decided, it has been instrumental in courts upholding these agency rules that ensure that our air and drinking water are clean, rules that ensure that drugs and medicines are safe and effective, rules that ensure that our automobiles, workplaces, food, medicine, and children's toys are not dangerous, rules that ensure our financial markets are fair and offer investors a level playing field. Even Justice Scalia supported Chevron deference. But Judge Gorsuch has signaled that he would overturn it and instead allow pro-corporate judges to substitute their policy views for those of the agency experts. If threatening the destruction of the regulations that protect the health, safety, and welfare of Americans sounds familiar, it should. It's straight out of the alt-right Steve Bannon playbook. And it is a fringe position that is not worthy of representation on our nation's highest court. We also know that the Supreme Court just rejected Judge Gorsuch's harsh reasoning in a disabilities rights case. A few years ago, Judge Gorsuch wrote an opinion for the 10th Circuit Court of Appeals in a case under the Individuals with Disabilities Education Act. That opinion held that schools across the country must provide educational benefits to students with disabilities that, quote, must merely be more than de minimis. But just last week, in an IDEA case, all 8 Supreme Court justices disagreed with Judge Gorsuch. Chief Justice Roberts wrote that the IDEA, the Individuals with Disabilities Education Act, is, quote, markedly more demanding than merely more than de minimis test applied by the 10th Circuit, and added that Judge Gorsuch's approach would effectively strip many disabled students of their right to an education. We also know that Judge Gorsuch has consistently ruled against employees in cases involving claims of unsafe workplaces and sex discrimination, and has repeatedly sided with insurance companies that sought to deny disability benefits to employees. Here's something else we know. If the first 75 days of the Trump administration are a preview of coming attractions, one thing could not be more clear. The United States Supreme Court's rule defending the Constitution will be tested as never before. Conflicts of interest, emoluments, Muslim bans, rescinding LGBTQ protections, the list of constitutional rights the Trump administration is violating gets longer every single day. Now, more than ever, we need a Supreme Court justice who is independent and not beholden to ideology. Now, more than ever, we need a justice who will stand up for the rights of all Americans against big corporate interests. A justice who would be to the right of Antonin Scalia on the issue of Chevron deference is not a mainstream justice. A justice who would be to the right of Samuel Alito and Clarence Thomas by a substantial margin, as professors from Michigan State University and the University of Wisconsin concluded, examining Judge Gorsuch's opinions from the 10th Circuit and the Supreme Court's decisions reviewing them, is not someone within the mainstream of American jurisprudence. Everything that we have seen so far, from Donald Trump's judicial litmus test to the visible hand of right-wing interest groups in the selection process, to Judge Gorsuch's reluctance before the Judiciary Committee, to his pro-corporate bias in cases he has decided, leads me to the conclusion that he will be neither a justice for all Americans nor one on whom we can count to stand up to President Trump. We cannot let Judge Neil Gorsuch become the crucial ninth vote on the Supreme Court. One justice matters. The list of recent 5-4 decisions coming out of the Supreme Court shows that one judge's vote can forever alter history. Just remember that Bush versus Gore, Citizens United, District of Columbia versus Heller, the Affordable Care Act were all decided by 5-4 votes. I will, therefore, oppose Judge Gorsuch's nomination to the Supreme Court and support the filibuster. And I urge my colleagues to do so as well. If Judge Gorsuch cannot muster 60 votes, the problem is not with the process, it is with the nominee. If Judge Gorsuch cannot get to the 60 votes historically required for confirmation to the nation's highest court, I urge President Trump to withdraw his nomination and consult with a wide range of senators, legal scholars, and others that past presidents have sought out before making a Supreme Court nomination, and put before us someone in the mold of Merrick Garland, who can enjoy bipartisan support and be within the broad mainstream of American jurisprudential history. Otherwise, the consequences of forcing Judge Gorsuch's nomination through will fall squarely on the shoulders of President Trump and his Republican allies in the Senate. And if they decide to exercise the nuclear option, forever changing the history of the United States. Republican allies in the Senate. And if they decide to exercise the nuclear option. Madam President, I yield back to the chair.
Senator from Virginia.
Madam President, I also rise to discuss the Supreme Court nomination of Judge Neil Gorsuch of the 10th Circuit. I take this very seriously. I started my legal career as an appellate law clerk in the 11th Circuit Court of Appeals in the South, working for a spectacular jurist, Judge R. Lanier Anderson III. He taught me about what it was to be an appellate judge: humility, not making a case a personal cause, careful application of the law. I then went on to practice law in the state and federal courts, the trial and appeal courts, including the United States Supreme Court, as a civil rights lawyer for 17 years. When I was the governor of Virginia, I twice had to appoint members of the Virginia Supreme Court and grappled with qualifications to serve on an appellate bench. And maybe most especially, Madam President, my wife was a judge. So with a judge in the House, she was a judge for 8 years. I spent a lot of time also thinking about the characteristics of a good judge. Judge Gorsuch has some strong characteristics: educational background, professional experience. These are characteristics that are worthy of respect. But I have decided that there's an additional characteristic that's very important: judicial philosophy. And as I've looked at Judge Gorsuch's judicial philosophy, I've concluded that I cannot support him. I have read scores of his opinions. I met with him in my office. I'm so proud of my colleagues, Democratic and Republican, because in 2 months, Judge Gorsuch has enjoyed something that Merrick Garland didn't get in 10 months. Judge Gorsuch has had meetings with virtually all senators. He's had a Judiciary Committee hearing. He's had a Judiciary Committee vote. He's getting floor debate, and he will get a floor vote. Those are the 5 things that he's entitled to, and he's getting all of them. Judge Merrick Garland was nominated. Republicans wouldn't meet with him. They wouldn't hold a hearing. They wouldn't do a committee vote. They wouldn't do floor debate, and they wouldn't do a floor vote. He got nothing. He got nothing that he's entitled to as a sitting judge on the D.C. Circuit, and also the Senate didn't exercise the advise and consent function that is part of our constitutional job description. Well, let's talk about Judge Gorsuch's record, and many of my colleagues have been speaking for hours. I want to just focus on one aspect of his record. Judge Gorsuch was promoted by President Trump as not an activist, not an activist. And Judge Gorsuch has written with scorn about activist judges, saying that judges who impose their moral or social preferences on others can't square their position with the Constitution. He even scorned activists in courts, saying that liberals are addicted to the courtroom, as if somehow bringing constitutional claims in courts are wrong. So I think it's fair to look at Judge Gorsuch by his own standard. Is he an activist or not? The best definition of a non-activist judge was the definition given by Chief Justice Roberts during his confirmation hearing. He said, look, I'm an umpire. I have no platform. I have no agenda. I call balls and strikes without fear of any party, without favor to any party. I'm an umpire. And I looked at Judge Gorsuch's record and then talked to him about a set of cases to determine whether that was in fact true. And I've concluded that Judge Gorsuch is definitely an activist. He may not be an activist on everything. I don't think you have to be an activist on everything to be an activist, but I do believe he's an activist. And it shows through in no area clearer than it shows through in cases dealing with women's ability to make their own decision about their own health care, especially reproductive health. There's a famous 2013 case that's been much discussed during these discussions and in committee, Hobby Lobby versus Burwell. It was a challenge that was brought up in the 10th Circuit, where Judge Gorsuch now sits. And the legal question before the circuit court was pretty straightforward. Under a congressional act designed to protect religious liberty, the Religious Freedom Restoration Act, could a company claim that its religious views conflicted with the contraception mandate of the Affordable Care Act? And if so, could they gain protection for their own position? Now, Madam President, it was sort of a controversial case because the notion that a company could assert religious views was sort of a novel theory at the time, but the majority in the 10th Circuit ruled, with Judge Gorsuch as part of the majority, that yes, a company could assert a claim based on sincerely held religious beliefs under the RFRA statute, and they could assert that their beliefs conflicted with the ACA's contraception mandate. And then in 2014, that ruling was upheld by the United States Supreme Court, a controversial decision, but the majority agreed with the position that, yes, a company could assert that its sincerely held religious beliefs were in fact in conflict with the statute, and they could get relief from the statute for doing that. Judge Gorsuch joined the ruling, which I indicated was later affirmed by the Supreme Court. But what interested me about Judge Gorsuch in the case was that he chose to write a concurring opinion. Now, for folks who, most folks know what they are, but if you're not a lawyer, when a panel writes an opinion, there's a majority opinion that is the ruling in the case. If a judge feels that it's wrong, a judge will write a dissenting opinion saying, no, you're wrong, and here's why. And you're sort of duty-bound if you think the majority is wrong to write a dissent. But a concurring opinion is about as voluntary as it gets. A concurring opinion is, I agree with the outcome, but I just have a point that I want to make that I can't convince the rest of the majority to go along with me on, and I want to make this point. And so Judge Gorsuch wrote a concurring opinion that was incredibly revealing. It was voluntary, and that shows you a little bit about a person's philosophy, incredibly revealing. Revealing for two reasons. First, Judge Gorsuch had already joined the majority opinion to say that the employer, Hobby Lobby, could challenge the employer mandate of the ACA. He'd already joined that. But he stretched beyond to rule that, in addition, the individuals owning the company should be able to sue to challenge the employer mandate, even though they weren't the employer. The ACA mandate only applied to the employer of the female employees. The employer was Hobby Lobby. But even though the mandate didn't even apply to the Green family that owned the company, Judge Gorsuch said they should be able to challenge the ACA anyway. I practiced law for a long time. There is a complete separation, there's supposed to be, between individuals and an incorporated company. You can run a business and not incorporate it, and in that case, there's no separation. But as soon as you incorporate it, you get all kinds of protection, especially you can protect your own personal assets from liability for corporate actions. The Green family had done that, but Judge Gorsuch said even though you voluntarily separated yourself from the company, and even though the mandate doesn't apply to you, you should be able to file a lawsuit to challenge the mandate. I found that to be highly, highly unusual, a great stretch. And I asked him about it when we talked, and he did not give me a satisfactory answer. But here was the thing about the Hobby Lobby case that was more notable. It was the way that Judge Gorsuch described what the case was about. The majority opinion in the 10th Circuit and the majority opinion in the Supreme Court described the case the same way. They basically said, the owners of this company claim that the contraception mandate is contrary to their religious views. That's what the case is about. The clash was between the owners' religious beliefs and the statute. That's what the case was about. But Judge Gorsuch described the case completely differently. Here were his words. All of us must face the problem of complicity. All of us must decide the degree to which we are willing to be involved in the wrongdoing of others. He didn't describe it as a clash between the owners and the statute. He described it as a case about whether you're willing to be complicit in the wrongdoing of others. That wasn't the legal issue at all. What does that phrase mean in the Gorsuch concurring opinion in Hobby Lobby? The wrongdoing of others. Who are the others he's talking about? He's talking about female employees of Hobby Lobby who wish to make their own choice from among available and lawful methods of contraception. Those are the others he's referring to. And he's also referring to that choice as wrongdoing. That is a completely editorial comment that's not drawn from what a lawyer said or what a plaintiff said. That's his own characterization of the case, and it is completely irrelevant, and I would argue insulting. It is a completely irrelevant and insulting reference to something that wasn't part of the case at all, except Judge Gorsuch decided to inject it into the case. Somebody who looks at women making their own choice of contraception as the wrongdoing of others, that's very telling. Point.
Senator, the time for the Democrats has expired.
President.
Majority Whip.
If my friend, the senator from Virginia, needs a minute or two to wrap up, I know it caught him mid-thought. I'm happy to yield to him for that purpose.
I would appreciate it, and I'll take 2 minutes and finish quickly.
Senator from
I thank my friend, the Deputy Majority Leader, and my friend, the Senior Senator from Texas. I draw support for my conclusion about that language from 2 other cases that Judge Gorsuch was involved in the 10th Circuit. One case dealing with contraception and one case dealing with an effort to defund Planned Parenthood in Utah. In both cases, the 10th Circuit reached a decision that was pro-women's health access. And the parties were fine with the decisions. They were going back to the district court, and they didn't apply to have the cases reheard en banc. But in both these cases, Judge Gorsuch took the highly unusual step of trying to get the appeals heard anyway, even though the parties didn't want to have them reheard. In my experience as an appellate advocate, that is virtually unheard of. And I've talked to litigators in the 10th Circuit, and they've said the same thing. It's highly rare. And the fact that Judge Gorsuch would do it in 2 cases, both of which involved women's health access, is important. Finally, in his confirmation hearing, Judge Gorsuch was asked directly whether he agreed with the decision in Griswold versus Connecticut, the 1965 decision that said that married couples could not be criminalized for using contraception. He said it was a precedent worthy of respect, like all precedents, but he would not agree. He would not say he agreed with the case. Chief Justice Roberts, during his confirmation, said he agreed with the case. Justice Thomas said, I have no quarrel with Griswold. Justice Alito said he agreed with the case, but Judge Gorsuch would not. Griswold versus Connecticut has been used repeatedly in the last 50 years to basically create a body of constitutional precedent that says the relationships of people, romantic, intimate relationships, should be free from the intrusion of big government. You can't criminalize somebody because of their relationship. And somebody who is not willing to commit to that principle, I think, is somebody who has not earned my vote. And with that, I yield the floor. And again, I thank my friend from Texas.
Madam President.
Majority Whip.
Madam President, members of the Senate have been coming to the floor talking about the important vote that we'll be casting tomorrow and then again on Friday, which will result in the confirmation of Judge Neil Gorsuch as the next Associate Justice of the United States Supreme Court. Having served on the Senate Judiciary Committee since I first came to the Senate, it's been my honor to participate in the confirmation hearings in the committee on now 5 Supreme Court justices, Judge Gorsuch being the latest. And what I've been struck by when it comes to Judge Gorsuch is how much our friends across the aisle who cast a party line vote in the Judiciary Committee against the judge on his confirmation, how much they've been struggling to come up with even one intellectually honest argument against the nominee, in spite of his obvious and tremendous qualifications and bipartisan support. For example, I heard our colleague from Virginia, my friend Senator Kaine, criticize a couple of decisions that the judge made. What he left out is Judge Gorsuch participated in 2,700 panel decisions on the 10th Circuit Court of Appeals during his 10-year tenure there. 99% of them, or 97% of them, were unanimous. As a presiding officer knows, that means that each of the judges, the 3 judges on the typical panel or in an en banc, basically that everyone agreed, whether they were nominated by a Republican or Democrat. So this whole idea of cherry picking the judge's judicial record to try to find some straw, to grasp at some straw with which to disagree with his confirmation is pretty striking to me. But last night, we saw the latest act of desperation to try to justify the unprecedented partisan filibuster of Judge Gorsuch. For example, it was reported that a handful of lines in a 2006 book were borrowed from other sources. Well, the timing of this says it all. This book's been published for 10 years. The only reason for this allegation is a last-minute attempt to try to make something, really anything, stick, to tarnish the character of someone who will soon serve on the United States Supreme Court. This kind of baseless attack is not only disingenuous, it's transparent, and it has absolutely no merit. Even the author of the main article allegedly plagiarized has rejected that characterization. So this is the person who wrote the article that Judge Gorsuch was claimed to have plagiarized, in essence. Well, the author of the main article rejected the characterization of plagiarization. She said that under the circumstances, it would have been awkward and difficult for Judge Gorsuch to have used different language. Other academic experts have also rejected the claim and made clear that the preferred methodology for facts is to cite original sources, which is exactly what Judge Gorsuch did. Talk about an 11th hour baseless attack. The bottom line is this: instead of evaluating the judge based on his qualifications, his sterling reputation he has among people across the political spectrum, our friends across the aisle are determined to attempt the first successful partisan filibuster of a Supreme Court nominee. That's disappointing, but it's also destined for failure. Yesterday, I pointed out how we actually got here. Back during the President George W. Bush's first term, Senator Schumer and others laid the groundwork and then executed a strategy for unprecedented obstruction of judicial nominees. That was in response to the election of the last Republican president. And this is in response to the election of a new Republican president. I think for him, following the election of the current one, obstruction is of a perfectly qualified nominee to the Supreme Court is just the next step. It actually represents the ultimate escalation of this weaponization of the filibuster used in judicial confirmation. As I've said before, based on the merits of the nominee, the justifications for opposing Judge Gorsuch are paper thin. Our colleagues across the aisle unanimously supported Judge Gorsuch when he was confirmed to the 10th Circuit Court of Appeals just 10 years ago. He got everybody's vote. It was a voice vote. This was to the 10th Circuit Court of Appeals, a lifetime tenured position. All of them agreed he should be confirmed. Well, that includes then Senators Obama, Senator Clinton, and Senator Biden. So I would ask you, what has changed in the last 10 years that now caused them to reach deep into their bag of tricks and to filibuster this nominee for the Supreme Court? Well, it isn't his track record as judge, that's for sure. As I mentioned, of the 2,700 cases he's participated in, 97% were unanimous. 97%. One recent analysis put him in the middle of his circuit, ideologically speaking. And for a decade, he's done a good, fair work as a judge on the 10th Circuit. Really outstanding work, to be honest. And that should tell you something about this judge and this man. But it should also tell you something about the opponents of this nominee, many of whom, like Barack Obama and Hillary Clinton, as I mentioned, supported his nomination just 10 years ago. The only thing that's changed, the only thing that explains our radical shift of Democrats in opposition to this good judge is that now President Trump is in the White House. I honestly believe that every excuse they've come up with to engage in this unprecedented filibuster is completely without merit. What they're really upset about is what happened on November the 8th. And I don't believe if they won't confirm Judge Gorsuch, they will never vote to confirm any nominee of this president, period. And what we're talking about is, all we're asking for is an up or down vote. If they want to vote against the nomination, that's their right. But as everybody knows, to get to that, we first have to get 60 votes to close off debate and then get to the majority up or down vote. But they won't even allow us to move to a vote. So I hope that our Democratic friends who are obstructing will reconsider. I believe there are 4 Democrats who are going to join all the Republicans in voting to confirm this nominee. So he will enjoy bipartisan support, as he should. This judge is a faithful interpreter of the law. He believes in an independent judiciary and enjoys support across the ideological spectrum. He will be confirmed as the next Supreme Court justice, but it's up to our Democratic friends to determine just how that occurs. Mr. President, I yield the floor.
Mr. President, I rise today to offer my strong support for Judge Neil Gorsuch, President Trump's pick to replace Justice Scalia on the Supreme Court. On Monday, his nomination passed out of the Senate Judiciary Committee, and we expect to confirm him before the end of the week. I am tremendously excited to have him on the bench. Throughout his career, Judge Gorsuch has proven time and again that he is exceptionally qualified to serve on the Supreme Court. He has been praised and endorsed by members of both sides of the political spectrum, the left and the right. As a judge on the 10th Circuit Court of Appeals since 2006, after being unanimously confirmed by this body, Judge Gorsuch has proven he is as mainstream as they come. In fact, of the 800-plus opinions that he has written for the 10th Circuit, less than 2%, or 14 opinions, have drawn dissents from his colleagues. In other words, 98% of his opinions have been unanimous. That's even more remarkable when you look at the makeup of the 10th Circuit. 12 of the judges were appointed by Democrat presidents, while only 5 were appointed by Republicans. Mr. President, it does not get much more mainstream than that. During his confirmation hearings last month, Judge Gorsuch again proved that he is eminently qualified to serve on the bench of our nation's highest court. Let me share some of his quotes from his hearing. The Constitution doesn't change. The world around us changes. I don't believe in litmus tests for judges. If I'm confirmed, I will do all my powers permit to be a faithful servant to the Constitution and laws of this great nation. And one last quote. As a judge now for more than a decade, I've watched my colleagues spend long days worrying over cases. Sometimes the answers we reach aren't the ones we personally prefer. Sometimes the answers follow us home at night and keep us up. But the answers we reach are always the ones we believe the law requires. And for all its imperfections, I believe that the rule of law in this nation truly is a wonder, and that it's no wonder that it's the envy of the world. Close quote. Mr. President, it is clear that Judge Gorsuch is qualified to serve on the Supreme Court, and that he understands the role of a judge to interpret the law, not to make the law. To that end, I would also like to highlight Judge Gorsuch's in-depth understanding of the separation of powers doctrine, and I'm optimistic that Judge Gorsuch will carefully scrutinize cases and controversies that involve executive overreach. The past 8 years have seen an unprecedented expansion of the administrative state. This has come at the expense of both legislative branch and whose purpose is to make laws, and the judicial branch, whose purpose is to interpret the law and decide on specific laws' constitutionality. But more concerning than that, it has also come at the expense of American citizens. Overreach by executive agencies has led to regulatory expansion that results in the federal government involving itself in nearly every facet of our lives on a daily basis. This expansion has been permitted in part to U.S. courts relying on the flawed Chevron doctrine to show great deference to agency interpretation of the laws passed by Congress. As a result, agencies have been able to broadly interpret laws in a way that has allowed them to expand their regulatory authority far beyond what Congress ever intended. Fortunately, U.S. judges are beginning to question the Chevron doctrine and its impact on the separation of powers doctrine relied on by our founding fathers and affirmed in the U.S. Constitution. Judge Gorsuch is one of these judges. Regarding Chevron, Judge Gorsuch has written that Chevron seems to be no less than a judge-made doctrine for the abdication of the judicial duty that prevents American courts from fulfilling their constitutionally delegated duty, interpreting what the law actually intends. Careful judicial scrutiny and interpretation of the law will allow courts to rein in agency actions that are inconsistent with the law and beyond the bounds of what Congress intended. In his concurrence in Gutierrez-Brazula versus Lynch, Gorsuch argues that the Administrative Procedure Act vests in the courts the responsibility to, and I quote, interpret statutory provisions and overturn agency action inconsistent with those provisions, end of quote, and questions the idea that Congress, and once again I quote, intended to delegate away its legislative power to executive agencies, close quote. Judge Gorsuch takes his duty as a judge with the utmost seriousness. He seeks to interpret the law the way Congress intended, not in the way that an executive agency wants it to be. His careful and academic approach to judicial review is well suited for our nation's highest court. I'm confident that Judge Gorsuch will respect and enforce the constitutionally affirmed separation of powers doctrine that in recent years has been diluted by executive agencies broadly interpreting laws, resulting in regulatory overreach. This has minimized the role of Congress in the legislative process. As a result, the voices of American citizens have also been minimized and replaced with unelected Washington bureaucrats who think they know what is best for all Americans. Judge Gorsuch is one of the finest judges our nation has to offer. The knowledge and careful deliberation he will bring to the court will result in rulings that reflect justice, fairness, and an interpretation of what the law is and what Congress intended it to be, not what administrative agencies want it to be. Despite impeccable credentials, we are in a situation today because of a precedent set in November of 2013 by then Majority Leader Harry Reid and his conference. Former Leader Reid's use of the so-called nuclear option in 2013 meant the Senate could reinterpret its rules via simple majority vote. Former Leader Reid accomplished this by challenging a ruling of the chair with regard to the number of votes needed to end debate on certain nominations. The standing rules of the Senate require the support of a supermajority, or 67% of senators, to change the rules. To challenge the ruling of the chair, Reid only needed a majority vote to overturn the presiding officer's correct interpretation of the written rule. In other words, former Leader Reid broke the rules to change the rules, and by default broke precedent to change the precedent moving forward as well. Based on this new precedent set by former Leader Reid, the Senate is likely to confirm Judge Gorsuch to the Supreme Court by a simple majority vote. Because the Senate has always operated on precedent, we will likely follow this new precedent to approve Judge Gorsuch's nomination later this week. When he is confirmed, Judge Gorsuch will make a tremendous addition to the United States Supreme Court. His lifetime of defending the Constitution and applying the law as it was written provides clear evidence that he has the aptitude for this lifetime appointment to our nation's highest court. Thank you, Mr. President. I yield the floor. And I note the absence of a quorum.
Mr. President, I rise today in support of the nomination of Judge Neil Gorsuch to be our next United States Supreme Court Justice. Article 2, Section 2 of the Constitution entrusts members of the Senate with a responsibility vital to our democracy, providing advice and consent on the President's Supreme Court nominees. The significance of this task cannot be overstated, and it is one that I take very seriously. Days after President Trump nominated Judge Gorsuch to fill the late Justice Scalia's seat on the Supreme Court, I shared the qualities that I wanted to see in a justice. They included a strong commitment to the rule of law, first-rate credentials, and a solid judicial record. The time has come to determine whether the nominee meets those criteria. After meeting personally with Judge Gorsuch, watching his confirmation hearing, and evaluating his background and legal record, I believe that answer is a resounding yes. Judge Gorsuch's credentials are exemplary. He has an extraordinary resume and a brilliant mind. For 10 years, he has served on the U.S. Court of Appeals for the 10th Circuit. The Senate confirmed him to this position by unanimous consent in 2006. No roll call vote was needed because all 100 members supported the nomination. To date, Judge Gorsuch has decided 2,700 cases. 99% of the time, he sided with the majority. He's authored opinions in 800 of those cases. 98% of the decisions in these cases were unanimous. This record tells us something important. He is well within the mainstream. It's why he has gained the respect of prominent attorneys on the right and on the left. Several of my Democratic colleagues have made similar observations. Senator Donnelly recently said that he would support Judge Gorsuch's nomination because, quote, he is a qualified jurist who will base his decisions on his understanding of the law. Similarly, Senator Heitkamp indicated that she would vote to confirm Judge Gorsuch because, quote, he has a record as a balanced, meticulous, and well-respected jurist who understands the rule of law. Mr. President, my colleagues have it right. A justice should be a follower of the Constitution, not a trailblazer or an advocate. His or her role is to interpret and uphold the laws, not to create them. Judge Gorsuch understands this. He takes it seriously. In his confirmation hearing before the Senate Judiciary Committee, Gorsuch emphasized the importance of judicial precedent and a fair approach to the law. He said, "I come here with no agenda but one, to be as good and faithful a judge as I know how to be." Similarly, in a private meeting in my office, the judge promised to follow the law wherever it may lead. Judge Gorsuch recognizes the pivotal but the limited role that the Constitution allows judges to play in our republic. During long days of testimony at his confirmation hearing, he made clear that while legislators answer to the people, a judge answers only to the law. At the same time, Judge Gorsuch said that he interprets his judicial oath as a promise to make sure that every person, poor or rich, mighty or meek, gets equal protection of the law. Mr. President, equality before the law is Nebraska's state motto. It represents the commitment Nebraskans made 150 years ago when we entered the Union. That principle remains strong today. It should be a cornerstone of judicial philosophy for any nominee to our nation's highest court. It's why the words "equal justice under the law" are engraved on the front of the Supreme Court. Judge Gorsuch is dedicated to this principle. He's committed to applying the law neutrally, equally, and fairly to all people. Now, Mr. President, some of my Democrat colleagues are saying that Judge Gorsuch is out of the mainstream. They argue he won't look out for the little guy. They are prepared to take the unprecedented and extreme step of filibustering this nomination. This would be the first successful, totally partisan filibuster of a Supreme Court justice in the history of the United States Senate. Mr. President, let me share some of the facts about this institution. In our country's history, no cabinet nominees have ever been denied their appointments by a Senate filibuster. In our country's history, no federal district court judges have ever been denied their seats by a Senate filibuster. The first time a filibuster was used to defeat a judicial nomination was for a circuit court judge, Miguel Estrada, who was nominated by President George W. Bush to the U.S. Court of Appeals for the D.C. Circuit. In our country's history, the filibuster has only been invoked once to block a Supreme Court nominee. It was in 1968, and a threatened bipartisan filibuster by Republicans and Democrats prevented Associate Justice Fortas from becoming Chief Justice of the Supreme Court. The nominee ended up withdrawing because of ethical concerns. 2 sitting members of the Supreme Court were confirmed by fewer than 60 votes on an up or down vote. But neither one was the subject of a filibuster. A filibuster of this nominee, it sets a dangerous precedent and undermines the reputation of this institution. Judge Gorsuch will make an excellent Supreme Court justice. The American people deserve to have him on the bench, and I look forward to voting in support of Judge Gorsuch's nomination to serve as our next Supreme Court Justice. And I urge my Senate colleagues to do the same. Thank you, Mr. President. I yield the floor.
Mr. President, I'm honored to come to the floor today and join my colleagues to support the nomination of Judge Neil Gorsuch to the Supreme Court of the United States. Judge Gorsuch is an exemplary pick for my home state of North Dakota and also for our nation as a whole. He's shown deep respect for the Constitution and has a strong record of upholding the rule of law. If confirmed, Judge Gorsuch will take the seat that was held by the late Justice Antonin Scalia. Of course, filling that vacancy will be no easy task. Justice Scalia was a brilliant legal mind who had earned the respect of many in the legal community during his nearly 30 years on the Supreme Court. He was a true defender of the U.S. Constitution and sought to protect it so that future generations of Americans could live and thrive in a free society. His legacy on the court will influence American jurisprudence for generations to come. If there is anyone who is worthy of filling Justice Scalia's shoes, it is Judge Gorsuch. Like Scalia, Judge Gorsuch is an originalist when it comes to interpreting the Constitution. I had the pleasure of meeting with Judge Gorsuch last week to discuss his nomination, and I'm confident that he will make an excellent justice. Mr. President, if you look at his background, it is clear that he is an incredibly qualified nominee. After receiving degrees from Columbia, Harvard, and then Oxford, Judge Gorsuch went on to clerk for notable Supreme Court Justices Byron White and Anthony Kennedy before entering private practice. After 10 years of private practice, Gorsuch began his career in public service as a Deputy Associate Attorney General at the United States Department of Justice. In 2006, he was nominated by George Bush to be the United States Court of Appeals for the 10th Circuit, and he was confirmed unanimously by the United States Senate. Let me repeat that. He was confirmed unanimously by this body. I believe that says a lot about Judge Gorsuch as a candidate. In a body that is so often divided, a candidate that can receive unanimous support is truly noteworthy. When nominated by the President, Judge Gorsuch said, quote, "A judge who likes every outcome he reaches is very likely a bad judge, stretching for results he prefers rather than those the law demands," end quote. During his tenure on the 10th Circuit, he has demonstrated fair and prudent judgment in his opinions. In addition to his impressive professional background, Judge Gorsuch has roots as a Westerner and will bring those roots and a much-needed perspective to the Supreme Court. Because decisions that come from the court affect the lives of Americans from across the country, it's important that the court is comprised of justices from different regions of the country. It's critical that our next Supreme Court justice has familiarity with the challenges Western and Midwestern states like my home state and others face. Issues such as states' rights, Second Amendment rights, land use disputes, and the complex relationship between state and tribal governments. These are the everyday realities that we face across this country that the justices must deal with. I expect many of these important issues to come before the Supreme Court in the coming months. In fact, just yesterday, the court decided to move forward on litigation regarding former President Obama's Waters of the U.S. rule, also known as WOTUS, which has had a significant burdensome impact on farmers and ranchers and threatens the constitutional role of the states. Judge Gorsuch's background also makes him a prominent voice for Indian country, As chairman of the Senate Indian Affairs Committee, I believe it's important for our next Supreme Court justice to have a concrete record of respecting tribal sovereignty. I was pleased to learn that he has earned the support of a number of Native American groups, including the National Congress of American Indians and the Native American Rights Fund. Judge Gorsuch has a long history of handling cases that affect Native Americans from his time on the 10th Circuit. And he's demonstrated a consistent understanding of the unique legal principles involved in federal tribal law. The boundary between state and tribal authorities is often ambiguous. Yet Judge Gorsuch was able to bring clarity as he diligently studied the law and respected existing precedents in tribal sovereignty. For example, the Ute tribe of Utah has been engaged in legal battles with the state over the state's authority to prosecute Native Americans on tribal land. Judge Gorsuch has consistently ruled in favor of tribal sovereignty. In Hydro Resources versus EPA, case in which EPA overreach was redefining the boundaries of Indian lands, Judge Gorsuch overruled EPA's interpretation and respected the current tribal boundaries. Mr. President, for all these reasons, I urge a yes vote on Judge Gorsuch's nomination. As the highest court in the land, the decisions have a widespread impact on millions of Americans. When the stakes are this high, it is necessary that we confirm someone with a sound, fair, and prudent approach to the law. I have no doubt that Judge Gorsuch is the right person for this role. I enthusiastically support his nomination and urge my colleagues on both sides of the aisle to do the same. With that, Mr. President, I yield the floor.
The senator from Washington.
Thank you, Mr. President. Mr. President, I come to the floor today to express my deep concern about the Republicans' rush to fill the vacant Supreme Court seat and about President Trump's nominee for this critical position. I want to start by saying I believe one of the most solemn and consequential decisions we make as senators is whether to support a nominee to the highest court in the country. It's a responsibility I do not take lightly. And after careful consideration, I will be voting against the nomination of Judge Neil Gorsuch and oppose a cloture-ending debate. Mr. President, I come to this conclusion weighing several things. First, a Supreme Court justice has an enormous responsibility to uphold our Constitution and defend our democracy. The court's decision affects every citizen in every corner of this country. And at times, one justice, perhaps this nominee, may be the only thing standing between someone's rights and an executive branch that operates as though it is above the law. And that is a real concern when I have heard over and over from people in my home state of Washington who are frightened about the direction President Trump is trying to take our country. Since taking office about 2 months ago, he has demonstrated complete disregard for the law, the Constitution, and American families. He has tried to force through un-American bans on Muslim refugees and immigrants. He fired Sally Yates, an acting attorney general who dared to stand up to him. Mr. President, it is clear this president doesn't just think he's above the law. He has at times shown a true disdain for it, repeatedly insulting the men and women on the bench, even telling a crowd that perhaps the Ninth Circuit of Appeals, Court of Appeals, a court that didn't rule in his favor, should be broken up. Now, we need an independent judiciary that can safeguard the rights of citizens against this executive branch. But with so much chaos created by this president, coupled with the cloud of an FBI investigation into him and his associates, I have no reason to trust he or his administration are acting in the best interests of our country or our democracy, and I cannot support moving forward with his choice for this court. On top of that, I am concerned by the unprecedented pace of the Judiciary Committee process, which would rush through this nominee on the fastest timeline in recent history. And that is pretty striking because this same committee failed to hold a single hearing on this vacancy for 12 months following Justice Scalia's passing. It refused President Obama's nominee, Judge Merrick Garland, any opportunity to be heard, which brings me to my serious concerns about this particular nominee. And I want to start with women's access to health care. President Trump campaigned on promises to overturn women's constitutionally protected rights to make their own health care decisions secured by the historic ruling in Roe v. Wade. Now, this president has broken almost every promise he's made, but one he appears to be keeping, especially in selecting Judge Gorsuch, is his promise to undermine women's health and rights. Judge Gorsuch would have taken the ruling in Hobby Lobby to allow women's bosses to decide whether or not they get birth control, to an even more extreme result. And his deeply conservative record suggests he can't be trusted to stand up for women's constitutionally protected health care rights or access to care. In fact, it seems clear he will work to weaken those rights at every opportunity. Mr. President, since day one of this presidency, women nationwide have made it absolutely clear they do not want to go backwards, and that is something I'm going to continue to fight for. I'm also going to keep fighting for our workers, and I'm troubled that as a federal judge on the 10th Circuit, Judge Gorsuch has a clear record of siding against workers and with corporations and big business. The Associated Press said his opinions were, quote, coldly pragmatic, and they're usually in the employer's favor. His history of dismissing workers' safety concerns and hostility towards upholding disability rights greatly concerns me and strongly suggests that he would join conservative justice to undermine workers' rights. We need a justice on the Supreme Court who will uphold workers' protections and safety and right to organize. I'm also deeply concerned about the potential effect on children and students with disabilities. In a number of cases, Judge Gorsuch ruled in ways that made it more difficult for them to receive the support and services they not only deserve, but are entitled to under the Individuals with Disabilities in Education Act, our nation's special education law. I strongly believe in this law, and I believe we should be doing everything to ensure individuals with disabilities can attain their full potential by accessing meaningful, quality public education, certainly not the bare minimum. And Mr. President, it is notable that while Judge Gorsuch was testifying, actually while he was testifying before the Judiciary Committee 2 weeks ago, the Supreme Court unanimously rejected his prior ruling in a case involving the rights of a student with disabilities to receive a meaningful education. And it is highly troubling that when it comes to policies concerning torture, Gorsuch, as a member of President George W. Bush's Justice Department, advocated that the president has broad powers to basically ignore parts of the legal ban on torture. This deference to executive power is concerning, to say the least, but it also makes a whole lot more sense as to why Judge Gorsuch would be Donald Trump's #1 choice. And his testimony before the Judiciary Committee regarding Citizens United, in which he incorrectly stated the court left Congress the ability to enact common sense campaign spending limits, strengthens my decision to vote no. So if you believe in transparency in our elections and upholding the integrity of our democracy, or you believe that we need a justice that will protect the rights of all Americans and stand with them and not with President Trump and millionaires and billionaires, this choice is clear. As I've urged my colleagues for weeks, with so much chaos in the administration and so many questions now surrounding this president's commitment to the rule of law, slow down. Stop playing political games, respect the families we represent, respect the separation of power, and stop trying to jam this nominee through. And whatever you do, do not blow up the Senate rules for Supreme Court nominees. Invoking the nuclear option is a dangerous path to go down. Mr. President, I've been in the majority, I've been in the minority. And either way, I believe when it comes to a lifetime appointment to the Supreme Court, The Senate must adhere to a higher standard and the 60-vote threshold. If you can't get that many votes for a Supreme Court nominee, you don't need to change the rules. You need to change the nominee. Thank you, Mr. President. I yield the floor.
The senator from Vermont.
Mr. President, first I commend the senior senator from Washington State for a terrific statement. I know as a member of the Judiciary Committee that we reported the nomination of Judge Neil Gorsuch by the narrowest margin, a party line vote. But the majority leader then filed cloture to cut off debate on this nominee. And has shown he's promised to use whatever tactic is necessary to ensure this nominee is confirmed, no matter the concern of senators or millions of other Americans. Today is just the 75th day of the Trump administration. Only 75 days of having a Republican control of the White House and the Congress. The Republican leader has promised to vitiate the historic rights of the minority in this institution, all in the service of Donald Trump's agenda. And as we know, Donald Trump asked him to. Now, all presidents, including President Trump, are entitled to have their Supreme Court nominees considered on the merits. In over 42 years in the Senate, I've evaluated every nominee in the merits. I've never gone to partisanship. In fact, I've voted to confirm 6 Supreme Court nominees of Republican presidents. In fact, I don't know if there's any Republican in this Senate could say that. But unlike Senate Republicans' treatment of Chief Judge Merrick Garland, I take my constitutional duty to independently evaluate a president's Supreme Court nominee seriously. That's included Judge Gorsuch. Now, I had concerns that Judge Gorsuch would bring a partisan agenda to the court, but I went to his hearing with an open mind. I'd hoped he could convince me that he was a conservative I could support, as I did Chief Justice Roberts. I voted for Chief Justice Roberts not because I thought I'd always agree with him, and I don't, but because I was able to take him at his word that he did not have an ideological agenda. I can't take Judge Gorsuch's word that same way. It's no secret that Judge Gorsuch is very conservative. That much was evident back in 2006 when he's confirmed to the 10th Circuit, but at that time he did not have a judicial record. He explained that judges should not be ideologues who disregard precedent to affect their own personal views, politics, and preferences. Well, I wish that same judge were before us today, but he's not. Judge Gorsuch has a fine resume. I don't take issue with the qualifications on record, but my concern is that he's not lived up to his own standard. I'm concerned that his personal views, his politics have permeated throughout his judicial philosophy. That is, in fact, the reason why his nomination is before us today. To know what kind of justice Judge Gorsuch would be, we have to understand what he's chosen. President Trump made very clear right from the beginning that he had a litmus test. Anyone he nominated would automatically overturn Roe versus Wade. Then candidate Trump proceeded to outsource the selection process to far-right interest groups. The leader of that unprecedented vetting process admitted they were not driven by, quote, who's a really smart lawyer, who's been really accomplished, close quote, but by a search for someone, quote, who understands these things like we do. Now, let's be clear. These aren't groups that support independent judges who act with restraint. These groups search for nominees who skew the court, and they would give President Trump a list and say, here, you're allowed to pick from our people. If these groups sought a mainstream, widely respected independent jurors, they would have been as supportive as I was of Chief Judge Merrick Garland. Instead, they funneled money to push Senate Republicans to hold Chief Judge Garland's nomination hostage and to have the Senate defy the Constitution of the United States for the first time ever, not allowing us to vote on him, not allowing advice and consent. The groups I've talked about, the billionaire donors who fund them, have a clear agenda. One that's anti-choice, anti-environment, and pro-corporate. I'm not willing to gamble, in my mind, that they blindly gambled the millions of dollars on Judge Gorsuch. They chose him for a reason. They're supremely confident he shares their far-right agenda. So is the White House. The White House Chief of Staff has said that Judge Gorsuch has the vision of Donald Trump, and that with this nomination, we're talking about a change of potentially 40 years of law. People who vetted him do not want a nominee who's going to call balls and strikes. They want a nominee who will expand the strike zone to the detriment of hardworking Americans. In the hearing, he did nothing to allay my concerns. In fact, he solidified them. I can't recall a nominee refusing to answer basic questions about the principles underlying our Constitution. These are fundamental questions, but he would not answer. Other Supreme Court nominees have been far more forthcoming. For example, when I asked Judge Gorsuch a straightforward question whether the First Amendment, framers of the First Amendment believed it permitted the use of a religious litmus test, he refused to answer. Any first-year law student knows the answer to that one. I then asked Judge Roberts a similar question over 10 years ago, whether the internment of U.S. residents who have a particular nationality or ethnic or religious group could be constitutional. He said, I'd be surprised if there are any arguments that could support that. He gave real answers to basic questions, and he earned my support. So I'd hope that if Judge Gorsuch was not willing to be transparent in front of the lights and cameras, would he answer written questions? He again declined, refusing to expressly acknowledge that Congress has war powers, even though we know we do. He provided no answer at all to questions regarding the Supreme Court's decision in Shelby County to gut the Voting Rights Act, or about women's rights to obtain contraception. And he refused to answer whether the First Amendment prohibits any president from proposing a religious test. Now, previous nominees respected the Judiciary Committee's constitutional role by answering questions in a substantive way, not mere platitudes. And the difference is clear to Vermonters. As an editorial in the Rutland Herald put it, Gorsuch's affable muteness sent a message. I am above the people and their concerns. I have no responsibility to anyone but the narrow band of millionaires and ideologues who have advanced my nomination, and to the president who's declared war on the American government. And I ask the consent at the end of my statement, the full editorial be printed in the record. Thank you. You know, if simply had automatic rules on decisions, then all judges would reach the same results. Well, they don't. Legal decisions are matters of interpretation, often matters of justice. We know that Judge Gorsuch at the Justice Department embraced broad and discredited assertions of executive power. He also once complained about liberals relying on the courts to vindicate their constitutional rights. But when he became a judge, he had no problem twisting statutory language to limit the rights of workers, of women, and children with disabilities. In fact, last summer, he wrote a concurrence to his own opinion to argue that the Chevron doctrine should be overturned. The Chevron doctrine not only forms the basis for our modern government, but it's well-settled law. It has been so for decades. As Emily Bazelon and Eric Posner wrote in the New York Times, the administrative state isn't optional in our complex society. It's indispensable. But his rejection of that has shown that he is not a mainstream nominee. His judicial record demonstrates a partisan agenda, hostility toward our government's power to enact environmental, labor, or consumer rights or other regulations to keep hardworking Americans, that they have a safe and level playing field, not just the wealthy few, but all hardworking Americans. He spoke repeatedly about the limited role that judges play in our democracy, but his actual record belies that claim. And I think that's precisely why these extreme right interest groups selected Judge Gorsuch. That's why the President's Chief of Staff promised he'll bring a change of 40 years of settled law. But that's also why I cannot support this nomination. And it's why the Senate Republicans have brought us to this precipice. You know, we understand why they paraded before the Senate the most extreme and partisan slate of cabinet nominees I've ever seen. First, they tried to repeal the Affordable Care Act. Well, that collapsed under the weight of their own inter-party infighting. So then they dusted off the Congressional Review Act, and by party line votes, rolled back more than a dozen environmental, workplace, privacy, health care, and transparency protections. Think about it. They've not sought compromise anything in this Congress. That's not the way to vote. That means hard weight. What they did, to give you one example, they repealed an important internet privacy rule that protected Americans' online activity. That means by their party line vote, hardworking Americans will now see their private internet activity sold to the highest bidder for greater corporate profits. They're allowing these companies to come basically in and spy in your house because they're making money. But they didn't stop there. They rolled back protections to ensure that all students have the same educational opportunities. They've eliminated rules requiring employers to maintain records of workplace injuries so employers could avoid accountability. In other words, if you have a major injuries, you have to keep a record of that. Let's make sure nobody knows this is a dangerous place to work. They've rolled back rules holding coal companies accountable for their pollutions. Rolled back protections under the Title X program, which means that in underserved communities or rural areas like Vermont, Title X, which is critical to making sure women have access to the basic health care they need, Republicans are taking away. But that's what one party rule gets you. They're looking out for corporate interests, but they struggle at looking out for the interests of hardworking Americans. In fact, 3 times this year, the most since any vice president since 1911, Vice President Pence was forced to make the trip to Capitol Hill to break a tie and ensure some of these extreme measures. And it's like the Gorsuch nomination. They have no interest in playing by the rules. They prefer to break them. And the unprecedented obstruction of Chief Judge Merrick Garland is going to be a permanent stay in this body. In fact, days after the 2016 election, Republicans who turned their back on the Constitution for a whole year refused, even though they sworn an oath to uphold the Constitution, which calls for advice and consent. For a whole year, they refused to advise and consent and have a vote on Chief Judge Merrick Garland. But right after the election, we're told now we must rubber stamp President Trump's nominee. If we don't, they'll forever damage the Senate. I remind Republicans we have a choice here. We can work together with President Trump to find a mainstream consensus nominee. Recall the process President Obama used when he selected Chief Judge Merrick Garland. He sought the advice of both Republican and Democratic members of Congress and was told this is a person who would get a solid majority vote. He said, we've reached out to every member of the Senate Judiciary Committee, to constitutional scholars, to advocacy groups, to bar associations, representing an array of interests and opinions from all across the spectrum. And then President Obama nominated somebody who in normal times would have gotten the vast majority of votes of Republicans and Democrats. You know, if President Trump were to follow that template, we'd not be in this extraordinary place. Let me conclude this. In the committee, I say I respect this institution as much as anyone. As Dean of the Senate, I've been here for 42 years. I've devoted myself to the good the Senate can accomplish. We, 100 senators, stand in the shoes of 320 million Americans. We should be the conscience of the nation. First and foremost, we must do what's right by 320 million Americans. But I'm not going to vote solely to protect an institution when the rights of hardworking Americans are at risk. For these reasons, I must oppose this nomination, and I ask consent my host statement be made part of the record.
Without objection.
I yield the floor.
Senator from California.
I thank the President. How much time do I have?
The Democrats have approximately 36 minutes remaining.
Thank you very much. Mr. President, I rise today as the ranking member of the Judiciary Committee to speak about the nomination of Judge Neil Gorsuch to the Supreme Court of the United States. In committee, at the outset of the hearings, I remarked that our job was not to evaluate legal doctrines and theories or review Judge Gorsuch's record in a vacuum. Our job is really to assess how this nominee's decisions will affect the American people and whether he will protect the legal and constitutional rights of all Americans. So I've had this in mind throughout the entire process. Let me begin with an aside. I represent a large state, and I do pay close attention to constituent letters, calls, and emails. A weekly report lets me know on what issues people are focused and what they think, and I take this feedback very seriously. In general, my barometer has been that when I receive over 30,000 calls, emails, or letters, that's when I know an issue is reasonably meaningful to many people in the state. To be clear, I don't base my final judgment on any issue or nominee solely on the numbers of calls and letters I receive. However, this is a representative democracy, so I find this to be an important measure of what California constituents are thinking. Excuse me. When it comes to this nomination so far, my office has received a total of 112,309 calls, emails, and letters from California constituents. 92,799, or 83%, oppose this nominee, and 19,510, or 17%, support this nominee. Let me just read a few of the calls. One constituent from Silverado, California, wrote, "In 1971, when abortion was illegal, I was forced to have a child at age 16. That was 46 years ago. With Gorsuch, we would step back into that world where women and girls have no choice but an illegal and unsafe abortion or become a mother. That's wrong. The choice is untenable and dangerous. Filibuster Gorsuch and do whatever it takes." Now, I was a college student in the 1950s, and I remember very much what life was like before a woman had the right to privacy to control her reproductive system, according to Roe v. Wade. Another constituent from San Diego emailed, and I quote, As a beneficiary of the right to marry 3.5 years ago, I personally understand how important Supreme Court decisions are. I also attended a segregated elementary school when I was a little boy. I do not trust that Neil Gorsuch would advocate for the best interests of women and minorities. Please do not confirm him. A woman from Richmond, California wrote, "I believe that we, the people, will have a difficult time getting fair and equal treatment with Gorsuch being on the Supreme Court. He will help the rich corporations, and the poor and middle class will suffer." Now, I don't comment on any of these because none of these are sacrosanct, but they are opinions. And Brandon Gregg from Burlingame wrote, "The Republicans did not give Merrick Garland a hearing, instead waiting until Trump could propose a young, right-leaning judge who will take our country backwards. Gorsuch will not advance the agenda of human rights within our Constitution, but will plunge us back into the past where minorities had little protection. Women did not have equal rights. People of color were denied the right to vote, and protections for all people that we take for granted did not exist. This is not the world I want for myself, my children, and my grandchildren. Filibuster Gorsuch's confirmation, please." Bottom line, Californians are letting me know loud and clear that who sits on the Supreme Court matters. Unfortunately, up to now, much of the press coverage on this nomination has been about politics and process. In contrast, little has been said about how the Supreme Court affects the lives of Americans, their families, and their communities. So, let me say, in the past 24 years that I have been a member of the Judiciary Committee, I have seen that the Supreme Court is, in fact, the last word in so many areas. The personal rights of all Americans, including who they can marry and whether women have the right to privacy that allows them to control their own bodies. The Supreme Court determines whether decisions about health care will be determined by families or businesses. The Supreme Court has the final say on whether states and localities will be able to pass laws that make it harder for low-income people, people of color, seniors, and students to vote. The Supreme Court will decide whether corporations are able to pollute our air and water with impunity. And it's the Supreme Court that will be the final word on executive authority, whether it's used to waterboard, detain individuals indefinitely, or overreach in other ways. Each year, more than 350,000 civil and criminal cases are filed in federal courts. The Supreme Court hears arguments for only about 80 cases a session and makes decisions on approximately 50 more cases without hearing arguments. Now, this means the Supreme Court only hears a very small percentage of cases, less than 0.02%. Before the current vacancy, the most significant questions were closely decided by 5-4, with 5 votes coming from Republican-appointed justices. These include important decisions that affect our elections, like Shelby County and Citizens United, decisions that weakened the power of average voters by expanding the role of dark money and gutting a key provision of the Voting Rights Act. We also saw a 5-4 decision in Heller that overturned 70 years of precedent on the Second Amendment and blocked the District of Columbia's common sense gun regulations. As my colleague, Senator Whitehouse, outlined in the Judiciary Committee, in the last several years, this Supreme Court has issued an additional 11 5-4 decisions that promote the rights of corporations over the rights of everyday people on topics as wide-ranging as age discrimination and harassment to limiting access to courts and juries. So, who sits on the Supreme Court matters. Just look at some of the key cases that have come down since this vacancy arose last year. For example, the Supreme Court deadlocked 4-4 on a case to determine whether unions are able to fight for fair pay and benefits for all workers by requiring them to contribute to a union's action on their behalf. We know this issue will go back to the Supreme Court. If, next time, the court rules against unions, like the California Teachers Association, it will be overturning a 40-year precedent known as agency shop and will permit an assault on workers' rights. Also, last year, the Supreme Court heard the case on North Carolina's law that reduced early voting days, eliminated same-day registration, and established new restrictive photo ID requirements to vote. The Fourth Circuit struck down North Carolina's law, concluding it had, and I quote, targeted African Americans with almost surgical precision, end quote. Yet, when the Supreme Court took it up, they deadlocked 4-4. Who sits on that court matters. After 4 days of hearings and reviewing Judge Gorsuch's record, we have learned that he indeed has strong views of what the law should be and how it should be interpreted. While Judge Gorsuch was not responsive to many questions, he did tell us that he's happy to be called an originalist and that he embraced the term. He also stated that he believes judges should look to the original public meaning of the Constitution when they decide what one of its provisions mean. According to him, the Constitution, and I quote, the Constitution isn't some inkblot on which litigants may project their hopes and dreams, but a carefully crafted text judges are charged with applying according to its original public meaning. Original public meaning. That takes us back to 13 colonies, 4 million Americans, and 1789. I find this originalist judicial philosophy to be deeply troubling. It essentially means that judges and courts should evaluate all our constitutional rights and privileges as they were understood in 1789. To freeze our understanding of the Constitution in 1789, I think, ignores the framers' intent. But more importantly, it would ignore the vibrancy and growth of our nation. We are no longer a society that condones slavery. We no longer permit segregation. We don't allow child labor. We recognize that women not only deserve an education, but can be leaders in business, government, and their homes. We cannot turn the clock back 230 years. As Justice Brennan said, asking judges to resolve legal questions by looking only to what people believed when our country was founded was little more, and this is a quote, was little more than arrogance cloaked as humility, end quote. And that while, quote, proponents of this facile historicism justify it as the depoliticization of the judiciary, the political underpinnings of such a choice should not escape notice, end quote. After all, those who would restrict legal claims to the values of 1789, specifically articulated in the Constitution, turn a blind eye to social progress. This is Judge Brennan's speech in 1985 at Georgetown University. This is an important point that I think bears repeating. A judge's decision to adopt an originalist philosophy is inherently political because it discounts the expansion of constitutional protections beyond white men who owned property. And yes, that's the way it was back then. The United States Constitution, I deeply believe, is a living document intended to evolve as our country evolves. We're not supposed to ignore social progress, and I don't believe the founders of our country ever intended us to do so. Another concern with George Gorsuch's record is his extreme conservative view of the federal government. For example, he's indicated he believes the long-standing legal doctrine that allows agencies to write rules to effectively implement laws should be overturned. And that doctrine, as the chair well knows, is the Chevron doctrine, and it was discussed in committee. Chevron was itself a unanimous opinion, authored by a liberal, Justice Stevens, and joined by conservatives, including Chief Justice Burger. This legal doctrine has been in place for decades and has been cited more than 15,000 times. If Chevron is overturned, as Judge Gorsuch has advocated, many important laws that Congress has passed would become effective. And I want to give you a personal example. In 2007, Senator Olympia Snowe and I finally passed legislation, thanks to Senator Ted Stevens and Dan Inouye, to increase the mileage efficiency of cars. This was critical to address because pollution was clouding up our cities, and it was important to improve the functioning of our automobiles. Our legislation required the Department of Transportation to set standards so that fuel economy would increase at least 10 miles per gallon over 10 years. That's the time we could foresee, and continue to rise after that. We instructed the agency to achieve, and I quote, the maximum feasible average fuel economy, end quote, and directed the Secretary of Transportation to consider, quote, technological feasibility, economic practicality, the effect of other motor vehicle standards of the government on fuel economy, and the need of the United States to conserve energy, end quote. That's directly from the bill. Here's the result. It has just been announced that this program will raise fuel economy to more than 50 miles per gallon by 2025. I think the specifics were 54 miles to the gallon. This would have been impossible in 2007 when we were trying to pass the bill. We could not possibly understand 10 years hence technical details of specific automobile efficiency technologies and how they would develop in the decades to come. Federal agencies simply must play a role. We need their technical expertise and ongoing involvement to ensure the legislation we pass is implemented effectively as ensured by Congress. In committee, I discussed George Gorsuch's textualist bill. This means that he believes statutes should be interpreted only by, quote, the plain meaning of the language, end quote. Combined, this judicial philosophy includes, 1, limiting laws and statutes to a dictionary definition that he selected, 2, reversing precedent to say that agencies can't interpret ambiguous laws, and 3, reinstating a legal doctrine to further limit agency experts. Taken together, these 3 points would require Congress to pass bills so that they are either so specific they would be very limited in effect, or so broad they would actually be meaningless. For example, Senator Collins and I have been working on legislation that would require the FDA to ensure the safety of personal care products, such as we all use: shampoo, deodorant, cosmetics, shaving creams, lotions. The FDA doesn't do it in this country, but they do it in Europe. And our bill asks the FDA to evaluate the safety of the chemicals that are put in these products. In committee, we had testimony about a shampoo that once used, hair fell out of the individual's head, and many thousands of complaints had been registered. Congress does not have the expertise to do the chemical evaluations, and without deference to the FDA, the bill would have to be thousands of pages long to cover every contingency for every product made by hundreds of companies, and that's simply not workable. If Congress can no longer rely on federal agencies, and if all laws can only be interpreted by limited dictionary definitions, then government would have no ability to regulate markets, defend against a financial crisis, protect workers, build safe roads, or safeguard our environment. We depend on the scientists, the biologists, the economists, the engineers, and other experts to help ensure that our laws are effectively implemented. And so this is really a dastardly controlling mechanism. Under the arguments proposed by Judge Gorsuch, this would no longer occur. Instead, only congressional action would be able to address these important issues. These rules that agencies would write would have to be written by Congress. And even that would be severely limited. Such a radical change in law would hurt ordinary Americans, certainly their safety, and certainly our communities. Let me say once again, who sits on the Supreme Court matters. The issues facing our country are consequential, and they have a real-world impact on all of us. Justices on the Supreme Court must understand that the court's decisions have real-world consequences for men, women, and children across our nation. Unfortunately, based on Judge Gorsuch's record at the Department of Justice, his tenure on the bench, his appearance before the Senate, and his written questions for the record, I cannot support this nomination. I thank the chair. I yield the floor.
I rise this afternoon to entreat my friend, the Majority Leader, to step back from the brink. As I and so many other of my colleagues have made clear, we Democrats have principled reasons to vote against this nominee on tomorrow's cloture vote. First, he has instinctively favored corporate interests over average Americans. Second, he hasn't shown a scintilla of independence from President Trump. And third, Judge Gorsuch, based on his record and history, has a deeply held, far-right, special interest judicial philosophy that is far out of the mainstream. He was selected off a list developed by the very hard-right special interest Heritage Foundation and Federalist Society. The Washington Post, after analyzing his decisions on the 10th Circuit, concluded that Judge Gorsuch may be the most hard conservative justice on the bench, to the right of even Justice Thomas. It may be abstract to many Americans, but Judge Gorsuch's judicial philosophy matters a great deal. It'll affect dozens of decisions and decades of jurisprudence that could have far-reaching consequences on the lives of average Americans. As Emily Bazelon in the New York Times put it, the reality is that Judge Gorsuch embraces a judicial philosophy that would do nothing less than undermine the structure of modern government, including the rules that keep our water clean, regulate our financial markets, and protect workers and consumers. If that philosophy becomes the majority view on the Supreme Court, average Americans are in big, big trouble. The prospect concerns almost every Democrat here in this body, enough to prevent cloture on Judge Gorsuch's nomination tomorrow. This leaves the majority leader and my Republican friends with a choice: break the rules of the Senate or sit down with we Democrats and the President to come up with a mainstream nominee who can earn bipartisan support to pass the Senate, enough bipartisan support to pass the Senate. We Democrats believe the answer isn't to change the rules, it's to change the nominee, as presidents of both parties have done when a nominee fails to earn confirmation. Instead, my Republican friends seem intent on breaking the rules for Judge Gorsuch and are trying to find reasons to justify it. The truth is, each side can blame the other. We believe they're more in the wrong. They believe we're more in the wrong. The game of pointing fingers, and they started it, can go back and back and back to the very founding of the Republic. If my Republican friends think they have to change the rules because this blame game has gotten so far out of hand that Democrats will never pass a Republican-nominated Supreme Court justice, I'd remind them of Justices Alito and Roberts, two conservatives who nonetheless passed the Senate having met a 60-vote bar. That was during a pretty contentious time as well. If my Republican friends think that what we Democrats did in 2013 was so wrong, and that's reason to break the rules, I'd remind them the only reason we changed the rules was because the Republican minority in the Senate had forced cloture petitions to be filed on more nominees under President Obama's first 5 years than in all the 225 years before him combined. They filed more cloture petitions against President Obama's nominees than all the cloture petitions filed from George Washington through George W. Bush. When Democrats changed the rules, however, we purposefully left the 60-vote bar for the Supreme Court intact because we knew, as the Republicans know, that the Supreme Court is different. Justices on the court don't simply apply precedents of a higher court. They set the precedents. That's why justices should be mainstream enough to garner substantial bipartisan support. If the majority leader breaks the rules tomorrow, and that's his choice, he would be forever unwinding that important principle, erasing the last shred of bipartisanship in the Senate confirmation process. If my Republican friends think a filibuster on Judge Gorsuch is so wrong that they have cause to break the rules, I'd remind them that almost every one of them lined up behind the majority leader when he vowed, mere hours after the death of Justice Scalia, that President Obama would not get to fill a Supreme Court seat despite 11 months left in his presidency. That was much worse than a filibuster. Even my friend, the Republican senator from Tennessee, called it audacious. But I think Representative Adam Schiff of California said it best. Quote, when McConnell deprived President Obama of a vote on Garland, it was a nuclear option. The rest is fallout. The fact of the matter is the Republicans blocked Merrick Garland using the most unprecedented of maneuvers. Now we are likely to block Judge Gorsuch because we're insisting on a bar of 60 votes. We think a 60-vote bar is far more in keeping with tradition than what Republicans did to Merrick Garland. The majority leader himself has stipulated, this is his quote, Mitch McConnell's quote, in the Senate, it takes 60 votes on controversial matters. On the other hand, there is absolutely no precedent, rule, tradition, or custom that can justify what the Republicans did to Merrick Garland. None. The two are not equivalent. over the long history of partisan combat over judicial nominations? Of course, there is blame on both sides. We don't believe the blame should be equally shared between Republicans and Democrats. The Republican Party has been far more aggressive in employing new tactics and escalating old ones to fight the nominees of a president of the opposing party. The Republican Party has been far more aggressive in their selection of judicial candidates, picking judges who have an ideology closer to the conservative extremes of American politics, while Democrats have tended to select candidates closer to the center. Keep this in mind. The last time a Republican-controlled Senate confirmed the Supreme Court nomination of a Democratic president was 1895. Let me repeat that amazing fact. The last time a Republican-controlled Senate confirmed the Supreme Court nomination of a Democratic president was 1895. So, Mr. President, we can argue endlessly about where and with whom this all started. Was it the Bork nomination, which received a vote in the Democratic Senate, by the way? Or was it the obstruction of judges under President Clinton? Was it when Democrats blocked a few judges under President Bush? Or when Republicans forced Democrats to file more cloture petitions in 5 years of President Obama's presidency than during all other presidencies combined? Was it Judge Garland or Judge Gorsuch? Wherever we place the starting point of this long twilight battle over the judiciary, we're now approaching its end point. We are nearing the final hour, and the stakes are considerable. After the cloture vote on Judge Gorsuch, Democrats will have been denied Merrick Garland due to tactics we felt were unfair, and Republicans will have been denied Judge Gorsuch because of tactics they think are unfair. Our two parties have traded bitter blows. In the tortured history of the Scalia vacancy, the debate has been saturated with contradictions. But in a very real sense, even though each side thinks their side is more right than the other, neither side is happy with how we got here. And now we are standing on the brink of an irrevocable change to the way this body conducts business. As the majority leader once said, changing the rules is a bell that's very hard to unring. As the clock ticks steadily towards tomorrow, what are we going to do? I, for one, would like to see us step back from the brink. As a Democratic leader, I still hope I can sit down with the Republican leader and find a way out of this pernicious cycle. I believe that, as leaders of our respective caucuses, it is at least up to us to try, for the sake of the Senate. The Republican leader and I disagree on a great many things, but we agree upon the importance of the Senate in American life. We can decide today to commit to solving this problem. Each side can stop pointing fingers. Each side can lay down their arms. Each side can put aside the resentments built up after years of trench warfare on nominees. We can decide today to talk about a way out of this impasse instead of changing the rules. We've both lost Supreme Court nominees. We shouldn't also lose a long-standing rule of the Senate that encourages our two parties to work together to fulfill one of the Senate's most important functions. So the option to sit down with us Democrats and talk about a new nominee that can gain sufficient bipartisan support remains on the table right now. I hope my friend, the Republican leader, thinks about where we're headed and takes a moment to let reason and prudence prevail over rancor and haste. Just as the majority leader holds the power to exercise the nuclear option, he also has the power to avoid it. If the majority leader is willing to cooperate in a bipartisan way, if he's willing to sit down with us in good faith and try to find a way out, he will find an open door and an open mind. And maybe we can, for the moment, avoid an outcome that no senator from either side wants to see. I yield the floor.
Mr. President, the Senate is at a crossroads. Senate Democrats, at the behest of outside far-left activist groups, are leading the charge to break nearly a 230-year-old precedent of confirming Supreme Court nominees by a simple majority vote. Why? Well, when you go down the list, there's only one reason. That reason is not based on substance or reality. It's purely partisan. Judge Gorsuch is eminently qualified. That does not seem to be in dispute. His credentials are exceptional. His resume is impressive. His judicial demeanor, professional competence, and integrity all exceed what you expect in a nominee for the highest court in the land. Judge Gorsuch checks every box, so much so that the American Bar Association gave Judge Gorsuch its highest rating. The ABA's assessment, mind you, has been referred to by the minority leader as the gold standard when it comes to evaluating a nominee's fitness to serve on the court. Senate Democrats must be concerned about Judge Gorsuch's past then. Again, that is not the case. No one was able to dig up anything remotely resembling a scandal in Judge Gorsuch's past during this process. You can't manufacture a controversy where none exists. Nothing about Judge Gorsuch has come to light during this confirmation process that could conceivably merit blocking a vote on the nominee. I've heard Senate Democrats try and argue that Judge Gorsuch is out of the mainstream. That hasn't stuck either. This is a judge that has been with the majority of the 10th Circuit Court of Appeals 99% of the time. 97% of his decisions were unanimous. Judge Gorsuch is about as mainstream as you're going to find. Editorial boards from newspapers across the country, including the USA Today, have written in support of his nomination. Does anyone honestly believe that USA Today, which is far from a conservative newspaper, would support confirming Judge Gorsuch for the Supreme Court if he was out of the mainstream? So now Senate Democrats are seemingly creating new standards out of thin air to justify this blatantly partisan act. According to their talking points, a nominee is now expected to tell the Senate and the American people exactly how he or she would rule on matters that may come before the court, especially in instances where the activist base has a very keen interest. As the Judiciary Chairman rightly pointed out, the standard set by Justice Ginsburg in her confirmation hearings that it would be inappropriate for a nominee to offer hints or make commitments on matters that may come before the court has been adhered to ever since. This leaves Senate Democrats with a filibuster that lacks a reason. The minority leader has suggested the Senate abandon Judge Gorsuch's nomination if cloture is not agreed to, and ask the president to submit a new nominee. This demand rings hollow. Here's the truth. If this nominee cannot get the Senate Democrats' blessings for a vote, then no nominee put forth by the president can. Again, we are talking about a nominee who has climbed to the top rung of his profession. Judge Gorsuch is well qualified and well within the mainstream. He was unanimously confirmed to the 10th Circuit Court of Appeals, and as I mentioned earlier, received the highest possible rating after an exhaustive evaluation from the American Bar Association. Senate Democrats failed to create outrage and controversy over Judge Gorsuch's nomination because there is simply none to be found. But that didn't let them stop. That didn't stop them. It's an amazing 180 turnaround. Senate Democrats who just last year pushed for an immediate vote at the height of a contentious presidential election now appears to be fine with leaving that seat vacant literally for years. Just last year, the minority leader sounded the alarm about the judicial chaos a deadlocked court could lead to. He appears to be no longer concerned about that. By this logic, a vacant seat on the Supreme Court for a few months would be a devastating blow for democracy, but one left open for years is wholly acceptable. This makes absolutely no sense. The only explanation for it is that Senate Democrats expected to be voting on a nominee put forth by a Democratic administration, not one put forth by President Trump. Judge Gorsuch will be confirmed to the Supreme Court this week. It is unfortunate that we may have to break long-standing precedent to do so, but Senate Democrats' actions are to blame for that. With that, Mr. President, I yield the floor.
The senator from South Carolina.
Thank you, Mr. President. Mr. President, we've heard famously that elections have consequences. And over the next few days, we will have an experiment in what I call, Mr. President, the physics of politics. For every action, there is an equal and opposite reaction. And Mr. President, if the Democrats use for the first time, a partisan filibuster of a Supreme Court nominee, we will have an equal and opposite reaction. An unprecedented action is going to evoke an unprecedented reaction. Neil Gorsuch deserves to be confirmed, and I want to share for the next few minutes why. Mr. President, for more than 2 months since the nomination was first announced, we've seen that Judge Neil Gorsuch, he possesses the qualifications and the temperament to serve as our next Supreme Court justice. While all nominations carry enormous responsibility, this is arguably the most important position we are tasked with filling. We need someone who is extraordinarily qualified, someone who will respect the foundation of our country, someone who has the mental resilience to stay above the political fray. Some of my friends on the left have called Judge Gorsuch unqualified, too conservative, and someone who is simply not in the judicial mainstream. Judge Gorsuch started his legal career by earning degrees from not one but 2 Ivy League schools. Columbia University for his undergrad, Harvard Law for his Juris Doctor, graduating cum laude. He even, as a Marshall Scholar, earned a doctorate degree from Oxford. When one takes into account these extraordinary educational achievements, it would be simply incomprehensible how anyone would consider him unqualified. His record on the bench is just as impressive. And we've heard these numbers so many times that we sometimes just gloss over or glaze over these numbers, but these numbers are powerful indicators of how successful he has been as a judge. Out of nearly 2,700 cases, Judge Gorsuch has been overruled only twice. 98% of his opinions were unanimous, further proving that he falls exactly square in the judicial mainstream. He has received well qualified, as my senator from Arkansas just stated a few minutes ago, from the American Bar Association, the highest rating available for a Supreme Court justice. Judge Gorsuch is also not new to the nomination process. Just a few years ago, in 2006, Judge Gorsuch was unanimously confirmed by the U.S. Senate to the 10th U.S. Circuit. Now, let me say that one more time, because so seldom do we see the Senate acting in a unanimous fashion. So this perhaps as a moment of reflection, that Judge Gorsuch in just 2006 received a unanimous vote for the 10th Circuit. Every single Democrat serving in the Senate at that time voted in support of Neil Gorsuch, including 12 members who are still serving in this chamber today. His bipartisan support has not stopped there. Senator Bennett from Colorado says that Judge Gorsuch represents the best qualities of Colorado and that we need to fulfill our responsibility to this nominee. Senator Donnelly from Indiana has said, I believe he is a qualified jurist who will base his decisions on his understanding of the law and is well respected among his peers. From West Virginia, Senator Manchin acknowledges that while he may not agree with future decisions made by Judge Gorsuch, he also said without question, let me quote, he has not found any reason why this jurist should not be a Supreme Court justice. Senator Heitkamp from the Dakotas said that during her meeting with our Supreme Court nominee, Judge Gorsuch reinforced the importance of a judiciary that remains independent from the executive and the legislative branches of government. Neil Katyal, former acting Solicitor General under President Obama, said of Gorsuch that he is a first-rate intellect and a fair and decent man. The judge's work reflects his dedication to the rule of law. Last month, throughout his 3-day confirmation hearing, Judge Gorsuch provided detailed and thoughtful responses that should have answered every concern from committee members. As I watched, I was incredibly impressed with his depth of knowledge, his genuine demeanor, and his obvious respect for the rule of law. He understands that his job is not to make the law. Let me repeat that because this seems to be an unusual experience, at least it has been for me, to hear a judge understand and appreciate that his job is not to make the law. His job is not to alter the law. But he expressed time and time again that he is committed to interpreting the law as it is written. One of his most memorable comments from his hearing has left a lasting impression on me, and I hope it does you as well. He said, "A judge who likes every result he reaches is very likely a bad judge, reaching for results he prefers rather than those the law compels." In one sentence, Judge Gorsuch eloquently summarized what we should expect from our Supreme Court judges and also gives insight into how he intends to serve once confirmed. After his extensive and exhaustive hearing, we can clearly see beyond the shadow of a doubt that this man is more than qualified for appointment. Any argument to the contrary is based purely on political opposition. Today, the Senate stands on the verge of breaking historical precedents. We have let political disagreements get in the way of a judicial seat, a nomination that should stand far above political rancor. A year ago, Judge Gorsuch was serving on the US Court of Appeals for the 10th Circuit. He had no idea that he would find himself in the midst of a partisan battle. There is no question this man has led an exemplary life and deserves a fair vote. We are simply asking for a fair vote. A vote. Let us move past these political games and confirm a man who has earned this position with nearly a flawless record as one of the brightest judicial minds our country has.
Mr. President, I rise today to offer my support to the nomination of Judge Neal.
Quorum call.
Oh, thank you. I would ask that the quorum call be suspended.
Without objection.
Thank you. As I was saying, I rise today to offer my support for the nomination of Judge Neil Gorsuch to be the Supreme Court of the United States of America. Several weeks ago, shortly after President Trump announced this nomination, I came to the floor to say what an admirable choice he had made and had known him for some time. Now, after meeting with Judge Gorsuch to discuss his nomination, and after reviewing his qualifications, and after observing my colleagues on the Senate Judiciary Committee thoroughly vet him, I'm all the more convinced that this man is eminently qualified to serve as America's next Associate Justice of the Supreme Court. I was impressed that both of his senators introduced him to the committee for the hearing. I was kind of surprised that the biggest comments that I heard about the hearing itself was that he didn't answer some of the questions directly. As with previous justices, they didn't answer the questions directly when they're asked a theoretical about some possible future case that would come before them without the details. Another reason that I'm qualified, I'm convinced that he's very qualified, is the people that he went to school with have all had good comments about him. The people that he went to law school with have had good comments. The people that have been in the bar, in the legal arena with him have had good comments about him. And so have the other judges that he's worked with through the years as he moved up through the different process. I'm confident he's qualified to be our next justice because of his extensive judicial experience, his commitment to the rule of law, and his principled character. Neil Gorsuch's first job out of law school was a couple of blocks from here. Even back then, he was already preparing to serve his country on the Supreme Court by learning from some of the best jurists in America. He performed clerkships first for the US Court of Appeals, for the D.C. Circuit, and later for Justices Byron White and Anthony Kennedy at the United States Supreme Court. After working in private practice and at the Department of Justice, in 2006, President George W. Bush nominated Judge Gorsuch to serve on the U.S. Court of Appeals for the 10th Circuit. The Senate confirmed him by voice vote. That's unanimous. Mr. President, let me say that again because it's relevant to the misplaced, in my opinion, partisan rancor we're hearing over this nomination. In 2006, only Senator Lindsey Graham bothered to attend the Senate Judiciary Committee's hearing to consider Neil Gorsuch's nomination to the 10th Circuit Court of Appeals. This body, including then Senators Joe Biden, Hillary Clinton, and Barack Obama, was so confident about Neil Gorsuch, his character, and his qualifications to serve as a federal judge that he was confirmed by the Senate without anyone even asking for a recorded vote. With what is, in essence, an endorsement from three of the most influential political figures then serving in the Senate among my colleagues across the aisle, I find some of the opposition to Judge Gorsuch and questioning of his qualifications somewhat baffling. I hope my colleagues in the Senate will put aside the political bickering and scorekeeping that have dominated Washington over the last several months and give Neil Gorsuch a fair vote, up or down, based on his qualifications and his suitability for service on the Supreme Court. Since joining the 10th Circuit, Judge Gorsuch has been a busy man, doing exactly the kind of work that makes him qualified for this nomination. The 10th Circuit exercises appellate jurisdiction of federal cases originating in 8 states that cover about 20% of America's land mass. That jurisdiction does include my home state of Wyoming. As a member of the 10th Circuit, Judge Gorsuch estimates he sat on appellate panels considering approximately 1,800 criminal cases and 1,200 civil cases. The list of citations of case decisions he's authored is a single-spaced 21-page document. After hearing all those cases and drafting all those opinions, even Judge Gorsuch's detractors have criticized only a mere handful of the hundreds of opinions he's authored. I'm confident that Neil Gorsuch is qualified to be a member of the Supreme Court because of his steadfast commitment to the rule of law. The many opinions he's written are known for being clear and easy to understand. But most importantly, his opinions reflect his respect for following the law as it is written and applying and adhering to judicial precedent. He's a judge who applies the law to the facts of the case and reaches the conclusion that examination yields regardless of his own personal beliefs. As he said, personal politics or policy preferences have no useful role in judging. Regular and healthy doses of self-skepticism and humility about one's own abilities and conclusions always do. Judge Gorsuch is an adherent to and defender of America's Constitution and the separation of powers that document prescribes. As he said, quote, "Judges must allow the elected branches of government to flourish and citizens, through their elected representatives, to make laws appropriate to the facts and circumstances of the day." Throughout this nomination process, during all of which Judge Gorsuch has been under a political microscope, we have seen that he is a man of admirable character with a temperament that makes him well-suited to serve as a Supreme Court justice. We know he has a resilient character and thick skin, qualities important to any justice, because we've seen his demeanor in response to the criticism of his career and negative characterizations about some of his previous decisions, very few of them, I should add. We've even seen his reaction in the face of accusations about his judicial independence. In the face of that, biting disparagement about the work he spent his life trying to perfect, Judge Gorsuch has been respectful, remarkably patient, and resolutely committed to upholding the ethical canons and conduct demanded of him as a jurist. We glimpse Judge Gorsuch's character as he's spoken about the people he values and those he strives to emulate. His legal heroes are people like Justice White, who he said, quote, "followed the law whenever it took him without fear or favor to anyone," unquote. And Justice Anthony Kennedy, who Judge Gorsuch said, quote, "showed me that judges can disagree without being disagreeable," end quote. And Justice Scalia, who he said reminds us, quote, that the judge's job is to follow the words that are in the law, not to replace them with words that aren't, end quote. Neil Gorsuch has told us that he's also looked closer to home, to his family, to shape his character. His mother, who he said, quote, "taught me that headlines are fleeting, but courage lasts." His father, who he said showed him that kindness is the greatest virtue. His paternal grandfather, who Judge Gorsuch said taught him that lawyers exist to help people with their problems, not the other way around. Neil Gorsuch has demonstrated his commitment to the law, his scholarship, and his temperament befitting that of a judge. He is eminently qualified to be a member of the Supreme Court. Not in my opinion. That's what the judges have said. But, Mr. President, I'm not the only one who believes this. My office has received hundreds of calls and letters from my constituents in Wyoming urging the confirmation of Judge Gorsuch. He has a lot of support from folks in the Wyoming legal community from both parties, who I know and trust and whose opinions I value. Judge Gorsuch has earned a well-qualified rating, the highest rating they award from the American Bar Association. To give him this rating, the ABA's Standing Committee on Federal Judiciary conducted a peer review of Judge Gorsuch's integrity, professional competence, and judicial temperament. As children, we all learned that you might be able to fool your parents or your teachers, but you can never fool your peers. You especially cannot fool ones with whom you work long hours, like most judges and lawyers are known to do. You can't fool your peers. They're the ones who see you at your best and at your worst. That's why it's so remarkable that dozens of Neil Gorsuch's Harvard Law School classmates, people representing many different political and philosophical persuasions, and who have known him for more than a quarter of a century, signed a letter supporting his nomination to the Supreme Court. Mr. President, among our most important duties as member of this body is to carefully vet all nominees that come before us. Never is that responsibility so stark and so substantial as when our nation faces a vacancy on the Supreme Court. In November, millions of people went to the polls and rejected the kind of tired partisan bickering when they voted for a change in Washington. Those same voters went to the polls knowing that there was a vacancy on the Supreme Court and that whoever became the next president would choose that nominee. For many weeks now, Judge Gorsuch has been before us as that nominee. He's undergone scrutiny under which most of us would wither. We've all had time to examine his record. I thank Chairman Grassley, Ranking Member Feinstein, and all our Senate colleagues who served on the Judiciary Committee for conducting such thorough and detailed nomination hearings that provided us ample opportunity to examine Judge Gorsuch's qualifications and temperament. I believe there's only one logical conclusion to reach after all this examination, and that's that Judge Neil Gorsuch is supremely qualified for and capable of the solemn and mighty task of serving as the next Associate Justice of the Supreme Court. I urge my colleagues to join me in supporting this confirmation. I yield the floor and note the absence of a quorum.
Debate the qualifications of Neil Gorsuch, Judge Neil Gorsuch, the president's nominee to the highest court, the United States Supreme Court. Many who've come to the floor talking about his high qualifications, the fact that he has the highest ABA, the American Bar Association rating, the fact that he has the support of the 2008 co-chair of the Democratic National Convention, the fact that Neil Katyal, a very high-ranking former official in the Obama administration, supporting the confirmation of Neil Gorsuch. And we've had others come to the floor, of course, and express their opposition. We've had them come and express their opposition to an individual who has proven himself to be a mainstream judge, who has proven time and time again that he has the respect of his colleagues on the 10th Circuit Court, the bench of the 10th Circuit Court, as well as circuit courts around the country, and that he has the respect and admiration of the justices on the United States Supreme Court, where Judge Gorsuch clerked for Justice White, the last Coloradan to be on the nation's high court, and where he clerked for sitting Justice Anthony Kennedy. Judge Gorsuch has been known and become known as a theater judge, somebody who provides clerks to the Supreme Court because they understand the quality and caliber of Judge Gorsuch's work. We know that Judge Gorsuch was a part of 2,700 opinions, decisions that were decided 99% of the time with the majority of his court. We know that 97% of that time, these decisions were unanimous. We know about his record as it relates to being reversed or overturned. And we know that our colleagues who are opposing, for some reason, Judge Gorsuch, continue to come to the floor and talk about, apparently, the reasons they can't support Judge Gorsuch because he won't violate judicial ethics or the ethics that a judge is expected to keep, because he won't preview how he would rule under a certain fact circumstance. George Washington himself could come down from a mountaintop and would be rejected by the United States Senate to be a Supreme Court justice. It's pretty incredible to see and hear the arguments that have taken place, some lasting all night. Because some of these arguments are nothing more than sour grapes. Some of these arguments are nothing more than two wrongs must make a right in their mind. They criticize Republicans for invoking the Biden rule or the Schumer rule. And then they decide because of that, they're going to demand that the seat be held open, not confirmed, because they believe it was taken from them. And in their mind, if you do two things that are wrong, it must be a right. We've taught our children that's not true. And we know in this instance, the American people decided who this Supreme Court justice would be. In 2006, Judge Gorsuch, Neil Gorsuch, was nominated to serve on the 10th Circuit Court. A dozen sitting members of this chamber didn't object to his nomination then. They didn't oppose him. They didn't come and register their no vote. In fact, nobody even showed up at his confirmation. Lindsey Graham was the only one. That's how objectionable he was then. So either a couple of things have happened. Nobody did their work then to find out what kind of a judge he was going to be, or they have decided that the politics have changed. And to me, that's the most egregious part of this debate, is the politics of the time are demanding that there be absolute obstruction. For the first time in over 230 years of a Supreme Court justice, trying to defeat a Supreme Court justice with a partisan filibuster for the first time in 2 centuries. Of a judge who a judge who agreed 99% of the time with the opinions of of the court. 99% of the time, his opinions were made with the majority of the court. 97% of the time, they were made unanimously. This is an individual who has outstanding legal credentials. Harvard, Columbia, most importantly, time spent at the University of Colorado. He's a 4th-generation Coloradan. At a time, I think the old joke of Justice Scalia, the late Justice Scalia, was that 4 of the 5 boroughs in New York have their own Supreme Court justice. Well, wouldn't it be nice if we had a Supreme Court justice west of the Mississippi River? Another additional Western voice on the Supreme Court? A judge who comes from a circuit court, that represents 20% of the land mass? If you're a Westerner, and you have a choice of putting a judge on the Supreme Court who is familiar with tribal law issues, a judge who is familiar with water issues, a judge who is familiar with public land issues, that's a pretty good pick for the High Court to represent a vast part of America that is underrepresented on the nation's High Court. This institution can seem pretty puzzling at times because you consistently hear the outcry for bipartisan support. Let's work together. Let's have bipartisan support. And the president nominates a judge who has strong bipartisan credentials from the people who know him the best. Look, most people in Washington, D.C., most people in this chamber have known Neil Gorsuch for just a couple of months since the time of his nomination. Most conversations that people in this chamber have had with Judge Gorsuch have consisted of an hour or two at a judicial nomination hearing, confirmation hearing, or perhaps when he visited the office prior to the hearing. That's the extent of their relationship and their knowledge and their understanding of Judge Gorsuch. But the people who know him best, the people out in Colorado, Republicans, Democrats, they believe he is well qualified and should be confirmed, that he deserves an up or down vote. People like Democratic Governor Bill Ritter believes that Judge Gorsuch should have an up or down vote, be confirmed. And again, this is apparently some people find Judge Gorsuch so unreasonable or so unfit to serve on the High Court, they might find it hard to believe that in 2008, the 2008 co-chair of the Democratic National Convention is supporting Judge Gorsuch's confirmation. Jim Lyons, close friend, attorney of President Bill Clinton, supports the confirmation of Judge Gorsuch. They know his record. They've reviewed the cases that the opposition has stated that they find so egregious, and they still believe he is worthy of confirmation to the court. The standard that has been set by those who oppose Judge Gorsuch is a standard that simply says no justice could be confirmed. Why? Because we know that because Judge Gorsuch's credentials, his academic background, his judicial history, his temperament, his qualifications, his ratings, show that he is more than able to serve and deserving to serve on the Supreme Court. But there is a certain difference of philosophies that has been presented here. A difference of philosophies that some people believe that a judge shouldn't just be a judge who follows the law or who rules and makes a decision based on where the law takes them, but people who believe that a judge somehow has to be maybe a focus group of opinion or policy preferences. That a judge should be somebody who puts their thumb on the scale of justice to reach an outcome that's preferred by a political party. That's not what our founders had in mind when they wrote the Constitution. That's not what justice is about. Judge Gorsuch believes that you take an opinion, you take a decision where the law takes you, where the law leads you. Guardian of the Constitution. He understands the separation of powers, but apparently that's not good enough for some. They want an activist judge, but I hope that over the next several hours, the next few days, that our colleagues will come to realize those who know him best believe that he is qualified, that he deserves an up or down vote. That a judge who votes 99% of the time in the majority agrees with it. Mr. President, I thank you for your time today and look forward to our conversations as we confirm Judge Gorsuch at the end of this week.
The Senate returns at 10 a.m. Eastern Time to continue debate on Neil Gorsuch's nomination to the Supreme Court. Senators will hold a cloture vote at 11 to limit debate on the nomination. If this vote fails, it could be followed by votes on what's called the nuclear option to change Senate rules invoking cloture. Live coverage here on C-SPAN 2 at cspan.org and on the C-SPAN radio app. This morning, Politico talks to House Freedom Caucus Chairman Mark Meadows and caucus members Jim Jordan and Justin Amash. Watch it live at 8:20 a.m. Eastern Time here on C-SPAN 2 and cspan.org. And listen live with the C-SPAN radio app. Two senators on the Foreign Relations Committee, Ben Cardin and Marco Rubio, held a press conference on the Syrian civil war and what the U.S. response should be to Syrian President Bashar al-Assad's use of chemical weapons. This is 20 minutes.
Good morning. It's a pleasure.